Good morning, good morning, good morning. It is Tuesday. It's April 29th. We are in the Commonwealth of Massachusetts versus Karen Read, day 6. Yesterday was yet another half day for the jury, but a full day for us because the ARCCA experts were on the stand for a voir dire after the jury was excused at the lunch break yesterday. We got through witness 11 partly. We got into Ian Whiffin's testimony. If you watched the last trial, he is the Cellebrite guy. I thought this direct examination came in much more clearly than his last direct examination, but the questioning is more clear. There are definitely things about Attorney Brennan's style that are not my favorite, but his questioning is much more clear and the direct examination comes in much more clearly. And throughout the direct, I was saying, I hope they take the, cell phone temperature from John O'Keefe's phone and the location data from Waze and the movement and activity data and put it together in a timeline. And they did that. And when we ended the day with the jury yesterday, that's where cross-examination was picking up on that timeline and what was on the timeline and what was not on the timeline. I'm very interested to see where we get this morning with cross-examination. Attorney Alessi is seeming to be the attorney that's going to be handling the experts, which we guessed from pretrial motions. And then after we get into this cell phone data, are we going to go to Karen Read's cell phone data next? Or are we going to go to who's at the Waterfall? Where do we go next? Because last time the order was very clear from Adam Lally. I don't think it was nearly as strategic as this, but it was clear. And it was the first responders on scene, then first law enforcement on scene, then when John O'Keefe went out for the night, then everybody at the Waterfall. It followed in groups of witnesses. This is telling a story through the witnesses in the way that the story needs to be told to the jury, not necessarily in just grouping the witnesses together. So with all of that, are you ready to go to court? Law nerds!
Bring the jury.
Are you ready to go to work? Are you ready to go to work? Are we ready to go to court? It feels like work. There are days when I'm like, streaming doesn't feel like work at all. And then there was yesterday. But here's the thing. This jury has got a much better picture of this case than the last jury had. And if you're sitting there going, wow, this evidence seems much stronger against Karen Read than it did last time, even knowing what you know, even knowing what's going to come in and trying to put that out of your head, hey, this evidence seems stronger. It's coming in much more clearly. A lot of it's evidence we saw last time, some of it's not, but it is coming in much more clearly. There's a long way to go in this trial, and we know some of the things that are going to be coming up. And we know some of the things that the jury's going to sit there and be like, well, damn. So we have to just see if this strategy of not really having any law enforcement on yet is going to work. Or if by the time they get to law enforcement, that is just going to overshadow everything that's come before it. We'll have to see how we feel about it. Law nerds, let me know what you're drinking, where you're coming in. It's a tankard. It's a mega pint of coffee this morning. Do we need it? Probably more. Have we started it? Not yet. So let's go to court. We're going to roll the intro. We're going to go to court. Did we get a new intro for the trials? Yeah, I kind of felt like we needed it. So why not? We can do what we want. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. I mean, hear ye, hear ye, hear ye. It's time to go to court. The law nerds of the observational jury of the chat have gathered. I've got 2 different pastry choices this morning because, well, I couldn't decide. And I was like, we'll make both and see how we feel about it. Because I don't know, sometimes if it's the wrong thing, you're just like, I can't eat this right now. ADHD. It's a joy. It's a joy. There's days that you're just like, is that what I feel like? No, absolutely not. I'm never eating this again. If you know, you know. Let's go to court. I'm ready for some hear ye's. Are you ready for some hear ye's? I'm ready. They're my favorite thing about this case. I got to be honest. The hear ye. I mean, I do like the lawyer's house, but yesterday tested my patience for that too. There's only so much one can do. Damn it, that was loud. The courtroom ick has begun. There's been coughing this whole trial.
Hear. All persons have any business before the Honorable Beverly Cannone, Justice of the Norfolk Superior Court, and before the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. The court is now open. You may be seated.
Can we just take a moment to appreciate that the pool camera is finally showing the bailiff that does the hearies? Because I'm here for it. Like, we finally got a visual on the hearies. That might be our best hearie yet.
Were you all able to follow the
I'm a little shook that the jury's already in and the lawyers weren't just like, we need to talk more. I'm a little shook. I really am.
instructions and
I'm really
refrain from
surprised.
discussing this
Also,
case
yes,
with anyone since we
I
left
have my
Everyone
Metallica
said
and
yes
Justice
and
for All shirt on.
Were you
Emily,
also
stop
able
pulling
to
it up. You're
follow the
gonna go too far on
instructions and
that.
refrain from doing any independent
I've got-
research or investigation.
Emily, are you gonna wear Metallica shirts all week and then
Yes,
wash
and
them
no.
before you go to the concert?
Did
Yes.
anyone happen to see, hear, or read anything
Yes,
about
I
this
am.
case since we left yesterday?
So.
Everyone said no and shook their heads. Before we start, at the end of
Same
the
three
trial, when I
questions.
give you your instructions, I'll explain to you what a stipulation is. But essentially, a stipulation really is just something, a fact that the lawyers agree
The
to.
attorneys agree, they stipulate
what the lawyers want
to a
me
thing.
to tell you what they agree with is that last Friday, when we were on our view at 34 Fairview, you may have seen an object in the front lawn. It looked like a rock. If you saw that, please disregard it. They want you to know that that was not there on January 28th to January 29th.
Okay. So
Thank you. With
they're
that,
like,
could we
whatever
have Mr.
they
Whiffin
saw,
back,
they're like, that
please?
was not at the house. I guess you never want anyone to confuse if there's a rock there that, oh, maybe he could have hit his head on something. That's an odd thing to have different, but you need to make sure that they know. If it's different than what was there at the time that this happened, they need to know what's
morning.
So
different.
you're still under oath. Thank you.
So,
All right, Mr. Lessie, you all set?
Thank you, Your Honor.
the jury is not sequestered. They won't be in this case. It's harder and harder to sequester juries with
May I approach?
digital
Yes.
issues. Y'all are telling me a lot in the chat about The Rock. I had no idea. Okay. I'll go looking for that information. I don't look when there's trial. I look for what's going on in the trial, and that's it.
Your Honor, if I may address the court. Mr. Brennan and
That's
I
not
have
good.
agreed, as we did yesterday, to stipulate into evidence portions of Mr. Whiffin's March 2025 report. So if I could have it marked.
And that's about where they were
Thank you.
getting last time.
Exhibit 43. Thank you.
Thank you.
I will say when there are anomalies, it normally is not taken
May I,
well
Your
by
Honor?
jurors.
Yes.
Thank you. Morning, Mr. Whiffin,
Good morning.
and welcome back.
Thank you.
Okay, we're back on the stand. I mean, at
Yeah,
least we're not
Your
coming in
Honor.
hot
Yes.
today.
Thank you.
I think we all need a breath after yesterday.
Thank you.
Mr. Whiffin,
At least
I
Brennan
just
does.
handed you
Maybe a
which is
Snickers.
in evidence as Exhibit 43, and this is a portion of your March 2025 report. If you could just take a moment to look at it, and when you've had a fair opportunity to do that, I'd ask you to turn to page 28.
Okay.
Oh, the
And just if you
audio
could,
just
sir,
got.
just pick up your head and let me know when you're ready to proceed.
Oh,
Thank you.
it sounded like the pool just gained up the audio. Delia in the chat asked, is it normal for the same judge to be doing the same case twice? It would be very unusual for a different judge to handle a case. That would generally only happen in issues where somebody had retired or switched assignments or moved to a different bench or had a medical something. It's very, very common and preferred that the judge who did the first trial do the second. It is very unusual that you would switch judges between trials. So it is much more common. The chat's talking. Maddie in the chat said, okay, twist my arm. I'll go get donuts. I want donuts. Can we bring enough for the class? That's not true. I've got a delicious chocolate croissant here, Emily. Be happy with what you have. This is not a witness for the defense. This is a witness for the Commonwealth, the prosecution. Natalie in the chat said, I'm like nervous after yesterday. My nervous system was unsettled. Yeah, it was a lot yesterday.
Thank you.
A lot yesterday.
Ready, Mr. Whiffin?
I am.
Thank you. So what I'd like to do is to, with your Honor's permission, is to publish
They're entering
pages
parts of his
28,
report into
29,
testimony
and
or
30,
into
and start
evidence.
with page
Damn.
28.
Okay.
Thank you, Your Honor. Mr. Wolf? And if you could enlarge the text down below as much as you can so the jury can see it.
AGD Gaming yesterday was really spicy. There's a case brief on the Emily
Thank you,
Show
Mr. Wolf.
YouTube channel.
So,
and there's
Mr.
timestamps
Whiffin,
when you need to catch up.
summary
Yesterday
section
was
of your report
spicy.
is a summary of the location
You guys have great
section
questions this morning.
that you wrote in your March 2025
I'm gonna get to as many of them as I can.
report, correct?
That's correct.
And it states the location data on this device contains a vast number of records while traveling between 12/19/33 and 12/24/38. These records all have a high horizontal accuracy value as well as bearing and speed information which conforms to the streets being traveled. Next paragraph. The device arrived outside 34 Fairview at 12/24/38 where it remained static for about 30 seconds. Do you see that, sir?
I do, yes.
And did I read that correctly?
You did.
You continue to read that correctly, Mr. Alessi.
Did I read that correctly?
Sorry, yes, you did.
Yeah, so at the end of it says, show the device moving west from the roadside towards the house. That's what you wrote, correct?
Correct.
TT Santiago, you're not late. They just said good morning.
I would
We're
like
all
you
good.
to,
There's grace.
Mr. Wilk, if we could
There's a grace
switch,
period.
back to
It's like when the opening act takes the
timeline,
stage. There's a grace
of Mr.
period.
Whiffin that we had published yesterday in
We
deck.
all need a minute. They're getting into Mr. Whiffin's report a little bit. He kind of zoomed over
79.
in direct examination. Brennan kind of zoomed over that the phone looked like it was
Mr.
drifting
Whiffin,
westerly.
if
There
you
were arrows
could,
though in
please.
his report
We
that
just
showed
read
that.
that portion of your report that says at 25:30 the device bearing shifts to a westerly direction as location records also show the device moving west from the roadside towards the house. Did you put that in your timeline?
I did not.
It was in the rest of his
It's kind of
report. though.
important information, isn't it?
I believe with the declining accuracy, the value that those records provided was more limited.
But it was important enough for you to write it in your report, but you didn't put it in the timeline, correct?
Correct.
Dead ass though, it was in the earlier slides on the PowerPoint because the arrows were pointing and it showed it yesterday. So, I mean, again, it's fine to have a serve, but I think there's probably more serves for this witness than this one because the timeline is a summary. I think there's, well, we'll see
Now,
when they
if
get
you
to
could
more.
continue on your report, page 29, Mr. Wolk, if we could put, and we're going to be flipping back and forth between the timeline in your report.
I was wondering who he was talking to. He was talking
If we
to
could go
his tech
page
person.
29, enlarge it, the text, so the jury is able to read it along with
I like
us.
your dog more said.
We're going to start
Is
from the
Whiffin
top.
the state's Cellebrite expert? Because I keep hearing
So-
people say he's not. No, he's
The
the
next
state's Cellebrite
says,
expert.
from the combination
He
of
works
device
for Cellebrite.
location and bearing, it
He is the senior digital forensic examiner from the company Cellebrite. Yes. Will the state have other forensic examiners? I assume so. They're on their witness list. But he works for Cellebrite, so he is their Cellebrite expert. I don't know what else you would call it.
does
The internet might quibble with the word expert and snark about that, but that's who this witness is.
appear that the device started to move towards the house. However, since the bearing information appears to be based on the location records rather than the direction the device is facing, it is difficult to say with any degree of certainty if the device actually moved. Did I read that correctly?
You did.
So the first part is again a statement that the device has started to move toward the house. Now, if we could go to the next paragraph.
Scrange in the chat said, does the
This
Commonwealth pay experts to
location
testify?
data
Yes.
is immediately followed by 12 minutes of low accuracy records which offer no reliable location information. So I just want to make sure I've got the time period here right. The 12 minutes is from 12:25, correct?
Yes.
And
that's
so
correct.
12:25 plus 12 is 12:37. So the range we're talking about here is from 12:25 through 12:37, correct?
Correct.
Then, if we could go to, Mr. Wolk, please, back to the
Morgana,
timeline.
I'm holding on to your question.
Slide
A number of
80.
you asked. I'm going to get to it when we have at some point he's going to approach and show him documents again, and we'll have a minute. Ron said, did I read that correctly? Gives me depth flashbacks.
I
Us
want
too.
to discuss with you the very top entry, Health 123156, where you have the entry, start of health event, 36 steps, 25 meters, and yesterday we agreed 25 meters is approximately
This is at
84 feet,
12:31?
correct?
Correct.
And that is what you have in the timeline. Let's understand what that means.
Appreciate, and I said this yesterday, that I thought the defense was going to, instead of just excoriating this expert, I wonder if the strategic choice was, Jen McCabe will wreck herself, and at the end of the day, the Google search isn't the end all be all. But if the jury looks at this timeline, I think there is a lot of room in this timeline for the defense to argue their position of the case and how they see the case. So instead of saying, oh, these reports aren't right, you don't know what you're talking about, they are just focused on the timeline. Okay, so at 12:31 a.m., there's 36 steps, right? Okay, we're nailing that down. Okay, so the accuracy gets less accurate for 12 minutes. And during that time, there's also 36 steps. Okay, well, what are some reasons, and they'll get there, I'm sure, that phones get less accurate? Because he said in direct, it could be things like going inside or going in a basement. His words, not mine. So we're seeing the defense nail down the timeline here, as opposed to just saying everything this guy says is crap, throw it out. It's interesting to see, and I think we're going to see that throughout their direct.
At that time period, 12/31/56, do you recall writing in a March 2025 report that the device began moving for a period of 20 seconds?
Related to the location data, I believe.
Yes.
Yes.
Now, if we could, Mr. Wolk, go back to page 29 of the report. So
Thank
what
you,
I
Ian
want
Moore
to
in
do
the
is
chat
go
who
back
said,
to
quote,
that paragraph
everything
up
that
the
guy said is
top
bullshit.
from
My cousin
the
Vinny.
combination of the device.
And DDB.
From the combination of device location and bearing, it does appear that the device started to move toward the house. However, since the bearing information appears based on the location records rather than the direction the device is facing, it is difficult to say with any degree of certainty if the device actually moved. So you're talking about difficulty saying with certainty, correct?
Correct.
But it is certainly possible that the device was at that location and was moving toward the house. That's possible, correct?
Based on location data, yes.
Now what I'd like to do, please, is to go, stay on.
Remember, I'm trying not to, I know a lot of you haven't seen this trial before, so I'm trying to give commentary without spoilers the best I can, but also orient you to the information in this case. So this is not a spoiler. Remember, at the end of this trial, the jury instructions in Massachusetts are actually incredibly strong for a defendant. And when we get to those jury instructions at the end, when they talk about circumstantial evidence, which is most of the evidence in this case is circumstantial evidence, because it's evidence you have to draw an inference from. It's not a direct evidence of a thing like, and we'll get into that another day. But the circumstantial evidence instruction says very plainly, and I think in more than one spot, if there are two reasonable inferences, you must, that's the word in the jury instruction, must pick the one that points towards, and they either say innocence or not guilty. I think in Massachusetts, they say points towards innocence. So when we're getting the defense bringing in, so it's possible A or B, the jury instructions very clearly say that possibility must default in favor of the defense. And that's why you don't see, I think, the defense trying to skewer this witness. Instead, they are using this witness to say, here is the doubt. If it could be this and it could be that, then it's not a guilty verdict. So that's, I think we're going to see more of this. It's possible. It is a less dramatic style of cross-examination, but I think it's incredibly effective when you can bring it back around in closing and say, even the state's expert says it's possible A and B. The jury instructions say, if there are two possibilities, you must pick the one that points towards innocence. So that's why, even though it doesn't feel like a big dramatic, like, get him cross, it's strategic.
That
incredibly
report,
strategic.
In the third paragraph says, the reason for such low accuracy location data at this time is not known, as there are many possible reasons why the accuracy was be reduced. There's a little grammar issue there, but in fairness to you, sir, we do that when we write.
Oh, Alessi, you just make our nerd hearts happy. There's a little grammar issue there. It's okay, boo-boo. We need to do an Alessi word of the day. I think we only got one yesterday.
Any possible reasons why the accuracy was
I had to back that up.
reduced.
That
There's
was
a little
funny.
grammar issue there, but
Correct.
in fairness to you, sir, we do that when we write long reports. But I think that your intention here
I do it all the
is,
time, Alessi.
You know, why the accuracy is reduced at
Was
this
reduced,
point,
yes.
correct?
Correct.
Thank you. This could include reasons such as the device entered
Notepad is
a
dying.
building covered area, the result of weather conditions, geography, poor connectivity, or interference, to name a few. So those are the reasons you gave, which could contribute to some low accuracy, correct?
Correct.
And interesting, the very first reason you gave is that the device could be entering a building or covered area. And that phraseology could include a house, correct?
Correct.
It could include a garage attached to the house, correct?
Correct.
And it could include the house at 34 Fairview, and it could include the garage attached to the house at 34 Fairview, because both of those are buildings or covered areas, correct?
Correct.
Right.
Then you go on in the next paragraph.
Different strategy than last time. I think
To
it's
say it
effective
is
when they argue it
known
later.
that the device was not being used at this time, and is this time that include that 12:37, 12-minute range, 12:25 to 12:37?
Yes, it was not being used for location purposes.
So that's another reason why, right, the accuracy could be a little bit on the lower side.
Correct.
Now, the next paragraph says, at 12:38:13, when the device begins recording higher, and that's relative to what it was recording before. It's not that it's high, but it's higher than what it was just moments before.
Correct.
The data centers on a location slightly closer to the house than the roadside. Although several records show the same center coordinate with differing accuracy radii. Some of these location records are shown in the map below in white.
Is radii really
So
the
let's go
plural
down
for
and
radius?
look at what you had
I guess
in
I never
your
thought about it.
report for the area in white. In the area in white that you're referring to,
Autumn
there are
Mississippi.
two
Thanks,
white
Chad.
circles, the largest one there.
The more you know.
This, in fact, was
I
a
never really thought about it.
depiction that you included in your report on page 29.
We can discuss octopus
correct?
octopi
Correct.
later. With Warren.
Interesting
Good use
and
of.
notable. You didn't.
I like Alessi a lot. I like his style a lot. I like how he changes his tone to highlight to the jury like this shit's important. I really appreciate it. This is a great graphic that we did not see in direct. And look, pictures are helpful to all of us, especially on day 6 of trial. So the jury's like, ooh, pictures. Love it. Love
This,
it. Love it.
in
Love it.
fact, was a
Included in
depiction
your
that
report.
You included in your report on page 29, correct?
Correct.
Great image.
Interesting and notable. You did not include that depiction in your timeline that you discussed with the jury yesterday.
It wasn't in the PowerPoint either.
I did not know.
But it was important enough for you to put that depiction in your report, correct?
Correct.
And notably, the larger white circle covers a substantial amount of the house at 34 Fairview, correct?
Correct.
A few of you in the
So,
chat asked, isn't this leading? Yes, it's direct
Given your
examination
testimony on direct yesterday
You
with
get-
Attorney Brennan,
to
the phone of
Use it.
John O'Keefe, according to this depiction, could be anywhere within the largest white circle, correct?
Correct.
I really like
And it-
Using
and
this witness for them.
depiction was not offered
Yep,
by
it's
you
cross.
or the
Did I say direct?
Commonwealth in
It's
your
cross.
presentation to the jury.
if I said direct, my mouth and my brain are doing different things. The coffee has not connected them yet, but it's cross, it's allowed. So you don't have to do
Yesterday.
direct
Correct.
questions.
Correct. Not in the PowerPoint.
Now, if we could go back.
It was
Mr.
in his
Wolf, to
PowerPoint.
page 29.
It was in his direct examination in his
Of
PowerPoint.
your
It was
report.
just greatly downplayed in his
into
PowerPoint.
the text. And if we can enlarge the text just a little bit, please, for the jury, Mr. Wolf.
What I appreciate about this witness is the way he's answering on cross. He has not backed away from the answers. Did you put this in your timeline? No. Did you include this in your report? Yes. It was important to include it in your report. Yes. He just really, he's not moving away from those answers at all, which I also really appreciate.
So,
I mean, you did what you
the
did.
paragraph that begins
If you
with at
just say it.
12:38:13, when the device begins recording higher accuracy information. Again, the data centers on a location slightly closer to the house than the roadside, although
move me out of
several
the way.
records show the same center coordinate with differing accuracy radii. Some of these location records are shown on the map in white below. And I repeated that just to connect this part of the text to that diagram with the big white circle. Have I done that correctly?
Yes, correct.
Thank you.
Kim said, what should he have done? Lied. No, some experts will not just give the answers. Some experts will say, yes, it wasn't in my timeline because I didn't feel that it was important to put it in the timeline because it's represented blah, 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 blah. They will fight for that over explanation instead of just answering the question. And it makes it seem like it's because they are afraid of the implication or they want to fight with the attorney. So him just saying, yep, that's what I did, is appreciated by me.
Sir, the next paragraph.
And I don't think Alessi's, I think Alessi sounds like he's yelling because we have a microphone, but in court,
the GPS
the witness doesn't always hear him.
And the associated accuracy radius jumps around numerous times between the
It does what
house
now?
and the road.
Jump around.
Did I read that
jump
correct?
Around.
Correct.
Jump up, and get down. Jump, 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 jump. All stuff.
And therefore,
Wait, no, House of Pain is Boston.
over
It's
the
totally
next
appropriate
few
for this trial.
hours, according to your report, the phone of John O'Keefe could be in the house, correct?
Based on the low accuracy information, yes.
The answer is yes.
Yes.
But there's other information that contradicts that. But he didn't
next paragraph.
fight to add that in. He said based on the low accuracy, yes,
Well,
because there's more.
We'll stop there for a moment.
Oh, chat,
and
do
I
we
would
summon
like
Octo?
to, Mr. Will, put
Hey, Warren.
back, go down, scroll, please, to that diagram that's right below that text again.
I think that point cuts both ways because if the jury looks at the battery temperature and is persuaded by that, the jumping around of the accuracy data might not be significant to them. If they have questions about the battery temperature and about other things, then they might be like, no, this keeps moving. So if the accuracy is moving and the temperature seems stable, then where are we at?
Yesterday, you discussed the Waze application with Ms. Attorney
I came
Grant,
to get
correct?
down.
Correct.
I came to get down.
And
Look at
you
that.
stated
This is
that
number
Waze location data is more accurate than the data that comes from the Apple apps like health data and location, correct?
Incorrect, no.
I'm sorry. Is Waze location data, in your view, accurate location data?
There isn't really a thing such as Waze location data. Waze,
I'm having trouble hearing.
Waze location data doesn't really exist. Waze is
Apologies, Mr. Whiffin. Bostonians, is it warm in Massachusetts today? Because it sounds like the air is back on in court. This was a huge issue last time they were opening windows yesterday. This was a huge issue last trial that when they had fans on in court, not just the only fan, but other fans, it got really hot. All of you are saying, yes, 72. Yeah, it might feel really warm in court. So it sounds like they have the fan on. So we're going to hear everyone yelling a bit more. What we learned from last trial is this courtroom was built in like 16 something. I'm exaggerating, but I'm from California. If anything was built, it was built in like 1960 or later. Like there's not old shit. They just rebuilt it. But Massachusetts loves its old shit. So old courthouse, fans, no AC is my understanding. And the fans can get really loud. And so when they're having trouble understanding each other, I'm like, uh-huh. Well, it's patio. It's like, patio weather, but it's going to get really hard to hear in this courtroom, and we're going to hear them yell. I know all of you are saying it's historical. I get it. And yes, in California, old stuff doesn't last because it falls down. Yes. So old courthouse, no AC, fans are loud. The attorneys are going to be yelling and the witness is going to be like, I couldn't hear you. That's going to go on. We haven't heard the judge yell, please speak up yet. So we're day 5 in. That's nice. But yeah, it's like Aperol Spritz season if it's that warm in Massachusetts.
requesting location data from location services, and location services would respond
Back to
with high
Waze data.
accuracy information.
Okay, I appreciate that correction. So
All of you are like, beautiful day here, beautiful
when
day.
someone is using a Waze application, is the information they
mean,
get
Tennessee
through that
likes old shit
Waze
too. I love it.
app accurate?
It tries to be accurate, yes.
And as a general matter, is the Waze application more accurate than the Apple information regarding location?
It's the same thing.
It's the same thing because it's coming essentially from the same source, correct?
Yes, Apple provides that information to Waze.
Right. So you had testified
though there is
yesterday
drift.
that at a certain
Anyone who
point,
plays Pokemon Go knows all
the
about
Waze
the dreaded
application
drift.
ceased functioning, correct?
Correct.
But just because it ceased functioning, the Waze, the Apple applications were still
It's fair.
taking effect, and that's why you could make this depiction on this item that is on the screen now, correct?
Correct.
In the winter, I'm more of a paper plane kind of a girl than an Aperol Spritz kind of a girl. Spritz just with the ice, it
If
just
we
feels.
could, Mr. Wolk, go to page 30.
He's not referring to the witness. I see a lot of you guys in the chat saying, is he calling Mr. Whiffin Mr. Wolf? No. He's talking to his defense team individual that is operating the slides on the screen. So he's not talking to this witness. He is talking to his defense person. Can we please go to this slide? He's not calling him Wolf, unless he wouldn't.
And what I'd like to highlight, please, is the text. So if we can enlarge it up at the top. So you then state, while location data from this data source, cache SQLite, is usually able to identify the location of the device with a high degree of accuracy and reliability, these records are so close that making a distinction between the device's actual location on the front garden is impossible, correct?
Correct.
Your words, impossible.
Correct.
Did you provide any of the information in that paragraph in your timeline or to the jury in your direct testimony yesterday?
Not in the PowerPoint, no.
What now?
Next paragraph. If the location records are limited to just the records between 0025, which is 12:25, and 6 a.m. and with an accuracy radius of 10 meters or less, there are 46 records, all of which fall within the red circle shown below. Go ahead, Mr. Wolk, if you could scroll down. And that is the only depiction there that you included in your timeline yesterday, correct?
For y'all
Correct.
asking, shouldn't
So
it be in the
you
report?
took
It is in the report.
One
it
of
wasn't
two depictions
in the PowerPoint.
in your summary of the location.
because they're reading the report.
This one, in terms of your timeline presentation, correct?
Correct.
Now, in terms of the timeline, and Mr. Wolk, if we could go back to the previous with the other depiction.
I like your dog more asked,
Could
is
enlarge
his
that
report
depiction,
part of the
please?
evidence? There are portions of his report that the defense is going over that they have stipulated to
So-
allow in evidence. Reports are not always allowed, but yes,
You
the things Leslie's
testified
going
that
over
the
will be, and the jury will have
flagpole in
it.
the fire hydrant are more down toward the small black circle. Is that correct?
That's my understanding, yes.
And yesterday, you rendered an opinion that you believed that the phone was mostly in the location by the flagpole in the fire hydrant, correct?
Objection.
I'm going to see counsel at sidebar for a minute, please.
You know, we got trucking pretty well through some testimony before we got to a sidebar. Look at how calm. Look at how calm. I'm here for it. All right, they're going to sidebar.
May I, Your Honor?
Yes.
Thank you.
We had some good questions.
We could,
Mr. Alessi, before we get back to you, in the chat asked, can the prosecution call Karen Reed? No. Karen Reed has a Fifth Amendment right against self-incrimination. The prosecution cannot call her to testify. But what they can do is pick clips from all the public statements that she's given and play those to the jury without her testifying. The defense cannot use her recorded statements. So the defense can call Karen Reed to testify. The prosecution can use her out-of-court statements. So those are your two options that you have. And Morgana asked, Emily, why can't they call Apple to testify? They can. I'm sure the jury is asking the same. What do you think? Apple can't testify to the Cellebrite report. The Cellebrite report is going to be a big point of contention for the defense and what's in the Cellebrite report. And an Apple employee is like, yeah, that's not our report. But if they wanted to call someone from Apple to explain, I mean, there are some things that might be proprietary, but generally what phones are capable of, what they can detect, motion data, they can do that. It might be harder to do, but they could do that. I don't know if they will.
Again, please.
I doubt that they will. But
Thank you.
yes, they could. The defense can't use her media
So,
statements because
if
they
we can
are
enlarge
self-serving
that
hearsay.
depiction.
The defense can call her to testify, but they cannot use her statements out of court.
So, yesterday, Mr. Whiffin,
If the defense wants the jury to hear from Karen Reed, then it has to be on the stand under cross-examination. The prosecution, however, can use those party opponent statements.
you focused your testimony and your opinions on the smaller black circle, correct?
Correct.
And you didn't discuss at all or disclose at all this depiction, and therefore didn't discuss or disclose at all the larger white circle, correct?
He discussed it. He didn't use this image, though.
Not when discussing my overall opinion.
Right.
Yeah.
So the answer
Is no.
right. So,
He
The
showed the overlapping
fair way to
circles, but
interpret-
very briefly.
and this is what you put in your report, this is your depiction, is that, and based upon what you said yesterday, the phone could be at the very edge of the top of the circle, correct?
Correct.
And the phone could also be at any point, so you can, in theory, put a phone anywhere around the very edges of that entire circle, correct?
Yep.
There's caveats to that, but yes.
Well, I'm just asking
Yes.
that according to
There's
your
caveats to that, but
testimony
yes.
yesterday, in this depiction, the phone could be anywhere in that location
Yes.
within the area of that white circle.
Correct.
Sarah, no, the voir dire yesterday was different witnesses. It didn't involve
I
this
would like
witness.
to now go back
This is his-
to
This is
the
juxtaposing
timeline,
the
Mr.
report he
Wolf,
wrote vis-a-vis
Where we
the
had left
PowerPoint
off,
he gave to the jury
which
yesterday.
is slide 82. And
They
at the
will
very
have data
top
from
entry,
Karen's
you
phone
have
later in
health,
trial.
Time 3156, and then the description, start of health event, 36 steps, 25 meters, and we agreed about 84 feet. And this is where the device began moving toward the house for a period of 20 seconds. Is that correct?
It's the time that 36 steps started to be recorded. I've got no idea of the direction of travel.
I want to focus on the time, 12:31:56. Are you aware that a firm called Aperture, on behalf of the Commonwealth, has submitted a report that states that there was a trigger event at 12:31:56 that they refer to as the supposed collision? Are you aware of that?
Objection.
Sustained.
I recall seeing a report. Sorry.
You don't have to answer that.
Oh, he already said he saw the report. Go on, Alessi, rephrase it.
Mr. Whiffin,
Did he review a report?
are you familiar with a firm called Aperture?
I'm vaguely aware of them. I've heard of them once.
Are you familiar with a person by the name of Dr. Judson Welcher?
I'm not, no.
But you're familiar with the firm Aperture?
I am.
And do you know that the Aperture firm is working on this case?
That's the only reason I'm aware of this company.
Right. And do you know that the Aperture firm has used your data in your report? Do you know that?
I believe I saw something about that.
Do you believe you saw something, or do you know that they
What'd you see?
used your data for a report in this matter?
What'd you see?
I recall seeing a report. I don't recall whether it was my data that was being referenced.
Do you recall seeing a report from Aperture?
I do.
So you reviewed a report from Aperture.
Well, you saw
Several
it.
months ago, yes.
And did you read the whole report?
It was a PowerPoint presentation, I believe.
Yes.
Yes, I reviewed it.
And you recall reading that entire PowerPoint presentation?
I don't recall what it said, but I remember reading through it.
Fair enough.
The whole 140-page PowerPoint.
Do you remember, as you sit here today, reading
Unless he just
about
got
a
excited. He was like,
trigger of a number 1162-2? Do you recall reading that?
I recall seeing reference to a trigger event.
What did you understand the Aperture firm that's retained by the Commonwealth?
that's objectionable.
What do you understand they meant by trigger 1162-2? Objection.
Sustained.
I was going to say. Yeah.
Do you recall the
That's not a
specific
proper question.
slide that discussed a trigger? Objection.
Do you recall that, Mr. Whiffin?
Very vaguely.
Would it help your recollection if I showed you a slide from that report that you said you reviewed to refresh your recollection?
All right, so why don't I see counsel at sidebar? Bring that with you, Mr. Alessi, please.
Alessi's going to have to go about this a different way. You cannot ask this expert to testify about the opinion of the other expert in this way, because they are not, it's not I'm the cell phone expert and that's a cell phone expert, and I reviewed that report to tell you why I agree or disagree with the opinions. This is an expert in the accident reconstruction, so it's a different expert that has not yet testified. So Alessi's going to have to narrowly tailor the questions about, if I told, like in a hypothetical way, if I told you that an accident reconstructionist said XYZ happened at this time, where in your data does it reflect that? In the motion data, in the cell phone battery, whatever. So he's going to have to rephrase that if we're going to get into that question. Let's zoom past sidebar. We can zoom. The jury cannot, so they deserve all of our empathy as they sit there awkwardly for what looks like a fairly long sidebar. You can't impeach. Pitbull Crew asked for impeachment. A great question, but you can't impeach this expert with an accident reconstructionist report. You can give a hypothetical. Bell said they relied on his data. Right, but he didn't make his data for them. They can be questioned more, but he can't be. So it's going to have to be in the form of a hypothetical, which should be pretty easy. Tracy said EDB, is it frowned on for Karen Reed to go up to sidebar? This jury probably has no realm of context, and she's not in custody. There's no concern about it. The court told her that was her option. Her attorney said we can get her headphones, and the court said no, she can walk up to sidebar. I think it's easier for the defense than having to explain to her everything that happens at sidebar, because sidebar is a lot happens. So you guys are asking about the sequestration order. They were saying that the experts should be excluded from it. So the experts should be excluded from it.
You can approach.
Thank you.
She didn't go up to sidebar last trial, I don't think. But then the attorneys had to come back, sit down and try to tell her what was happening. And that's a lot.
I'm handing you this document.
Thank you.
She wouldn't be speaking at the sidebar. She would be listening to what's happening.
Tell me when you've had a fair opportunity to take a look at that.
Kate Manning, did Alessi win? He won our hearts with his love for grammar and his fulsome vocabulary. But I think he's doing, I think this has been a really strategic cross. I see a lot of you talking about who is and is not in the courtroom.
Recollection
It's not.
with regard.
It's kind of not on topic, but it's not of great interest to me. I really don't pay that much attention to who's in the courtroom unless something pops off, because people will be in court for reasons and not be in court for reasons. And it's just so outside of the testimony. I don't really pay attention.
To an aperture report that discusses a trigger.
And it gets us off topic fast.
1162.2.
It does, thank you.
Pardon me?
It does, thank you.
And how does it refresh your recollection?
Because I saw
I
it.
remember seeing that several months ago.
I'm sorry, Your Honor. There's a blower on here that I'm having trouble hearing Mr. Whiffin. If you, sir, could bring the mic. It's not
There's a blower on here and I can't hear. It sounds like the fan is back by where Alessi
your
is.
fault.
That
if you could bring
sucks.
it and speak a little louder, I'd appreciate it.
Yeah, I recall seeing that as part of the report that I read 2 months ago.
And you recall the time of 12:31:38 now, correct?
Correct.
Let's
Yeah.
go back to your timeline.
In cross, being able to hear your witness is critical. And if you have a fan right behind your head,
82?
that would be so frustrating.
So you just spoke about a trigger 1162.2
Mariah, that's
associated
hilarious.
with a time of 12:31:38.
That shit's funny.
And we are now at the timeline of 12:31:56, correct? Objection.
Sustained.
We are now going back to the timeline, deck 82, and you see up at the top where it says health 31:56. You see that, sir?
I do.
And then it says start of health event, 36 steps, 25 meters, which we have said is 84 feet or so. And this is when the device begins moving, correct?
Correct.
And that is after the trigger of 1162.2, correct? Objection.
Sustained.
Let's go to the next entry on the timeline, which is 1232.03. You see that? That's Doppler.
I do.
And then you state pocket state cleared. Is the phone at that time in a pocket?
It's impossible for me to say. I can say that the camera was blocked, but I don't know what was blocking it.
You're saying at this point the camera is blocked?
It had been blocked, and at that point, it became unblocked.
So at this point, it became unblocked from a previous block status, correct?
Yes.
Does there have to be some human manipulation of the phone at 12:32:03 for that to happen?
That's a great
Technically
question.
not.
That's a great question.
There are scenarios that wouldn't require it.
Is it more likely than not that there had to have been some human contact in action for this pocket state clearing event to occur?
Yes.
That's a great question.
12:32:04 is the next. It's a type unlock. Device unlock with Face ID. You see that, sir?
I do.
Is there some human action that has to occur for the device to unlock with Face ID?
Typically, you must be paying attention to the phone.
Sorry, sir?
You must be paying attention to the phone, assuming that that setting's enabled.
So someone had to be looking at the phone.
Yes.
Great questions.
At
Great questions.
12:32:05, application focus. What does that mean?
That the messages application was at the foreground of the device being used.
Next entry, 12:32:06. We discussed this it says read message, pull behind me, and that is associated with a Jen McCabe. It's a Jen McCabe message of 3147, correct?
Correct.
And does a human have to be reading that for that entry to be made?
The message needs to be on screen. If the conversation with Jen McCabe was already on screen when the device was unlocked, then that message would automatically be considered read.
Next entry, app lock 123209, end application focuses messages, and then it says device locked with lock button for the last time. That requires human interaction with the phone, correct?
Correct.
And it actually requires somebody to take the cell phone and press the side button to do that, correct?
It does, yes.
So there has to be some degree of coordination for that to occur, for a human to be able to have something that hits that button, correct?
Certainly, yes.
Do you understand?
Erica's Way in the chat asked what all of you are asking. What time did Karen drop John off? We haven't gotten there yet in the testimony. So we're going to have to wait to see how it comes in because we're not there yet. The jury does not have anything to check this timeline information about. They are taking in this information, and then as they learn more information, if they have notes, it'll be like, wait, the times. But we're not there yet.
What the term fine motor skill means? Do you understand that? And would that person have to be using fine motor skills to do that?
Yes.
Next entry, 123216. End of health event, 36 steps, 25 meters, again 84 feet. That is in your timeline because that's when you believe the end of the health event, the end of the 36 steps occurred, correct?
That is the time that the device data shows the end of the health event, yes.
So
Can I
yes.
have a moment, Your Honor?
Yes.
Thank
So
you.
yes. So that's a yes. Good use of time frame. Real good use of time frame. Lindsay asked, EDB, is it true only the DA can charge perjury? Well, the feds can too, but yes, it has to be a prosecutor. Generally, law enforcement has to investigate it. So any Commonwealth witnesses who perjure themselves are
Do you
unlikely
need
to
the
be
light,
charged.
Mr. Lessie?
Yeah,
They're
it would be
unlikely to be
helpful.
charged
Thank
for
you.
Have the
other
lights, please,
reasons.
Dave?
I've tried a perjury case. I don't know many people who have criminally prosecuted perjury cases. They are very unusual to prosecute. They are very difficult to prosecute because most people can say, I misunderstood. And if you misunderstood, it negates your mens rea for a perjury because perjury is not for, I didn't understand the question.
Do you recall
they are very hard to prosecute
writing in
and
your
rarely done.
March 2025 report the following?
Emily, did you take?
Final health
Did I win? Yes, I
activity
did.
of note on John's phone can be seen to have occurred between 12:31:56 and 12:32:16, during which 36 steps were recorded, covering a distance of 24.
We haven't gotten to see Alessi. We've only gotten to hear him. We've only gotten to hear his inflection, but the full body inflection is is just the best. He's like, see? Oh my goodness, it's so good. I'm just backing it up because that was delightful because we haven't gotten to see a lot of the full animation from Alessi and Cross.
12:31:56 and 12:32:16, during which 36 steps were recorded, covering a distance of 25.4 meters, again at 84 feet, according to healthdbsecure.db. Do you recall writing that?
I do.
And you used in your report 36 steps were recorded covering a distance of 25.4 meters or 84 feet, correct?
Correct.
Great point to highlight.
Do you know a trooper named
When those 36 steps were taken and how much distance those 36 steps covered. Can the Commonwealth get up there and be like, well, he could have been walking a different way? Well, Alessi has pointed out that the phone moved in a westerly direction towards the house and 84 feet were covered. So can the Commonwealth get up there and be like, but it could be anything? It'd be real hard.
Nicholas Garino?
I could try.
I'm aware of him, yes.
Are you a little more than aware of him? You've worked with him on this case, haven't you?
He sent me some of the files related to it, but further than that, I've got no relationship with him.
But isn't someone sending you files on a case you're working on, working with the person? Isn't that a fair conclusion?
It could be.
He doesn't back down from stuff. He's like, I mean, he sent me files.
Do
Could you be working with
recall
him?
reading
Whatever.
Any reports of Nicholas Garino?
I don't recall reading a report by Nick.
Does that mean you didn't read it, or you just don't recall reading it?
I honestly can't remember if I did or not.
Sir, if you're sitting there being like, we didn't work together, and he's asking about Trooper Garino, and then you're like, oh yeah, no, Nick and I didn't chat about that. I'm less persuaded that you and Nick aren't working together. No, he sent me some info. Okay. The first names are going to get you every single time. It is so much more casual, Whiffin.
I remember some of the reports that I read for this case. I don't recall who one was by Nick.
Would it refresh your recollection if I
Is
showed
Trooper
you
Garino's
a
name Nick? I
portion
really
of
don't
his
know.
report to determine whether you would have read it?
Please.
Thank you. Moment, Your Honor, please.
Sure.
Blake. All right. Instead of me memeing, I'm going to try to answer some questions. I saw the question, will Whiffin be questioned by Brennan again after this? Yes, there will be a redirect that will be questioned. So yes, the redirect will be done by Brennan after this. And then sometimes you can have like a recross and then a redirect and then a recross, and then it gets confusing. Sergeant Mom said, sorry, I'm late. Is this actual testimony from ARCCA? No, this is not one of the crash daddies from ARCCA. This is Mr. Whiffin from Cellebrite. The ARCCA experts aren't even slated to testify until the defense case. So, Lovable Swamp Witch said, Emily, what's the best opening act you ever saw? There was a year that Dave played at the Gorge and OAR opened, and it was a fucking vibe. But
Yes.
Limp Bizkit is opening for Metallica this weekend.
Mr. Brennan?
I'm very excited. Emily, do you love concerts the most? Yes. It's literally why I work. Because tickets have gotten fuck expensive. Though if you're in Nashville, the ticket prices that are remaining for Metallica have dropped if you want to go to Metallica. I was looking yesterday at parking, and the tickets, some of them have dropped pretty significantly. Second, Steve Miller Band opened recently when we went to see Def Leppard and Journey, and they were fucking amazing.
Thank you.
Fucking amazing. They crushed.
Thank you. I am providing you with
But
a document.
Alessi,
and
I'm sorry. I
would
love you. This is
ask-
really important. This fall, for Christmas, my teen wanted concert tickets. Both my kids got concert tickets for Christmas. We're just experiences over all else, except maybe a Switch 2. And my teen and I are going to see MCR. I'm so excited I could cry. We're going to see MCR. Evanescence is opening. So I have no chill about it. I am so excited. So I think my list of best opening acts will grow. But, Three Doors Down opened for Creed when we went to see Creed. I mean, they're not really an open act. They were so good. So there's been lots. But I'm going to lose my mind. I'm going to lose my mind. And we are both going to flat iron our hair. I'm so excited. I'm so excited.
If
I'm so
that
excited.
refreshes your recollection as to whether you read a report of Mr. Garino.
Emily, do you work
A
for
report
concert
or
tickets?
this report?
Yep. Yep. I work for concert. Yep. We'll work for concert tickets. It was much easier when I was in college. It was like $10. So, live music is good for the soul. It just is. You know, I know some people do sound baths. Going to see like Three Doors Down and Creed is in fact a sound
Don't recall
bath.
ever seeing this report.
It's all of the woo-woo. It's self-care, people. Don't let anyone tell you differently. Live music is good for humanity. I will die on that hill.
Have you ever had
Which is why I
any
hate fucking Ticketmaster so much.
conversations with Trooper Nicholas Garino?
Who, Nick?
Very briefly.
Oh,
But you had, the answer is yes.
Yes.
you and Nick have had brief conversations?
Did Trooper Garino tell
Okay.
you that he measured the distance from the flagpole to the front door and it was 72 feet? Did he ever tell you that?
How many feet now? When Trooper Garino measured from the flagpole to the door, how many feet now? 72? 72 feet? 72 feet? Didn't you say he walked 36 steps, 84 feet? Everyone in the chat that said, did they measure? Yes, indeed they did. It's a good cross. Look, it's not dramatic. It is not table slapping. This is a foundational cross that lays out everything they need to argue later. Because you know what the jury just did? The jury just went, 72 feet's less than 84 feet.
Very briefly.
But you had, the answer is yes.
Yes.
Did Trooper Garino tell you that he measured the distance from the flagpole to the front door and it was 72 feet? Did he ever tell you that?
Sustain.
Did you ever have a conversation with Trooper Nick Garino about the distance from the flagpole to the front door of 34 Fairview?
Maybe.
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 So is it maybe then you had a conversation with him in which he stated to you that that distance is 72 feet?
It's maybe.
He doesn't remember. It doesn't
So if we go
even
back
really
to-
matter at this point because the jury's heard it twice.
What
Maybe.
we were
He's like, I don't remember.
discussing earlier about
Because that
the
information will
steps
come in other ways.
and the distance covered. And this is in your report of March 2025, where we've talked about this, and it's the final health activity of note on John's phone can be seen to have occurred between 12:31:56 and 12:32:16.
Is this the correct slide?
No, it's
So
not.
let's take it down.
Thank you, Your Honor. Let me start that over. The final
The court's
health
like, I'm
activity note
distracted.
on John's phone could be seen to have occurred between 12:31:56 and 12:32:16, during which 36 steps were recorded, covering a distance of 5.4 meters, or 84 feet. 84 feet is greater than 72 feet, correct?
Correct.
Race tips with low quarter. Alessi.
So if the distance from the flagpole to the front of the house is 72 feet, and your report notes steps, 36 steps covering a distance of 84 feet, that would put those steps within the house, correct?
It would.
Y'all are making me jealous in the chat. You guys have seen some great fucking shows. Lawyers
Let's
have the best
continue
taste.
on with the timeline.
Y'all have the best taste. Just the best.
Deck 83.
Alessi's points have been made very clear.
We now have
Just, it's very clear what he's
Doppler-
getting at.
12:33:14, and then Doppler pocket state. Do you
Sweat.
recall in
That
your
distance is
report
measured in sweat.
adding a word to this, that your report said pocket state detected? Do you recall writing that?
More than likely, yes.
Yes. But the detected word is not on that slide, is it?
It's not, no.
What does pocket state detected mean?
I don't know if we need to
There was
go
an
over this
active
again, but
check
we'll
by
see.
the Doppler function, and it detected that it was in a pocket state.
Megan B answered the question in the chat, 369. That is the distance from the windows to the walls. Thank you. Chat.
The switch.
10 out
Thank
of
you.
10. Just 10 out of 10. They put it in meters because the phone. Oh, we binged. Thanks, Leonard. They put it in meters because the phone records it in meters. So I don't think they're trying to be cagey with that. I think it's just the phone records it in meters, so we put it in meters. Or we can blame it just on the fact that he's a Brit that lives in Canada. I mean,
Do you
one
need
of
this slide up there, Mr. Alessi?
I was just going to check that. I think the answer is going to be no, Your Honor.
That's me being cheeky. The phone records it that way. So he didn't convert it. Kathy said my very first concert was in 1986. Metallica opened for Ozzy. I've seen Ozzy perform too. Though in the lineup Ozzy was in when I saw him at the K-Rock Weenie Roast, it was
I would now
the Offspring,
like
then Ozzy,
to
then
change
Korn,
gears
and
a
Ozzy
bit
kind
and
of
go to
killed the vibe because it wasn't as high
temperature
energy as the
with,
Offspring and Korn.
An iPhone. You recall
Korn was
that
great live.
discussion in your direct testimony.
I do.
Thank you. Mr. Wilk, if we could please have the slide deck, but a different page, slide 60.
I don't remember what year that Weenie
And
Roast
just
was.
tee it up, but please
It was
don't put it
one
on
of
the
the best
screen
concerts
deck.
I've ever seen. It must have been like 2000, 2001, 2002, somewhere in there.
iPhones don't record ambient or the environmental
I haven't drinking
temperature
Midori Sour since.
where the phone may be at any given time, correct?
Correct.
But the iPhones, including the iPhone of John O'Keefe, log the temperature of the battery inside of it, correct?
Correct.
And as a result of that function, examiners and folks like you can use the battery temperature of an iPhone to identify increases or decreases in temperature within the environment that the iPhone is physically located in. True?
I believe so, yes.
And that's right out of your report, right? Your March
I'm very interested to
2025
hear
report
this.
makes that very statement, correct?
Yes.
Margie Rodriguez in the chat said, I was at that Weenie Roast, Emily. I really thought the entire
The
stadium was
battery
going to come down
temperature
with how much
of
people
an
were jumping.
iPhone generally matches the pattern of the rise and the fall of the thermometer temperature, correct?
From my testing, yes.
And when an iPhone is in a lock state with little activity occurring on the device, the battery temperature is heavily affected by the ambient temperature in the environment, again, matching the pattern of the rise and the fall of the thermometer temperature, right?
Correct.
And what I just read is right out of your March 2025 report, correct?
It sounds like it is, yes.
Your words.
And you actually established this in various temperature testing and test scenarios in your March 2025 report, correct?
Correct.
Let's discuss those two tests.
Dust Bunny asked if I like Tool. Yes, very much. Fair enough. You guys have seen some great shows. I love that we're talking about music aside from cross-examination. The Lonards are multitasking at a 10 out of 10 level today. Willie Newman asked in the chat, has the ARCCA voir dire been
You
completed?
had-
Yes. The court cut off the prosecution yesterday and was like, you're done.
An appendix
At the end of the
to
day.
your
That was it.
report that discussed two test scenarios with regard to temperature, correct?
Correct.
Can
And
I
that
just
was
ask,
append-
I'm sorry, Mr. Whiffin, do you have your report with you, sir?
I don't have a copy in front of me.
I'd be happy to provide him with a copy of his report so we can have him follow along.
I think that's great, thank you.
Okay, sure.
Would that be helpful, Mr. Whiffin?
Very, thank you.
The court's like, can we make this happen faster? I don't think that's the court being disrespectful. I know people will read it that way. I think the court is saying you can just give him a copy of the report. Some judges will not let you do that. Some judges are like, you need to walk up each time, refresh your recollection. The court's like, we can streamline this. It's fine. Get your report, take a look. You remember in Depp Heard when there was a fight over, well, this isn't a memory test. It actually is. This judge has said, give him his report. If you're going through things on his report, just give it to him and let's speed this up for the jury so we're not just going, would it refresh your recollection? That's technically how it should be done each time, but we're there. It's fine. So the court is actually, I think, helping Alessi make this go quicker. Nishay, good to see you in the chats at EDB. Did you yell at people on the stand?
There you go.
I had a
Mr. Whiffin,
quieter
please
style of
take
cross.
to reference that report.
And then whoop, there it is,
And
moments.
if you could, turn to
Those
page
didn't need to be
77.
punctuated by my voice. They were normally punctuated by my face. Being like, really?
Okay.
So, are you ready, sir?
I am, yes.
Thank you. So let's look at test scenario 1. Test scenario 1, you took an iPhone, if I'm remembering correctly, same model as John O'Keefe's?
I believe John Keefe's was iPhone 11. I used an iPhone 10.
But sufficiently
similar.
similar for purposes of this experiment?
Correct.
Or this test?
Same iOS version.
Yes. So it's the same iOS version, the software inside the phone, just a different model.
Yes.
And it's the software that's important for this test, correct?
I believe so.
So you state that you placed the iPhone inside a freezer, correct?
Correct.
And
I
now
wanna hear all
if
about
we
it.
could, Mr. Woke, if we can
You put it in
that-
a freezer.
Do we have that in would be page 77? And if we could enlarge that chart, please. Enlarge it just a little bit more. We're not concerned with the text at this point. So we can just.
Alessi's like, in biggin all the way
Thank
in
you.
court, please. Just in biggin. I would like to see it at this point.
Thank you. So what I'd like to do is focus on January 29th.
I'd like that too. Let's do it.
Excuse me. This is your experiment. When did you do test scenario 1, approximately, the date?
It's a
Remember,
good question. It was
Only experts can do experiments.
sometime probably in December last year.
You didn't
I'm
date.
sorry,
In December last year, I believe.
December 2020.
You didn't
Correct.
date when you did this?
What you did here was you took the phone, you put it inside a freezer. What was the temperature of the freezer?
I actually don't know.
But it was
What?
a freezer.
It was freezing. Yes.
So you didn't like put a fucking thermometer in the freezer during the course of time and then track the temperature in the freezer and then the phone at the same time? Like, I'm sure they have thermometers that you can put like the proby part in the freezer and then have like an external reading, and you could like check that external reading like every 15 minutes. What the fuck do you mean you don't know the temperature of the freezer that you hucked a phone into to do an experiment with? If there's no control, is it an experiment? Chat, you let me know. My ice cream was still cold. Sir. What? Mr. Whiffin, you are quickly turning into coroner armpits up in here. I don't know if the jury's going to be as offended by this as we are. But what was the temperature? IDK. Well, my optimism for the information we might glean from the battery temperature is slowly draining from my body.
It is sort of your just regular freezer that.
Nah, I don't care. I can't wait to ask Travis about this. He's going to lose his mind.
So what you did here was you.
I can't
you
believe
took the
this shit.
phone, You put it inside a freezer. What was the temperature of the freezer?
I actually don't know.
But it was a freezer.
It was freezing. Yes.
It is sort of your just regular freezer that everybody has.
A regular chest
Nothing
freezer.
special about
No.
it.
Well, if
Let's
it's a
look
regular
at some
chest
of the-
freezer, is it plugged in? What temperature is it set to? Like, I don't know. There has to be a setting on the
data that you have from this.
IDK is not the answer here. Holy hell.
Let's
I'm going
start
to glitch.
at the 1710 time frame where
How do you
it's
not need to know?
placed in the freezer, and you've got, and we're going to go with Fahrenheit, if that's okay with you.
Of course, yes.
Thank you. 73.4.
Would the relative coolness of the freezer not potentially impact the rapid or slower decline in temperature? Like the difference between the ambient temperature of the phone and the temperature in the freezer, couldn't that change depending on how cold the freezer is? Or is the phone going to is the phone temperature going to reflect a decrease in temperature at the same rate no matter what the differential is between the ambient temperature and the freezing temperature? What in the fuck is happening? It's a murder trial. What day did you do this? I don't know. How cold was the freezer? Cold?
degrees, correct?
Correct.
And then if you go all
What?
the way down to the 1725, which would be 15 minutes, correct?
Correct.
Can you state what the drop in temperature is of the battery temperature in just 15 minutes in a freezer?
Approximately 50 degrees Fahrenheit.
What was
So
the
it
ambient
drops
temperature?
50 degrees Fahrenheit in just 15 minutes.
Correct.
I know that's a
And
Leslie's
is it-
point. I'm going to back that up. That's actually a really good point. I'm just still fucking glitching. That's a really good point. It's a really good point.
In temperature is of the battery temperature in just 15 minutes in a freezer.
Approximately 50 degrees Fahrenheit.
So it drops 50 degrees Fahrenheit in just 15 minutes.
Correct.
And is it fair to say that if you do the math,
That's really fast.
that's about a little over 3.5 degrees per minute? And if Your Honor, if he wants to use a calculator, or just accept my estimate, whatever Your Honor thinks is appropriate.
However you can answer the question, Mr.
I'm
Leckie.
happy to accept. your
Alessi
answer.
sounds good.
That's fine.
He's like, I'm not mathing.
Just make sure.
Alessi probably busted out a calendar, a calculator. Damn. That's much faster than the temperatures dropped based on his direct examination yesterday. So the
3.33, would that sound
temp
fair,
of the
sir?
That sounds
freezer
So it's about
vis-a-vis the temp in Massachusetts
3.3 degrees Fahrenheit per
is
minute.
gonna matter.
Correct?
Correct.
That's a bad look, dude. That is a bad look for this expert.
Now let's go to
And unless he's going to use it to
the
say,
next page
hello, doubt.
of your report, page 78, where test scenario 2. And in test scenario 2, you took the same phone with the same software and you placed it outside at a temperature of 33.8 degrees Fahrenheit.
I think the defense will use
Correct.
this effectively during argument later and
And-
with other witnesses later.
We could enlarge that, please, Mr. Wolf?
I'm interested to see what redirect is like. Isn't being accurate important to you,
And
sir?
if you could just scroll up, well, just if you just leave it there, is fine. So
No?
if
Yeah?
we take the time that we start out with a control temperature, and then we've got
Chat, no, the control temp's not a control temp. It's just the temp before it goes into the scenario.
battery temperature
It's
at
not actually a
9:02,
control,
and
the
this
way
is the
you were
battery
thinking of.
temperature of the iPhone, correct?
Correct.
And we've got 66.2 degrees Fahrenheit, correct?
Correct.
So is it fair to call that a baseline for purposes of what this chart is?
The device had already been outside for 2 minutes at that point, but yes.
Okay, so we'll just refer to 66.2. And
What was the battery temperature before it went outside, though? Like, before that, what was the battery temp?
then if we go from 9:02 down to 9:15, a period of 13 minutes, correct?
Correct.
So at 33.8 degrees and 13 minutes, what is the drop in temperature in degrees? What's the
That's
drop?
fast.
Sorry, between the 9:02 and the 9:15?
Right. So does it go from 66.2 to 35.6?
It does.
And sir, so I don't have to have you do a math on the fly. I've calculated that drop at 30.6. Does that sound about right?
That sounds correct, yes.
So you got a drop of 30.6 degrees in
That's
just
fast.
13 minutes at an outside temperature of
At least-
33.8, correct?
Correct.
At least we knew it was 33 degrees outside when he put it outside in Canada. At least we had an outdoor temperature. That's way faster than the phone temp dropped in this case. The argument from the prosecution is going to be, but it was
We're
under
gonna
a
come
human,
back to this, but what I'd like to do
and it was between a person and the
is
ground,
to
and that's
compare
different.
these two test scenarios. The one
But
we
this
just
is a
saw,
very
33
effective
degrees
cross-examination.
Fahrenheit,
Not dramatic.
where it dropped
Precise.
30.6 degrees in just 13 minutes, again at an outdoor temperature of 33.8, and then test scenario 1 in a freezer, where it dropped 61.2 degrees in just 15 minutes. Now let's go to the slide 60, which was in your slide presentation yesterday, of what you stated was the temperature change in the iPhone of John O'Keefe on the morning of January 29th. You with me, sir?
Yep.
Thank you. So if we start out at 12:13, we see a battery temperature of 82 degrees Fahrenheit, correct?
Correct.
Then it drops a little bit to 77, a little bit to 72. And what I want to focus on is keeping the starting point for my questions here at the 12:37 time period on the morning of January 29th. And that's 72 degrees Fahrenheit, correct?
Correct.
Alessi's
So
making
if
very
you-
good points with this.
Take the time period from 12:37 to 12:53. That's a 15-minute interval, correct?
Correct.
It
The
drops
phone
from
only drops 11 degrees Fahrenheit in 15 minutes, correct?
Correct.
If you then go to 12:37 and give it a little bit more time, down to 1:36 a.m., the temperature, and that's just about an hour, right?
Correct.
And the temperature drops from 72 to 50, only 22 degree drop in an hour, correct?
Correct.
Now, if you compare
he's like, yep.
this chart in the drop in temperature, for example, 12:37, 12:53, in 15 minutes, it's only dropping 11 degrees. To your experiments, where with the first scenario with the freezer, it dropped.
Whiffin's seeing the issue. He keeps pulling at his collar. He's seeing the issue. There's just nothing he can do about it. The data is what it is.
Degrees.
Could he have done
15-minute
better data?
period.
Maybe, but this is outside of his...
Is it correct to say that there was a much more dramatic...
This is why experts should stick to their realm. This is not his area of expertise with doing experiments on phone batteries and the relative temperature of phone batteries. It was data he's trying to interpret outside of what he generally interprets. So he did an experiment to try to give more context to it, but this is the thing. This is not his field. So he's sitting there saying, it is what it is. Where are you going to go with it? It is where it is. The battery information from his experiments vis-a-vis the battery information from that night are showing a very different rate drop in temperature. And he sees it, but there's nothing. What can you do? He's saying, this is true. This is accurate, but this is why experts normally stay in their lane. This expert could have just said, from the data, this is the phone battery temperature I pulled. This is what it represents. The Commonwealth could have brought in another expert to say, okay, well, given this phone data and temperature drops, can you explain to us how batteries respond? Someone has to study how batteries respond in temperature in the world where we have electric cars, because batteries don't respond the same in the heat as they do in the cold, says somebody who likes to play Pokemon Go in the summer. So there's probably someone who studies that and knows how batteries respond in different temperature conditions. I don't know. Cooling and heating seems to be important for various mechanical devices that have batteries. So yeah, there's probably a different expert. Did the Commonwealth do that? No. So the defense is going to use that to their advantage. And I think pretty effectively. Let me know, do you think that this cross-examination has been incredibly effective? I think it's been very effective. And for those of you that are like, will the jury even remember? It'll come back up with other witnesses and it'll come back up in closing. The lawyers have to lay the foundation for what they're going to argue in closing. And this has been just a very strategic poking of holes at the things the defense needs to poke holes at the most, and almost a solidifying of timeline. We need the timeline solidified so we can juxtapose it with something else, and we need to poke holes at this. Incredibly effective. And even if the jury's kind of like, okay, whatever, later on, the defense can say, remember how fast the battery dropped in the experiment? It didn't do that here. And that's when it becomes the most powerful, is when you can argue it.
Drop
very
in
effective
temperature
cross
in your test scenario 1 than what actually occurred on John O'Keefe's phone for the time period we just covered in January 29th.
Yes.
And then with regard to even test scenario 2, where the temperature is 33.8 degrees, that's the ambient, the outdoor temperature,
Correct.
right? At that temperature, just above freezing, you've got a...
Sorry, that's below freezing.
I'm sorry?
It's below freezing.
What is freezing in Fahrenheit?
I don't know, but it's 0 degrees Celsius.
Right.
And it was -5 degrees Celsius at the time.
Right, but would you agree that, and I want to be fair to you because I know you use Celsius more
What
than
point in time are we
Americans
talking
use
about?
Fahrenheit. But would you agree that
Also, I don't disagree with my teen who keeps arguing that metric is superior. He's like, right, shouldn't freezing be 0? I understand, but, sir.
2 degrees Fahrenheit is the freezing point in Fahrenheit?
I honestly wouldn't know.
Okay, fair enough.
Emily, you ranted about experts staying in their lane and then keep pausing over the most effective example of experts should stay in their lane. Just keep reading. Emily says experts should stay in their lane. And now Scotty doesn't know. Like, don't tell Scotty. This is not a... Stay in your lane. Stay in your lane. Why? This.
At that temperature,
This is why.
just above freezing, you've got a,
Sorry, that's below freezing.
I'm sorry,
It's below freezing.
what is freezing in Fahrenheit?
Don't know, but it's 0 degrees Celsius.
Right.
And it was -5 degrees Celsius at the time.
Right, but would you agree that, and I want to be fair to you because I know you use Celsius more
Yes.
than Americans who use Fahrenheit, but would you agree that 2 degrees Fahrenheit is the freezing point in Fahrenheit?
I honestly wouldn't know.
Okay, fair enough. So, in any event, in your experiment at 33,
Again, I don't think the point being made here is whether or not -5 is below freezing. -5 is below 0. That would be below freezing. The damaging answer is, I don't know. That's the damaging answer. It's not the fact that he's looking at Alessi going, actually, it's below freezing. And Alessi doesn't address that it's below freezing. He says, but do you know what it is in Fahrenheit? And the guy's like, well, the jury has it up on the thing. Again, I don't know is the problem. You guys are right. It is below freezing though. But the answer is the problem. Because he's the expert and he's like, IDK. Because he's outside of his lane. Who said he should write a blog about it?
0.8 degrees Fahrenheit, you're getting a drop in your experiment in 13 minutes of 30.6 degrees, right?
Correct.
I know we lost some of the punch of those questions because I kept pausing. However, Alessi
But
even
much less
took
drop
the expert
in
being
temperature
right to make him
on
look
slide
wrong.
deck 60 of the actual iPhone of
'Cause he's
John
like, I don't
O'Keefe
know.
on the morning of January 29th, correct?
Yes, correct.
Do you know what the temperature was in Canton in January 29th, 2022?
I do not know.
Don't you think that that would be an important piece of information in analyzing where the phone of John O'Keefe was on the morning of January 29th?
I didn't think it was.
So you
What?
didn't think it was important, even though you issued a report discussing the temperature of the iPhone, and you did 2 test scenarios, one in a freezer, one in an ambient temperature of slightly above 33 degrees, and you didn't think it important to take the final step
At least he's
to
honest.
see whether there was anything to be gained from that comparison to determine where that phone was located?
My testing proved that the battery temperature is affected by ambient temperature. My report shows the data that was on the device. I also don't know the condition that the phone was found in, whether it was in a case, whether it was in a pocket.
That's a fair
So,
point.
To me, the ambient
Shouldn't you know that,
temperature
though?
in Canton at the time wasn't particularly relevant. I just wanted to show what data the device had recorded.
That's fair.
The
However,
information that you create from your digital forensics
It's not gonna
analysis,
unwind it.
including everything that's in the slide in your report, including battery. You want that, sir?
something was going on in court that kind of made him giggle. Look, I appreciate his answer because he said, look, I just wanted to show, does ambient temperature affect battery temperature? Fine. Still outside the lane. And Alessi has pulled him further outside of his lane and said, but you did experiments. And he's like, I don't know the condition of the phone. It could have had a case. I don't know what kind of case. Was it in a pocket? Was it not? I don't know how it was found. So the ambient type of Canton doesn't matter. You would think you would want to know, though, and say, well, I know that the ambient temperature in Canton was this. However, I didn't consider it because not seeking the answer, I think, looks worse. You guys were saying that the Apple S-word device was activated. That's funny.
To show what data the device had recorded.
It's a fair answer, but I don't think it undoes the damage that
The
question did.
information that you create from your digital forensics analysis, including everything that's in the slide, in your report, including battery... Well said, sir.
I wish I knew what it said, but later. I'll
I'll
look
go
for it
back to
later.
the question.
We'll get to the meme of it all later.
In digital forensics, you work with law enforcement often, correct?
Correct.
And you work in law enforcement in investigating cases, do you not?
Yes.
And
He
so
was law
oftentimes,
enforcement.
the law enforcement is using your digital forensics information to help them solve cases, correct?
Correct.
You didn't suggest to anybody on law enforcement that they might want to take a look at this temperature information to assist in determining where this phone could have been by the temperature? You never raised that with them?
I did not.
And do you know whether any law enforcement person was aware that you had done all this temperature analysis?
That he wouldn't know.
It was in my report.
So you create a report as part of this case,
Yeah, not unless they give law enforcement the
and you deem the
report.
temperature important enough to do 2 test scenarios, important enough to put it in a slide presentation to this jury. Yet there's no discussion of that between you and any member of law enforcement as to what it means?
The details were provided in my report, and there was discussions, but it never came up as to say what was the temperature in Canton that night.
Oh, so there were discussions.
Not with law enforcement.
Oh, who were
As
the
part of my preparations for trial.
Oh, tell me about who you discussed this temperature
Brennan.
information with.
It was with Hank.
You're hesitating, and I can't hear you. Who did you discuss
with
it
Hank?
with? Excuse me?
With Mr. Brennan.
Attorney
Sorry,
Brennan?
yes.
You discussed temperature with...
He looked like he had a question as to what Brennan's last name was. He was like, Hank. Brennan? He looked like he wasn't sure what Brennan's last name was.
Prosecutor Brennan.
It was in my report.
It was in your report,
Does he call
but
everyone
you
by their
said
first
you
name?
discussed. Which is it?
It's in my report, and the discussion was that it is in my report.
He might just call everyone
I'm not
by
in
their
a
first
position
name.
to suggest that investigations take place and
That's fair.
change based on my report findings.
Oh,
That's
sir,
truly
I'm
not his
not
job.
suggesting what you just stated. I'm just trying to get information about, you mentioned the verb discussed. Didn't you, in your
Yes, I
answer
did.
moments ago?
Yes,
So you discussed.
Isn't discussed a verbal thing? It's not a written thing?
it was discussed in preparation for trial, yes.
Oh, so there was a discussion, a verbal discussion with
You just
Attorney
said
Brennan
that.
about temperature in your preparation for trial.
Yes.
Was there any interest at all as to what this could actually mean for the potential location of Mr. O'Keefe's phone on these very important time periods in January 29th
He
that
did.
might assist to determine at various times whether Mr. O'Keefe is in a covered building
That's so compound. He
based
did with
upon
Brennan.
the temperature rather than outside in a nor'easter on January 29th?
Still compound.
I'm sorry, what was the question now?
Yeah, the question is, was there any discussion about the investigative value of what you had done
No.
in
that's not his job.
determining where that phone could have been on key time periods on the morning of January 29th?
Unless he,
That-
what? I want you to be this mad about him not taking the temperature of the freezer. Did you tell law enforcement to go do their job? No. That's not his job. Don't get mad about the shit that's not his job. Get mad about the shit that is his job.
It wasn't part of the discussion, no.
It wasn't part of the discussion.
It's not his job.
We went through, you may recall in my questioning, in your report,
Alessi, don't overstep.
where you stated that it was possible that the phone could be
You made
inside
really
the
good
house
points,
at 34
Alessi.
Fairview based upon that big white circle. You testified that the low accuracy at certain points could be because of it entering a covered building, correct?
Correct.
And you do a temperature experiment
Yep.
to track the very accurate temperature change of an iPhone,
Experiment's a loose.
and it doesn't match up the actual data with either of your test scenarios, and you don't raise that with anybody. Objection.
Sustained. You can ask it differently.
And in pieces.
Did you ever
Unless he's on a roll.
put together in any kind of form your test scenario 1, your test scenario 2, and the actual temperature chart of the iPhone of Mr. O'Keefe?
So how do you mean put it together? As in compare the two?
Exactly. Compare the two and reach any conclusions about location, because
No,
you spent
'cause he's
time,
not
did
an
you not,
expert
sir?
in
A
that.
lot of time in your reports on location of the phone.
He was just trying to give context for
But yet,
information.
with all that data, all that testing, all the experiments,
I mean, even
that
if
you
he had
did,
done it, it wouldn't have been allowed to come
You
in.
didn't include in your slide presentation, and you didn't include in your report what that could mean for the location of the phone, did you, sir?
I'm struggling to see the comparison there.
Let me see if I can ask it in
This
a different
is not.
way.
I don't think this is the fist banging
Nowhere
point
in
of
your
this
slide
witness.
presentation did
But
you have any discussion
That's
yesterday
lawyer brain.
about how your test
Is
scenario...
this the point?
Did you bring up, by the way, in your slide presentation yesterday, your battery temperature at all? Your tests?
Not the tests, no.
Right, so you didn't even raise
He's like, they're in the
yesterday in your
report.
presentation about where the phone might be located. You didn't even raise the experiments that you did, correct?
They're in the
Sustained
report.
as to the terminology. Ask it differently.
Did you yesterday, in your presentation to the jury, in any way discuss your battery test scenario 1 and 2 in your March 2025 report?
I
don't know if he was
believe there was
asked.
mention of testing, but not to the amount of detail to say what the testing was.
Right. So there was no detail given at all
No
about
detail.
it. You just mentioned that it occurred, but no detail in your discussion
Correct.
at all. And are you aware, with regard to the battery temperature, that battery temperature in investigations can be used to determine locations of phones at certain times? Are you aware of that?
No.
So you have never used battery temperature information in all your years
That doesn't surprise me
in any
at
way
all.
for any investigation of a case in determining location of a phone?
Again, I don't see how you can determine location of a device from a temperature reading, other than to say whether it was inside or outside.
Alessi, you're gonna step on your cross, my dude.
Battery temperature
That's a fair answer.
and
You're going to give him enough
the
room.
chart that you gave.
If
that
you
it-
keep yelling at him about stuff that's not the big points, you're going to give him room where the jury's going to be like, why are you yelling at this dude? Like, what? We're going to get to the point that it's going to be too much.
is up there, in your
And we're
opinion,
gonna
has
lose
no relevancy
some of the good
to the
points.
topic of where a phone might be to investigators in a case? Is that what you're saying?
Is that what you're saying, Mr. Whiffin?
I'm saying I can't take a temperature reading and make a determination about a GPS location based on the temperature reading.
That's
That's
fair.
not my question, though,
Okay.
sir, and I appreciate your answer, though. My
That's fair.
question is, you work with law enforcement investigators regularly,
Yes.
correct?
But he
Isn't
doesn't
this
direct
information
investigation. He just answers
Of
questions.
potential relevance based upon your experience with investigations, isn't this information at least potentially relevant in investigations?
I believe it could be. That's why I included it in my report.
Thank you. But you didn't include a discussion of it in your testimony yesterday, correct?
Correct.
I appreciate that this expert does not back away from his answers. I really do. He has been, even when he knows the
I just want to
answers
be clear
are not ideal,
on a final
he's been very
point on as
clear,
regards temperature.
I think, in answering yes,
Were
no,
you
yes, no.
aware of the temperature in Canton on January 29th, 2022?
He said no.
I know it was a blizzard, but I don't know what the temperature was.
He said no.
May I have a moment to switch
Sure.
topics? Thank you, Your Honor. Thank you, Mr. Whiffin. I'll be right back.
It's just interesting that the points I thought were the biggest serves were not the points that Alessi was yelling at about. So we'll see. The jury might completely disagree with me. Alessi's in there looking at them, not me. I can't. We'll see. I think I didn't even want to know what the temperature was. I didn't take the temperature of the freezer. I think those things can go to reliability, depending on where the jury's at. I think it gives the defense a lot of room to argue. But I really appreciate that this witness is like, yes, it's this, no, it's that. And I think his answers have been really truthful, including, I didn't think it was important. I mean, you can sit there and be like, well, that's not going to look great, but he just clear. All right, let's keep going and see. I saw a couple of you guys ask, should Alessi quit when he's ahead? He still has another realm to go in. It's just the relative frustration of different points is
Your
a little
Honor,
confusing to me.
If I may, I have
That's all.
one last point to make with temperature. If we could put deck 60 back up, please. Mr. Whiffin, if you bear with me, I just have
course.
one final set of questions.
I think
you
Alessi's
look
done a
at
really
this
good job with the
chart,
temperature because the temperature data is difficult for the defense to deal with down the
And
road.
you, under January 29th at 12:13, battery temperature of 82 degrees. But you then go down, what I'd like to start with is 12:37 again. And this is a key time point, 12:37. You've got a temperature of 72 degrees. And then 8 minutes later, 8 minutes, the temperature only drops 6 degrees, correct?
Correct.
Again, using 1237 is what I refer to as the baseline. You go all the way down, and you see to 1253 a temperature drop of only 11 degrees. Do you see that?
I do.
Thank you. That you can. Excuse me, Your Honor. One moment.
Okay.
It's hard because I think Alessi has made really good points. It's interesting that the defendant wants to ask a question or wants a point made. Let's see what this next question is. I'm now dead curious. Because whatever
The final
comes,
data point on this slide.
Next
Mr.
is probably
Whiffin,
what
Thank you for bearing with me on this.
Karen wanted to ask.
At 136, there's a temperature of 50 degrees Fahrenheit, correct?
Correct.
Several hours later, at 6:06, 4.5 hours, the temperature drop is only 7 degrees, correct?
Correct.
Brennan's going to come back up and say, could the phone being underneath someone impact temperature? That's what he's going to come up and ask.
I'm switching. May I have a brief moment, Your Honor?
Okay.
Thank you.
Taylor in the chat popped in and said, Emily currently watching while, oh, no, that's what I was not doing. Watching while outlining for my last two finals of 1L. I thought about you yesterday while doing my crim law exam. Hopefully things that we've covered here are the real world examples that stick in your head while you're going through those exams. Congratulations at the end of 1L. We went and did karaoke the end of my 1L. There were champagne jello shots, which I didn't think was a thing, and it was great. And then there was way too much vanilla Stoli. But the end of 1L was a delight. It feels so good to be done with 1L. And then you need to sleep for like a week. The post
approach your
1L
honor?
crash is real.
May I have Exhibit
Haley said, good morning, EDB. It's my golden birthday today, turning 29 on the 29th. So excited. I know. I love a golden birthday. So excited to spend it with the law nerds. Thank you for all you do. Any advice to studying law being older than the average student? First of all, you are wise. So
What is Exhibit 42?
life experience matters.
Okay, thank you.
I
We've
think
got it.
bringing that
Thank you, Julie.
perspective is very helpful.
Yes.
There were people in my law school classes
42.
in their 40s. So I think it's an advantage that you have experience. And
Do you recognize Exhibit 42
you can
from
ignore
your
the bullshit that
March
swoops up law students
2025
sometimes.
report?
I do.
So that is my advice.
And sir, just take a fair time to
Last advice, if you have to study for anything, don't forget, your brain needs rest. Sleep more. Your brain will retain information better. Hydrate and move and eat well. You have to do those things. If you just study all the time, your brain will not work for you. It's like a pet. Treat your brain like a beloved pet. It needs good quality food, water, and rest. That is my best advice. Let's keep going.
familiarize yourself with the exhibit before I start asking you questions. They're going to be very brief.
The court
And I'm
reporter
going to be,
is
if you
doing
look what you
verbal
need to, but I'm going to be
stenography.
focusing on just
and the
under
mask thing.
detailed analysis communications on paragraph 3, on page 43.
We don't
the
take care of
top
Tamagotchis,
3 or 4 entries.
Okay.
Tell me when you're ready, sir.
Marley said we almost named our rescue dog Lally. If you do name a pet
thank
Lally,
you.
do you say, what if
Your
anything
Honor,
did
may
you
I
do to this
have,
plant?
43, which is in evidence public?
Yes.
Thank
What
you,
if
Your Honor.
anything happened here?
Mr. Wolf, please. And if you could enlarge, you don't need the text, so if we can just go to detailed analysis, communication, call history, and now if you
Can
could
we
just super
Go
enlarge
back to the screen.
the first few entries. Yes,
Can I?
that is great. So what I want to do is
If I do this
just
enough, maybe it'll
cover
work. Yay!
the information here. Whose phone is the subject of the entries on this chart?
This is John's phone.
And if we start with the first entry, reading left to right, 12:14:36, end time 12:15:20, incoming call from Jen McCabe. Duration 44
There was some emphasis
seconds.
on that.
You see that, sir?
I do.
You see, and is that a call that is answered?
Yes.
If you go to the next entry, 1847, just 12:18:47 to 12:19:23, outgoing call duration 36 seconds to Jen McCabe, duration 36 seconds. Do you see that, sir?
I do.
Is that a call that is answered?
Remember, everyone,
Difficult to say. That could be a outgoing
If you've
call that
seen
lasted
this
36
trial
seconds
before,
of ringing.
you know about
I
the
believe
Karen
it was
Reed
answered.
calls.
Well, how is
Everyone
it
who
that you can
hasn't
tell
seen
the
it
first
doesn't know
one
yet.
was answered,
The
but
jury
not the
doesn't know
second
yet.
one?
Because it's an incoming call.
Okay, fair enough. So if we go to the third entry, 12:29:44, 12:29:51, incoming call from Jen McCabe. You see that, sir?
I don't mean to interrupt. Could I ask about the display?
I wonder if he's going to ask about the display not being redacted. Well, it seems everyone in this case has rehomed their phone. Maybe they've rehomed their phone numbers too, but you know, law nerds don't see if those numbers are still live. We do not. We do. I hope that that's what's being asked about, but for those of you that have seen this trial before, you know how many phone calls there are from Karen Reed. I find it to be persuasive evidence. We'll talk about it when we get there. The jury doesn't know yet. So this is the first time in this testimony that the jury is seeing how many phone calls there are to John's phone from Karen Reed. They talked about it a little bit in opening, but not a ton. So let us continue. I saw some comments. Brennan didn't redact his exhibit. Brennan didn't use these as exhibits. These are defense exhibits. They are the expert's report that were given to the defense, and the defense put these in as exhibits, not Brennan, just to clarify. Not that I'm, just to clarify where we're at. This is a long sidebar. Like a long sidebar. All right. I wonder if they sent the jury to take a bathroom break. That's a long
Whenever
long
you're
sidebar.
ready, Mr. Lessie.
Thank you, Your Honor. May I approach, please?
Yes.
That was,
Okay.
yeah, I think they
So,
probably
Your Honor, I
took the
have a
morning break.
replacement Exhibit 42
when they sidebarred.
Redacted, obviously to replace Exhibit 42.
We're just gonna-
And it's per stipulation with Mr. Bright.
Zoom, zoom. Woo! Rio Regal said, and I hope I pronounced that properly, and if not, at least amuse you.
Thank you.
He doesn't back away or argue or minimize or mitigate. I appreciate that about this expert very much. It is
May I publish, Your Honor?
what I prefer from experts. Like, you did what you did, you said what you said. Just
And Mr. Wolf, if you could again please enlarge, we're going to be focusing on the top entry of the chart again.
MSS said, does anyone talk to anyone in this chat? Yes, all the time.
May I, Your
And
Honor?
in real life and not in real life. But there
Mr.
are,
Whiffin, we
you know,
had
over
started going
30,000
through the
people in the
top
chat.
three entries. The first one you had indicated was answered.
I wonder if the prosecution's walking up to complain about the exhibit not being redacted. Look, the exhibit is now redacted. So I appreciate that the prosecutor caught it. I think the damage is probably already done. Look, doxing people sucks. I don't know if Jen McCabe's already been doxed, but given everything that's going on in this case and the fact that people were trying to dox experts, it wouldn't shock me. Having to change your phone number sucks. Having your phone number leaked on the internet sucks. I wish we had an Incogni sponsor today. I've worked with them frequently and I love Incogni. Look, it can help get your info off the internet. We'll have to find our code from an older video. It sucks. It just sucks. And it is one of those things that there's not much you can do about except use things like Incogni. This happened in a couple cases we've seen where there's just not a mindfulness of redaction. And so I hope that, well, who knows? Maybe phone numbers have changed since 2022. One would hope. So it just sucks. I don't know if Karen Reed's changed her number. Who knows? But it is at least redacted now. They could have redacted out probably all the numbers with just the names in there and stipulated and said, we all agree that this is the phone number for Jen McCabe. It's fine. What does doxing mean? A couple of you asked, so I'm going to answer just real quick. Taking people's personal identifying information that is not public, even sometimes it might be found like deep in public records, and sharing it on the internet. Outing people's home phone numbers, outing people's cell phones, adding people's home addresses, stuff like that. Sometimes it can expand to nameless, faceless accounts and outing them as well. We can get into it more, but it sucks.
The second one you, as I understand it, could not tell. Is that correct?
Correct.
And then
The
the
defense-
third entry.
The defense is responsible for these redactions. Oh, no, yes, but I've worked with great companies like Incogni that have helped me get my info off the internet. But yeah. But this is a defense exhibit. The defense introduced this exhibit, so it is on them. The party putting the exhibit up, it is on them. So this was on the defense. And the prosecution called it out. I appreciate that they did.
Which is reading left to right, 12:29:44, end time.
And that's why it was a longer sidebar,
12:29:51.
because they needed time to redact it.
Incoming
That makes
call
sense.
duration 8 seconds from Jen McCabe.
Correct.
That's the third one. So because it's an
So,
incoming.
Mr. Lessie, we need to enlarge this.
Okay, Your Honor.
Doxing
Mr.
can be
Wolf,
illegal depending on the
Can you enlarge
circumstance.
that pursuant to the judge's order? Is that sufficient, Your Honor?
If you can make it as large as possible for the jurors, please, even if you have to do smaller segments.
I wonder if the jurors
If
are
we
just
have
like,
to, Mr. Wolf, knock off the final right-hand
wonder if the
column,
jurors are
that's
like, what?
insignificant. There you go.
All right, that's better. Okay, that's fine. Thank you.
May I, Your Honor?
Yes.
Thank you. So I want to now go to the last one for this Exhibit 42.
I mean, and yes, Chad, I know doxing.
Reading from left to right, 1220.
We'll have a whole conversation about it. But also, I know a lot of you are old enough when you like went to school, they gave you a book with everybody's like home address, parents' names, and phone numbers. I know. The world has changed.
2944, 122951, incoming call duration at seconds from Jen McCabe. Again, it restates duration 8 seconds.
Correct.
Given that it's an incoming call, you can conclude that that was answered, correct?
Correct.
The jury's
Now,
got the exhibits
if we
at
could,
the end
go back down.
when they are entered into
And
evidence.
focusing on
I don't
just
think they
the
get the
first
chalks.
three by way of example, Mr. Wolf, do just as Her Honor has requested, enlarge it as large as possible. Those three, after the first three, yep, starting there, just take the first three by way of example. All right. Mr. Whiffin, you should feel free to look at the hard copy Exhibit 42 if that's more helpful to you. But what I want to do is to focus on start time 12:33:35, reading across activity, incoming call, unanswered, and then to the right, Karen Reed. Do you see that, sir?
I do.
And do you see the same types of entries for 3409 and 3438?
I do.
And those calls are unanswered, correct?
Correct.
So in contrast to the, and now Mr. Walker, we can go back to the chart, trying to capture 6 and
Yes, Rick Springfield.
enlarge those ones last
The OG.
time. Thank you.
8675309.
So in the first one at 1436, and then skipping one to 2944, those are answered, but then starting, excuse me, at 3335
Brennan used the
and
timeline.
3409, those are unanswered, correct?
Correct.
You can take that down, Mr. Wolf. Thank you.
We didn't jump back. We are still covering the same testimony after the redaction, after the break. Alessi is picking up where he was, probably for flow. Tommy Two-Tone,
You have a
not
moment, Your Honor,
Rick
to
Springfield.
switch
Fair
topics.
enough. That's a really good reason to get that phone number. Like, that phone number's worth it for the lols. No, it's fine. We're all on the same page.
Mr. Whiffin, when did you start working on this case? What was the date, approximate date?
On this case or on this exhibit?
On this case?
Approximately September 2023.
So, over a year and a half.
Correct.
How many times have you been in
Daniela, we're
Norfolk
expecting court will
County?
be all day today. We'll see.
This is my second time.
So you were here once previously.
Correct.
Do you recall yesterday discussing what you had done with an iPhone, driving around and then moving it with your hand?
Correct. Yes.
In the year and a half that you've
For
been
everyone who heard that testimony yesterday about him driving around with the iPhone and seeing if it logged like step data, here's one of the things that would be very difficult for the jury, I think, or for some on the jury. Let me know if this is you, Chad. If you hear something that he says and you're like, that doesn't seem right, is the temptation to Google it? Because the jury can't do that. And if he's saying, oh, I drove around and it got step data, and you're sitting there going, could I hatch my eggs in Pokemon Go that way and get step data? How hard is it not to be like, let me just go drive and see if it has it? Like, maybe take some hills on the way home and just see if it's in my hand, if it registers step data. when they're talking about real world experiments and information you can get, like you can see your step data. You can't get to your battery temperature quite the same way, but you can see your step data. It is so hard, I would think, to be like, well, let me just do it. Jurors aren't allowed to just do it. They're not allowed to just do it. But even when they talk about I know last trial when they were talking about how fast the prosecution says that Karen Reed backed up, people got in their cars and were like, let me back up that fast. Fuck, that's fast. Like, it's hard not to do the real world experiments, I think, if you are a person that's like, I want to know. So I feel for the jurors in that they just can't.
On this,
Katie said, I got like 9,000 steps from Mission Space. Fair. I've never been on Mission Space. I get motion
case.
space.
Did you ever
My kids took it.
take an iPhone
But it's
and
hard.
do the same activity on the route that you were discussing yesterday between 34 Fairview and 1 Meadows?
I actually did it on Sunday night.
I'm sorry?
I did it 2 days ago.
I'm going to back up the question just because, well, I was distracted reading the chat.
Did you ever
So I backed that up.
take an iPhone and do the same activity on the route that you were discussing yesterday between 34 Fairview and 1 Meadows?
I actually did it on Sunday night.
I'm sorry?
I did it 2 days ago on Sunday night.
And with regard to
Oh,
your time on this case, what was the results of that?
unless he asked if he took the phone and did the experiments with the steps from Fairview to 1 Meadows, but, and you guys are saying 2 days ago, he probably wasn't in Massachusetts. He's in Canada. They're not going to fly him to Massachusetts to do that. And he's probably not going to pay to fly himself to Massachusetts just to do that. He didn't write a report on it. He did it just to see. We'll see where the answer goes, and I'll tell you if that's more of an issue or not. We'll just see where it goes. But he's not in Massachusetts, so that does not surprise me. But the route that they would have taken wasn't from Fairview to 1 Meadows at the relevant time. The route would have been the route from the Waterfall to 34 Fairview. And he had those hills that he put on the map where he showed those. That's not from 34 Fairview to 1 Meadows. So anyway, we'll see.
I object, Your Honor.
And Brennan objected to him saying what the results were.
Your time on this case, what was the results of that?
I object, Your Honor. I'll need to be heard briefly.
I'm sorry?
I object, I need to be heard briefly.
Okay. Come on over.
It should be the route he mapped. All right, back to sidebar. Emily, you should have just waited for the sidebar. I know. Keep reading. But now we can zoom. Interesting.
Yeah, Your Honor.
Yes.
Mr. Whiffin, I am now going to proceed to a different topic. Do you recall discussing
the court is not letting
the,
him go that way.
Google search?
And now the jury is left with, what were the results? Nothing.
How long to die in the cold?
Onto the Google search.
And you discussed that in your direct testimony, correct?
I did.
This will probably, I would imagine this is the last
You were
topic area.
a police officer for years before getting into the data forensic analysis of cell phones,
I think it's a
correct?
bad look on the
Correct.
You were a
prosecution.
response officer
I do.
of the South Yorkshire Police from 2004 to 2009.
Correct.
You continued policing with the Calgary Police, working patrol, correct?
Correct.
If I'm the
You work
jurors,
frequently with law
what am I assuming?
enforcement.
I do.
that
Indeed, law enforcement is the predominance of
the
your work,
prosecution
correct?
doesn't want me to know. That's probably what I'd assume, but I'm a lawyer, so it's hard
Probably
to
about 80% of the
put
work.
myself into
Yes.
that.
What percent?
About 80%.
80?
80.
We're not going to know the results.
Your work is used in investigations for law enforcement, correct?
Sometimes, yes.
In your area of work, you use and apply various forensic methods that are extracted, that data is extracted from a cell phone, correct?
Correct.
And you have various forensic methods to analyze that data, correct?
Correct.
And that data that you analyze
I feel like we're back
is
in the foundation of a
often
direct
used by law
examination.
enforcement in their investigations, right?
It can be, yes.
It can be, but it also is, from your experience, correct?
I'm sorry, are we talking about my actual analysis or analysis that's created by the tools that me and Cellebrite create?
Your analysis.
Okay, my analysis is typically used in investigations, yes.
So it's typically, your analysis is typically used by law enforcement.
On the cases I work, yes.
Right. And you know that is going to be the case oftentimes when you're doing your
Cellebrite's
analysis.
used by law
correct?
enforcement
Correct.
in almost every case that has a device. It is the go-to.
And forensic software is used to gain access to people's devices, correct?
Correct.
And those
Such as
devices
cell phones,
tell
right?
on you.
So, and there's something called an extraction process from a cell phone that you discussed in your direct testimony.
Yes.
Now, I'm not going to go into too much detail, but I want to cover,
Thank you.
because it would be covering old ground, but I want to cover some
Thank
of it.
you.
Okay.
It's important, is it not,
We are
that the extraction
repastrating
process on a
at this
cell
point.
phone be performed correctly.
It is, yes.
And that's so that the data that's extracted from a cell phone is complete, correct?
Correct.
So that the data is correct,
Correct.
and so that the data is reliable.
Correct.
And data forensic examiners and people in your area of work need to ensure that the extraction file has not been tampered with, correct?
Correct.
Because if an
Interesting.
extraction file has the possibility
I think I know
of
where this line of
tampering,
questioning is going, and I
then
like this use of
the
this witness. So I'm
information,
curious to
data
see if
from
it goes where I think it's going to
can
go.
be unreliable, correct?
Correct.
And there's a generally accepted methodology for how to perform an extraction of data from a cell phone, correct?
Typically, yes.
One of
This
the
is-
key ways
This is going to build on Alessi's cross of Trooper Garino, who extracted the phones. We haven't gotten all the way there yet because Trooper Garino hasn't finished his testimony yet, but we've started to see the questioning about how things are extracted. And I wonder if he's going to use this witness to explain what the right way to do it is, which he can do. You can make this expert your expert and be like, you know this shit. Tell me how this shit should happen. Tell me how it should happen when it's done right. Because the defense can't bring their experts till after the prosecution's case. So even if the defense has their experts that are going to say all this stuff, the jury needs to hear it before you raise the issue with the other witnesses. And this is a good way to get to how it should be done properly so that the jury understands when it's not done properly before we get to the defense case in chief. So this is making the expert kind of your own witness.
to determine whether the data extracted from a cell phone is valid and has integrity is to evaluate whether the extraction process created what is called a hash value, correct?
Correct.
And a synonym for a hash value is a hash signature, correct?
Correct.
And a hash value or hash signature, I'm just going to use hash value. Is that acceptable to you?
I'm fine with that.
Just
Thank
don't
you.
call it a hashtag.
So a hash value is
It's been here
a
for
unique
years.
and usually consists of a long string of numbers and letters that's generated from the data file from a cell phone using a computer algorithm, right?
Correct.
And one of the computer algorithms is Shaw SHA 256, right?
Correct.
And is it a fair analogy to state that a hash value can be thought of as fingerprint?
The judge
for a
sustained the
data file
objection about
from
the
a cell phone.
Yes.
results.
And is it also a rough analogy that a hash value can function like the seal on a milk container? In other words, if you open the milk container and the seal's broken, that the same analogy can be provided that if you don't have a valid hash value, then there is a question with regard to the contents of a cell phone, just as there might be concern about contents of a milk carton. Is that a fair general analogy?
Yeah, if the hash doesn't match, then something has changed in the data.
So if the hash doesn't match or you can't determine
It's a very
valid
simple
hash
way to say
file,
it.
it's sort of like opening up a milk container and that seal cap is off, correct?
Okay, I'll accept that.
Thank you.
Alessi, I don't think the jury needs the milk container analogy. If the hash doesn't match, something's been changed. Clear. It's really clear. Like, I get where you're going with the analogy, but if it doesn't match, something's changed. That's it. That's all. It has to match. Period.
Now, if a data file is altered in any way, the hash algorithm is going to produce a different letter in numeric string than the previous hash value for that same alleged data, correct?
Correct.
So that alpha numeric number is important because it can, if it's different, then it means something happened to that data, correct?
Correct.
And isn't it important for examiners, anybody in data forensics, to know whether or not the data they're looking at has a valid hash value?
Yup.
It would depend, in my opinion, on the origin of the data.
But you would agree that it's much better to have a valid hash value for data than not, correct?
I'd like to see the hash value match, yes.
You would like to see the hash value matching,
Yes.
correct? Now, once data from an iPhone is properly extracted and you get
The emphasis on
a hash
properly.
value, then the examiners of the data seek to pass and decode the data to try and make some sense of the data in a more user-friendly format so that a report can be created for investigators, correct?
Correct.
Leslie, can you tell me when you're going to pause and then I'll just start talking instead of thinking? If you're not at EDB, how do you hear court and talk at the same time without ever missing a
Do you
beat?
recall
ADHD.
preparing a report for the
I could also listen to an audiobook, read something else while doing a third thing and retain both of them. And I would regularly listen to music and movies in the background of my law school classes while listening to lectures. Like, half of my brain needs to be occupied by something else, which is why I can talk, read the chat, and watch this at the same time. ADHD. It's ADHD. It's just the way my brain is wired. And if I'm not doing all those things at once, I'll probably fall asleep.
iPhone belonging to Jen McCabe, dated December 20.
Yeah, I can't do one thing at a time.
I do, yes.
It's too slow. They also are talking too slow for me, which is tough. Because, yep.
And
Nita said, not me using Emily's background
that
noise while I'm writing my
report,
thesis. Get that
you
thesis.
discussed your views of a Google search of House Long to Die in the Cold, correct?
Correct.
And in that report, you rendered various conclusions about that Google search, correct?
Correct.
And you rendered various conclusions about what is called a timestamp.
Correct.
And the timestamp that was in question was 2:27:40 a.m. on January 29th.
Tez, it is fair.
on
It's
Jen
technically split
McCabe's phone,
attention.
correct?
Correct.
The squirrel
And
needs
the
something to do.
question that you were looking at is that timestamp they appeared in the data, that timestamp of 2:20.
27. 227.
7:40 a.m.,
227.
whether that belongs to the Google search, "How long to die in the cold," correct?
Correct.
And you testified yesterday with regard to that very issue, correct?
Correct.
Now, in your report of December 2024, you discussed the hash value of that cell phone, correct?
I believe so, yes.
Yesterday, in your direct testimony, you didn't mention anything about the hash value with regard to Jen McCabe's phone, did you?
I don't think he was asked.
Not in my testimony, no.
The answer is no, correct? However,
I
isn't
think it's
it
fair that he didn't say
correct
nobody asked me, but
that in your report
I don't
of
think he was
December 2024,
okay.
you had an issue with the hash value from the data from that phone?
I didn't have an issue with the hash value at all, no.
So you didn't note that it was not possible with the gray key extraction as the PDF containing the extraction hash value that it was unsigned? That was not an issue in your report?
The hash value matches, but because I didn't do the extraction, I'm unable to actually validate that was an original hash and hadn't been modified.
Exactly. So you...
He's like, right. It's a deeper answer than that, which I appreciate that he's like, no, I didn't have a problem with the hash. I had this other bigger problem.
You didn't do
Fair.
the extraction, but you couldn't validate the hash value, could you?
No.
So you couldn't determine whether or not
He's like, obviously, I
any
just said
of
that.
the data on that cell phone of Jen McCabe had been tampered with, correct?
I take a holistic view of the data and try to find anomalies and didn't see any that raised any flags.
That wasn't my question, sir.
Okay.
I'll try it a different way. You concluded
I appreciate how he answers. I
That
really do.
the
Some of the
hash
experiment
value
shit was wild.
was unsigned, correct?
Correct. They were always unsigned. Okay, apologies.
You concluded that the hash value was unsigned, correct?
Correct.
Thank you. And you went on,
Now he
did
wants
you
to
not,
explain.
in your report
I was just
to
complimenting
say
you,
that
sir.
this hash value could be used as a suggestion of authentication, but cannot be guaranteed 100%, correct?
Correct.
Did you discuss any of that doubt, that suggestion of authentication but can't be guaranteed 100% at all in your direct testimony yesterday?
I didn't know.
And again, hash values are very important concepts for data forensic examiners, correct?
For integrity, yes.
I just wonder if he would ever say it's 100% if he didn't do the extraction
Do you know
himself.
the chain of custody of Jen McCabe's iPhone?
I don't know.
Does anyone?
So you don't know the chain of custody of her iPhone.
Alessi, I don't think it can be known. I really don't. He's like, you don't know the chain of custody? No, I don't think anyone does.
You have an unsigned hash value and you can't guarantee the hash value authentication, correct?
No.
The objection's overruled.
Not from the hash value, no.
The thing is, the defense has to tread carefully with this because if all the shit from Jen McCabe's phone looks like it's corrupted, then doesn't that include the search? So it's got to be a bit more precise because they want to argue that there are things in Jen McCabe's phone that are accurate, like that Google search, like the fact that Cellebrite showed it was deleted, etc. So there's a line between, okay, well, we can't trust any of it, but trust this part. I'm interested to see how that plays out. It's the same with this witness, right? You can't skewer this witness if you want to use him for the timeline. You've got to point out the things that are issues for you while not just making it so the jury does not credit anything this witness says. I don't think the defense wants everything this witness says discredited. They want that timeline.
Go back to the 227.
They want those
timestamp.
circles of where John O'Keefe's phone could be.
And the question of
But
whether
they want to
that
question this.
timestamp is associated with a Google search, house long to die in the cold. You understand there is a dispute as to whether that
We know.
search was performed at 2:27:40 a.m. as the timestamp states, or whether that was performed later in the morning, say around 6:23 a.m., correct?
Correct.
You understand there's a dispute.
Yes.
And do you understand that the defense asserts that that timestamp means what it says, the Google search occurred at 2:27:40 a.m.?
I'm going to allow it. Do you understand that?
I do.
I didn't hear your answer, sir.
I understand.
You understand that?
Yes.
So there are various data forensic tools, are there not, to
Yes.
evaluate what is called an artifact, this timestamp, correct?
Correct.
And those data forensic tools include Cellebrite tools, your company's tools?
Yes.
And some of those Cellebrite tools are called Physical Analyzer.
Correct.
And then you have another tool, I believe, called Insights.
Insights is a suite that includes Physical Analyzer, but yes.
So it's Insights is a
It's
suite.
essentially the same
suite
tool.
of tools.
Essentially the same tool. So there's Insight, well, essentially, but they're two different tools, correct?
The
It's a
two
suite
different
of
versions
tools.
of the same tool.
Thank you. Two different versions of the same tool.
Yes.
But there are other tools from other companies, are there not, sir?
There are.
And a competitor of Cellebrite that can be used to analyze that 2:27:40 a.m. timestamp and to potentially resolve that dispute of whether the Google search "house long to die in the cold" occurred at 2:27:40 a.m. or later at 6:23 or so a.m.
I think the other tools overlie
There's other
Cellebrite,
companies
though.
and tools that can be used for that, correct?
Correct.
And isn't one of the companies that can be used a competitor of Cellebrite called Magnet Forensics?
Correct.
And they have a tool called Axiom, A-X-I-O-M, that evaluates questions such as this, correct?
They do.
And is Magnet Forensics a reputable company?
They are.
Am I correct that yesterday you essentially said that as of today, no Cellebrite tool, no Insight suite such as Physical Analyzer, today shows that 2:27:40 a.m. timestamp?
Correct. If you use any version from the last approximately year, that timestamp won't show up.
It won't show up as you sit here today.
Correct.
But that's not always been the case
Correct.
with regard to Cellebrite forensic tools.
I'm
correct?
curious to
Correct.
see how this
As
goes.
a matter of fact, in the first proceeding in this case, in June of 2024, when you testified under oath, the situation with the forensic tools was Cellebrite Forensics Insights did not show the 2:27:40 a.m. timestamp, but another version of Physical Analyzer did show it, correct?
Correct.
Chad, I'm not going to spoil what's coming.
Program, that second
I know. Y'all want to know. It's coming. Don't worry. He's going to answer it. Don't worry. Don't worry. He's going to
tool,
answer it.
Physical analyzer not only showed it at 2:27:40 a.m., but it showed it as a deleted state, correct?
It's a deleted record, yes.
A deleted record.
Yes.
Did you mention that yesterday in your direct testimony?
I don't believe so.
You don't believe so?
No, we
I think he
changed it
did.
since then.
Exactly. You changed it since then.
Yes.
Your company removed it
Yes.
after the first trial.
Before the first trial.
Alessi. Oh, Alessi, that's not going to go well with the court. Dude, Alessi, bruh, no, I know. Well, the shit's out of the horse on that. The court's not going to be thrilled because when the experts do it, the court's not going to be thrilled when the civilians do it. It's a different slip. That's not great. I wonder if the defense is going to put up that report and show it to him. The jury is not supposed to know about the first trial. It is a problem. And why is it bad? Because the jury is not told about a first trial. They are not supposed to mention it. It is supposed to be the prior proceeding. It is not supposed to be mentioned as a first trial. Other witnesses, it slipped. It's worse when the lawyer does it. First proceeding is what it's supposed to be. If the Commonwealth had done it, the defense would probably ask for a mistrial. The Commonwealth's probably not going to do that. I don't know if the Commonwealth will make it an issue or not, or if they'll bring it up at sidebar. We'll see. It might not. If I was the prosecution, I wouldn't call for a sidebar now because then you just Streisand affect it. But I'm wondering if the defense is going to bring up that report and show it to the jury. So.
Moved it
Yes.
after the first trial.
Yeah, that's
Before the first trial.
Well, you removed it from one tool before the first trial, but you didn't remove it from the other physical analyzer program, did you?
Up until the following version was released.
No, I'm talking about the time of trial when you were testifying.
I appreciate that. There's some complexities with how we released the software, which resulted in one being released several weeks later and one being released several weeks earlier.
At the time of trial,
Yes.
last year in June, when you were testifying under oath, one of the Cellebrite tools showed the timestamp of 2:27:40 a.m., correct?
Correct.
Yeah, the other lawyers have said previous proceeding very clearly.
But that timestamp doesn't exist anymore. It doesn't exist today, does it?
Correct.
Cellebrite removed it.
Yes.
You mentioned...
Could I see counsel at sidebar for just a minute, please?
Did you hear Alessi?
Sidebar for just a minute.
You mentioned...
Could I see counsel at sidebar for just a minute, please?
Yes, Your Honor. Prosecution did not ask for that. That was sua sponte from the court. The court is not going to be happy with that. Again, when like Carrie said it, it was like the first proceeding. It was like the last trial, it was kind of quickly in there. It's different than a lawyer standing at the podium saying, last trial under oath, you did this. It's different when kind of muddled in with other things. Let's zoom past this sidebar. We're going to get to how Cellebrite changed, I think.
Go ahead, Mr. Leslie.
Thank you, Your Honor. So with regard to the first proceeding,
Did the judge just tell him, you better fucking not? Not in those words. But we know it now because the judge called him up to sidebar on her own motion because it is different when the lawyer says it. The shit's out of the horse now. The jury's not stupid. They've heard it. They're going to be told not to speculate it about prior proceedings. But when he comes up and says, at the prior proceeding, it's not great. And there are times when jurors think that the defense is trying to get one over on them. They are skeptical of that. And if the jury thinks that it feels slimy, it's not going to go well. So, and then he has to get back up there and correct him. The jury knows. It's different when the lawyer says it. I have not heard Brennan say first trial in front of the jury. It's going to depend on the jury. Look, we like Alessi. We've seen him in pretrial motions. We've seen him do other stuff. It's how the jury feels coming into this thing 5 days ago. But it's not great. And it was full-throated. It wasn't muddled in with other testimony. Why didn't Brennan object? Because it highlights it. Because it just highlights it. And sometimes when shit goes real wrong in court, you don't want to highlight it. But Brennan hasn't said it, neither of any of the other lawyers. All of the other lawyers have said prior proceeding or last time. Witnesses have said it. It's worse when counsel says it, which is why the court pulled him up to sidebar and said, do not let that come out of your mouth again. No, the jury will notice.
Go ahead, Mr. Alessi.
Thank you, Your Honor.
Because now he has to correct it.
With regard to the first proceeding, there was one Cellebrite forensic tool that still showed the 2:27:40 a.m. timestamp,
Correct.
and it was shown in a deleted state.
The record was deleted, yes.
The record was deleted. And then after that, Cellebrite outright removed the timestamp from so none of its programs had it. Correct?
That's the point.
Again, if I could explain a little bit about how it works.
No, you
I'm
can't.
sorry.
Okay.
If you could just respond
That's for redirect.
to my question. Is that correct?
The timestamp's been removed, yes.
However, the competitor of Cellebrite.
Jurors did not get asked if they had seen the original trial. They got asked if they'd seen anything about this case or heard anything about this case. And some of the jurors had heard about this case, but you don't know exactly what they've heard. We don't know because that would have been questioned at sidebar. But there's no question left for the jury. So the problem is you can't tell the jury what happened at the first proceeding and the first trial. And you don't want the jury to assume that, well, you don't know what they're going to assume, and you don't want that assumption to count against the defendant. So that's part of why they are not told. We can get into the technicalities of that later, but
We just talked about
jurors are not told about a
axiom.
prior trial.
Yes.
They know about prior proceedings.
That program
That is it.
at the first proceeding showed the 2:27:40
She does not
a.m.
look happy.
timestamp, correct?
Correct.
And as a matter of fact, as you
She
sit
handled
here
it
today,
patiently. Some
the
judges would have
magnet
yelled at him in front of the
forensics
jury.
Program Axiom still shows the 2:27:04 a.m. timestamp, correct?
As far as I know, yes.
No, some judges
And
would have yelled at
Magnet
him in front of the
Forensic
jury.
Axiom is a reputable company, correct?
Correct.
Other times she doesn't look mad like that.
Cellebrite removed that 2:27:40 a.m. timestamp, which is in a deleted state, in response to issues raised in the first proceeding, correct?
It was changed because of the research that I did, and that was verified by the forensic research group.
But the issue arose because of what had come up in the first proceeding, correct?
In the first investigation prior
Before
to the
that.
proceeding, yes.
In the first investigation in this case, correct?
Yes.
So Cellebrite, after the first proceeding, after the investigation, just outright went and removed the timestamp.
It's not unusual to change
I
decoding.
didn't ask if it, I just asked whether
Yep,
they
we
removed
removed it.
But Magnet Forensic Axiom still shows that 2:27:40 a.m. timestamp, right?
Again, they refer to it differently, which is why they can
But
do
they
that.
still show it.
They do still show it.
Can you just finish the answer?
So,
Sorry. Just let him finish the answer. Is that what you said, Mr. Mayor?
yeah, my apologies, but I'm having trouble hearing, but I'll pause more just to make sure you're done.
Ask him to speak up then, Alessi. If you can't, just ask him to speak up. I didn't think
And that
Alessi was
2:27:40 a.m.
cutting him off.
timestamp, the dispute is whether it's associated with the search, House Long to Die in the Cold, correct?
Correct.
talk a little bit more about the first proceeding in this case. In terms of your testimony under oath in that first proceeding, do you recall stating that it was your opinion as to whether that 2:27:40 a.m. timestamp was associated or not with the Google search, "House Long to Die in the Cold"?
Experts could
Believe so.
opinions.
Right, so you called it your opinion.
Yes, probably.
You didn't describe it as a fact, you described it as your opinion, correct?
Correct.
Oh, Alessi.
Because you realize that there are other fair interpretations of that timestamp and when the Google search occurred, correct?
No expert in this case is going to come up here and say that's a fact, period. Every expert is going to say it is my expert opinion that XYZ. Every single one.
I think even if I believe it's a fact, it's my opinion.
Right, so it's your opinion.
Yes.
So you
Well, the jury knows about the first trial now.
also
Other
do you
witnesses have
recall
said it,
stating that there's
and it kinda
plenty of
glossed
other
over.
evidence on that extraction
No getting around it
that
today.
shows what activity was occurring at 2:27:40. You recall that?
Correct.
And you used the word evidence, correct?
Correct.
But that evidence on the Cellebrite program is now gone, correct?
No,
It's not gone?
it's not gone.
So the 2:27:40 timestamp still exists in Cellebrite programs?
Yes, it's shown differently.
Sorry, are we talking about the additional evidence
understanding.
that shows what
Well,
happened at 2:27:40?
No, I'm just asking whether.
Okay.
I thought we had that clear, but I thought, is the 2:27:40 a.m. timestamp show up on any Cellebrite program as you sit here today?
The decoded value does not show a timestamp for
Thank you.
that artifact.
It's,
Sir,
Sarah, because it's worse
does
when the
your
lawyer
work-
does it. Witnesses slipping is one thing. The lawyers know. It is a very different matter when the lawyers are standing up there asking the questions and they're the ones saying stuff in court they shouldn't say. That's why it's different. The others were witnesses saying it and it kind of got scooted past and the lawyers redirected them. Especially Jackson, he was like, so at the first proceeding and brought the witnesses back from stopping saying trial. It's worse when the lawyers do it.
Work include shaping how examiners will see the data when they open it.
Yes.
So you shape how the data
That's
is
a
going
good
to be.
question.
Correct?
Yes, we have
Yes?
ways to create the data so it's usable. Yes.
So the answer is
shape it.
yes,
Yes.
you shape the data.
Yes.
Right.
These various forensic tools, Cellebrite, Insight Suite, including Physical Analyzer, Magnetic Forensics Axiom, these are all tools, and we know that no one has access to the Apple source code on iPhones, correct?
Correct.
And the best source of information about what may be happening inside of an Apple iPhone would be if one could get the source code and look into the source codes to see what's actually happening, correct?
Correct.
So what happens is, in data forensics, because Apple considers it proprietary,
Yep.
and people can't access the source code, there's these various data forensic tools that in some ways try to serve as a surrogate, given the fact that there's no access to source code, correct?
Correct. That's fair.
So the best information would come from the Apple source code, but nobody has access to that, or few people do.
Therefore, these other forensic tools are used.
Correct.
So sometimes examiners have to give opinions like you give because you don't have access to the source code, correct?
But you were just saying.
So it's your opinion oftentimes
So?
with regard to ultimate conclusion.
Based on research and testing. But yes,
Not
it's an opinion.
100% absolute certainty because you don't have access to the source code, correct?
Correct.
Every expert that testifies in this case will say it's my opinion that. None of them will say it's a fact that XYZ. But there were so many good points made earlier in Cross. We have now gotten very far afield. And we haven't gotten too much
Your Honor, to
into the
switch topics,
227
Thank you.
timestamp, and I'm surprised we haven't gotten more into that. Because now we are wandering a bit. Stephanie Loop said, grew the baby watching this trial the first time. Now she's watching it with me. I hope with
Before I do switch,
Lots of
topics,
happy naps.
a couple points on the
we
22740 timestamp, if I may, Mr. Whiffin. The Google search in question associated with that timestamp, the dispute over that, is house long to die in the cold, correct?
Correct.
And you understand, sir, do you understand the significance if Jen McCabe made that Google search, house long to die in the cold, at 2:27:40 a.m. instead of 6:23 a.m.? Do you understand the significance of that?
Of course.
Sustained.
well, he answered
He
it.
said yes, Your Honor.
I'm sorry?
Oh
I
shit.
said sustained.
Oh, thank you, Your Honor. I didn't hear that.
Jurors, strike any answer that may have.
Right. So Alessi is,
What do you
At that point,
understand to be the
if you are ever in court, at that point, it might be fair for Alessi to say, can I turn off the fan behind me? Because I cannot hear.
significance of the dispute over 2:27:40 timestamp?
Sustained.
Mr. Whiffin, with regard to the 2:27:40 a.m. timestamp, have you looked at any forensic tools to answer that question other than Cellebrite tools and your tool Ardex?
I've used Axiom as well.
So you used Axiom, and so did you therefore see that 2:27:40 a.m. timestamp
Well, when did he use it?
still appeared?
Yes.
Did you discuss that with the jury yesterday, that you analyzed the Axiom program and that 2:27:40 a.m. timestamp
Oh, he's
still
opening
appears?
up a whole
I
door
didn't,
to
no.
talk about
You did
this
not.
and
I did not.
redirect. Because Axiom shows it differently. I imagine they'll get into it now.
Could we please, with the court's permission, put the PowerPoint presentation back up and go to deck 26? Mr. Whiffin, does an iPhone discriminate
Christy asks,
between
what, if anything,
whether
is a chain of
it's in
custody?
a car,
I mean,
bus, a bicycle?
the jury's going to hear
or
more about it.
walking?
It
Much more.
can, but I don't have the research on that.
Right. So as you sit here today, you can't say that an iPhone can tell the difference between a car, bus, bicycle, or walking, correct?
The iPhone can, but I haven't researched that data fully enough to understand it forensically.
So as you
I
sit here,
can't, but
you
the phone
can't.
can.
Does an iPhone merely register movement? Let me rephrase that. Does an iPhone register movement?
It does.
Do you recall yesterday discussing movement at a speed of about 1.4 miles per hour at 12:24:37 a.m. on
Yes.
January 29th, 2022?
I do.
Finish the question.
A person walking at a normal to even a slow pace can walk at approximately 1.4 miles per hour. Is that correct?
It sounds reasonable.
And does it sound reasonable that a normal speed of walking is between 2 and 4 miles per hour?
Reasonable.
Interesting. We are still on cross. No one has asked about crash detection or fall detection on the iPhone.
Switching topics, Your Honor, if I could have a moment.
You don't have to tell the court you're switching topics. You truly don't have to
You can take that. Okay, thank
tell
you.
the court that you're switching topics. Miss Krista said, Emily, I think your son has your eyes when he looked into the camera yesterday. He looked just like you. There are definitely times T looks a bit like me. Let's see. I'm going to try to get to some questions as I'm looking for them. Artemis said, question, his report 11 degrees Celsius or 11 Fahrenheit. He had both Celsius and Fahrenheit. At that point of the questioning, it wasn't up on screen, so I'm not 100% sure which he was referring to, but his report had both on there. To all of our new members, welcome. Enjoy not being on slow mode because we do have to keep the chat on slow mode. Otherwise, well, I can't see it. And it makes
When
it
you
hard
were
for y'all.
examining Jennifer
Ruru said, I play
McCabe's
Pokemon Go in the summer. I have to use a phone cooler. Yeah, it's a real
phone.
problem.
You used an operating
Overheating
system
during raids is
called
the worst.
iOS 14, correct?
That's one of the versions of iOS I used, yes.
That was one of the versions.
Yes.
Do you understand that Jen McCabe's phone was actually using iOS version 15?
Yes, I do. 15.2.1.
He's like, yes.
2.1.
Thank you. And do you recall,
He's like, that I know clearly.
recall saying, with regard to iOS 15.1, etc., that
15.2.1?
the iOS operating system, your words, had fundamentally changed, correct?
Correct.
Now, with regard to, we're back to Jen McCabe's phone, we're back to 2740, the issue of deletions. You stated yesterday that that deletion occurred after January 31 of 2022, is that correct?
Correct.
But you couldn't determine how that deletion occurred with certainty, correct?
Correct.
And he couldn't replicate it,
And you
which
gave
is
three
notable.
possibilities that you analyzed.
Not
correct?
being able to replicate
Three or
it was
four, yes.
notable.
3 or 4. And one of them was deleted by user, correct?
Correct.
Another one was that the search occurred but never loaded.
That would be the reason that there was no data found in the history.db file.
But that was another of the 3 or 4 reasons, correct?
That wouldn't cause the deletion of the record
Right, but-
necessarily.
Right. And then you...
Damn it, I cut it off.
You discussed those possibilities,
We're going to get a lot of use
but
out of
you
that this trial.
can't state
Not mad about it.
with certainty how that deletion occurred, can you?
Correct.
You have doubts about how it occurred, is that fair?
Yeah, I have an idea how it occurred, but I can't
You
prove
had,
it.
I'm sorry. I didn't,
Yeah, it's okay.
No, please finish. I
He's
want
not
to
going
make
to
sure.
say
I
doubt.
have an idea of how it occurred, but I've not been able to replicate it.
He's like,
so
I'm not gonna
my idea
speculate.
is unsubstantiated.
Right,
So,
unsubstantiated.
is it fair to say you have some doubts
Yes.
about how the deletion occurs?
That's fair.
And you believe your doubt is reasonable
Yes.
under the circumstances?
Yes.
for everyone asking about this soundbite.
That's my opinion!
Real Housewives of Orange County reunion. Iconic. I can't replicate it. It was a whole moment, but it was a Real Housewives of Orange County reunion. That's Tamara Judd. So it was very fair in the moment. Absolutely felt
Your Honor,
felt
that
it.
is the extent of my questions.
Oh, we're
of the
done.
witness at this time.
Not today, Judge.
Oh wait, wrong one.
Thank you.
Yay! Look, man, I like Cross, but there were some really strong points of that Cross in the middle, and then the end just fizzled. It just, and I think we're going to see a redirect that allows him to explain. I think some really good points were made, but I don't think the end of that Cross was as strong. Interested to see if he has this expert explain Axiom and what's in the Axiom report. Oh, I absolutely caught the reasonable doubt thing. I just think so you doubt how the deletion occurred? Okay. He said that indirect. I don't think it was the biggest point that he could make. So.
Good afternoon.
Good afternoon.
Again, I think there were other parts
As
of
a
that cross that were more
forensic
powerful.
analyst,
I like it. I
you
like
study data?
I
Alessi.
do.
You consider it a science.
I do.
Are you a criminal investigator like a police officer in your present role?
Not anymore.
Are you a detective in your present role helping aid one side or another in
And
an
redirect.
investigation?
I'm not, no.
At some point, you and I spoke about reviewing phones.
We did.
You had begun your whole process in some of this work before you had met me.
Correct.
And I'd asked you to look at Mr. O'Keefe's phone.
Correct?
Did I ever tell you what you should look for?
No.
Did I ever tell you what I wanted to see or what I wanted the results to be?
No.
Did I ever share with you parts of the investigation that had nothing to do with your actual data analysis?
No.
Right, which is
Would it be
proper.
inappropriate or not helpful for an advocate to provide you information that might taint or influence your thinking when you're looking at data in a case?
100% it would be problematic.
When I asked you to look at data in this case, did I ever express any opinion whatsoever that I cared, one way or another, what your results would find?
No.
Did I
Those are
ever
good
attempt
questions.
to shape or influence your process by offering you
That was
information that
intentional.
had nothing to do with your assessment of data?
No.
And so as a scientist, what a legal investigator or an advocate for either side thinks, is that relevant to you?
No.
The data is the data?
The data is the data. I can explain my opinions on the data.
The science is the science?
The science is the science.
That's sustained. Watch the form.
Now, counsel showed you some parts of your report regarding John O'Keefe's cell phone, didn't he?
Yes.
You saw select pages from that report,
Correct.
a few pages you were asked about.
Yes.
I also imagine this is how redirect's going to go when the defense gets their experts up there and says, did I tell you to look at this? Did I tell you to look at that? Did I tell you which way to go? Or did I say, take a look at this, tell me what you find? It's going to be the same with all of the experts.
But you wrote an entire report, didn't you?
I did.
And do you think that your entire report puts into perspective some of those select pages that you were shown?
Definitely, yes.
You know, I move to introduce Mr. Whiffin's entire report.
Okay.
They had to know that was coming. There's no way that the defense thought that the Commonwealth stipulated to putting in just a few pages of Whiffin's report without asking for completeness. The judge is going to allow that. His question was, do you think the rest of your report adds context to the select pages you were shown? Reports don't always come into evidence, but the Commonwealth stipulated, the defense asked for it. Yeah, we agree, you can have the report. Now they're going to say, give us the whole report. They wouldn't have put it in otherwise, but now they're not going to keep it out. You had to know that was coming. You know that was coming. Reports generally are not evidence. reports are generally the foundation for the testimony in court. I think the whole thing's going to come in.
Do you still have your report with you, Mr. Whiffin?
I do, yes.
Okay.
Let's start with questions that counsel asked
There
you
we go.
about the battery. When you were trying to determine how the battery worked, you shared with the jury that you did certain testing.
Correct.
What was the purpose of that testing?
To make sure that the battery temperature sensor would be affected by environmental temperatures, such as being in the freezer, such as being outside, being brought back indoors, and to make sure that the fall and rise of the temperature sensor, at least the pattern would match the expected pattern and would match the thermometer that was alongside it.
Was there a thermometer in the freezer?
When you put the batteries or the phone
Couldn't help
in the
myself.
freezers, did it matter what the temperature of the freezer was when you put it in it?
I didn't believe it did.
What was the purpose again of putting it in the freezer?
Just to remove the device from a warm environment, which was outside of the freezer, placing it inside the cold environment of the freezer and just seeing how the temperature dropped.
As you mentioned, you look at data through science, correct?
Correct.
And so, did anybody ever share with you the important points of the decrease in temperature of the cell phone battery to try to influence your results?
Objection, Your Honor.
I'm sorry, could you
Did
rephrase?
anybody
I
try
don't know if
to
we can.
tell you important points of the evening on January 29th, 2022 in an attempt to influence your
I think
studies
he could
on the
have said
fact that a
contested
battery
points.
or a phone, when it gets colder, the battery temperature decreases?
No.
So when you developed the graph of the battery temperature and you followed the progress of that temperature declining through the night, was there any other scope or focus of yours other than to simply track the data?
Just tracking the data.
Similarly, when you looked at healthcare data, were you asked to try to see if the healthcare data could fit a certain theory or argument?
No, I was not.
You were looking at the healthcare data. Were you looking at it independently?
I was.
Now, it's not your opinion, or you're not taking a position.
It's not what?
The meaning of that data matching up is, are you?
No.
No one's asked you to give an opinion about the coordination of data, have they?
I know,
So
healthcare
if
again.
the data just
I know.
coordinates on its own, that has nothing to do with your opinion.
Objection, Your Honor.
That's argumentative. Yeah, the form is argumentative.
You mentioned when you put a cell phone in a colder environment, like a freezer, you noted that the temperature goes.
When she says sustained as to form, it means the question is formed improperly. There's a number of different ways to form a direct question or a leading question. And so sustained as to form means the form of your question is wrong, which is indicating, you know, oftentimes you would have the defense object with the grounds, and the grounds would be the form of the question. And because the judge doesn't allow grounds, she is responding, yes, I am sustaining that objection based on the form of the question,
Goes down.
the way it is
Correct.
asked,
Do your
not
studies
what is
also
asked.
show that when the cell phone is taken out of a certain temperature and put in an increased temperature, the cell phone battery temperature goes up?
It does.
That's my cell phone. Speaking of
Do you
cell phones,
have available for the screen the battery graph that we had on your PowerPoint?
I do. 2 seconds.
If you could go back one to where it's just the chart, please. And if you could enlarge it, we'll start near the top.
2 seconds.
I was looking at chat in the stream and on my text, and Dr. B's like, do you want me to bring you
At
Starbucks? And I'm like, yeah.
12:20:43 on January
Yup.
28, 2023. The battery temperature is 77 degrees.
I'm sorry, that's 8:43 p.m.
That's
all right?
8:43 p.m.?
Yes, the first record.
77 degrees?
Yes.
And if we look down to the last box on January 28, 2023,
Yes.
so at 23:28, that's 12:23:28?
Okay?
Okay, they're approaching. Give me 1 second because I am. Well, they are approaching. I am. Well, getting egg bites. And once I do that, then we can chitty chat a bit more. Actually, I'm gonna zoom. So thanks, Dr. B, for bringing me treats. We are going to need treats today. We have a whole lot with this witness today. It's just
Gonna
been
ask,
much. I'll ask Dr. B to pick up enough for the class.
Mr. Whiffin, I'm going to ask you to start at 12:13 on January 29th, 2022. Battery temperature 82 degrees.
Yes.
And now you are also tracking healthcare data. weren't you?
Correct.
You are also tracking location information.
Correct.
At 12:22.
I really wish this expert would look at him and go, health data. Yes.
The battery temperature is 77 degrees Fahrenheit.
Correct.
And during that time, 12:22, that is the time with the location data where we see Mr. O'Keefe's car traveling near Cedarbrook, isn't it?
The form sustained.
And at 12:22 on January 20th,
You can't cross-examine your own witness, Brennan. It's redirect. You have to still ask direct questions. They can't be leading questions. Leading questions mean, let's just do a quick refresher for Brennan and chat. Leading questions are questions that assume the answer. It's not that it's a yes, no answer. There's nuance to it. It's, this is the same time John O'Keefe was in the car, correct? That means this time is when John O'Keefe was in the car. That assumes the answer. And is a yes, no. If he had said, at this time, what does all the data show is happening with the phone? That is a direct question. But he gets into a pattern of leading questions, and the court's like, stop it. He's trying to go faster. It is faster when you can lead, but you can't because it's your witness.
29, 2022. Where does the location data show Mr. O'Keefe's phone in progress?
It's around Oakdale Road, I believe.
And the travel that you're noting, is that consistent given the speed of being within a car?
I believe so.
And do you know whether or not that car had heat on?
I've got no idea.
You have healthcare data that the phone moves for a 20-second period, right?
I believe so,
And
yes.
That is after the Waze information stops.
Correct.
So you have to watch the form. I know it's hard to orient. You have to watch.
You're the prosecutor.
In your PowerPoint presentation, you are tracking the Waze information, aren't you?
I am, yes.
And at some point that switches to more local location data?
Again, Waze is not recording the location data. Waze is requesting location data from Apple's location services, and location services is doing the recording of the location data.
Right.
So if we're following the phone through Waze, at 12:24:25, is it in a car moving at 16.6 miles per hour?
According to the data, yes.
And at 12:24:26, according to the data, is it still in a car moving at 17 miles per hour?
Stained his two forms.
Can you pull up your PowerPoint?
Just
and
go
we'll start
through
at
it.
12:24:25.
Yep.
We could show the jury the progress of that phone.
Okay.
I saw in the chat, can we have Dutch Brothers instead of, unfortunately, not between where my husband is and where my house
And
is.
at
So,
12:24:25, how fast is
there's like
Mr.
3 new
O'Keefe's
ones
cell
in
phone
Murfreesboro.
moving?
The data on the device says that it was moving at around 16.6 miles per hour.
Next page, 2426.
17 miles per hour.
Next page, 2427.
15.9 miles per hour.
Next page, 2428.
14.5 miles per hour.
Right.
2429.
I don't know if you need to reiterate.
12.1 miles
This.
per hour.
2430.
11.5 miles per hour.
2431.
10.4 miles per hour.
2432.
8.9 miles per hour.
2433.
7 miles per hour.
2434.
5.2 miles per hour.
2435.
3.5 miles per hour.
2436.
3.2 miles per hour.
2437.
1.4 miles per hour.
And 2438.
0 miles per hour or 0 meters per second.
And at 2438, that phone is stopped
All
near
the
flagpole.
paper on the mic is rough.
I would say so, yes.
Then the location data gets more broad.
It does.
There is no movement at that time after the car stops. Is there any movement when the car stops at 2438, between 2438 and 2430?
He's trying to make
Any
specific
movement
points.
indicated on
It's
the
harder when you
healthcare
can't.
data?
Not from the health data, no.
And no, I don't think there is a Dutch Brothers anywhere in Franklin.
At 12:31:57.
Definitely not
does the
between where
phone
DOCKET is and where
demonstrate
I am.
any movement.
If I may just look back at my report,
course,
just
please.
to recall.
True, but I go over to Murfreesboro for other things because Donuts, my hairdresser. The Target's really good. The Target in Smyrna is also really good. So
What time was that, sorry?
12:31.
there are times I'm
57.
over there. Brennan wants to make specific points because he can see where the defense is going to argue with their
Yes,
cross,
around
and he wants
12:31,
to
56
kind
or
of close
57
those gaps.
is the start of the health event, 36 steps.
But it's hard.
How long? How many seconds does that phone move for?
Uh, 20 seconds.
12:31:56 to
Demos's is in Murfreesboro.
12:32:16.
Correct.
And that is that the only time that the phone moves from the point it stops at the flagpole until the next morning?
Correct.
The only time.
Correct.
12:31:56 to 12:32:16.
Yes.
And when that phone moves, you can't tell if it's walking a straight line or in a circle.
Correct.
You don't know if the phone is pacing back and forth.
Sustained is to form.
Can you tell
Can you tell what the phone's
how
doing?
far a phone moves from its origin, from its original point when you're counting steps?
No. iOS creates the calculation, number of steps times the person's gait, and provides the 25.4 meters value.
At 12:32:16, when that phone stops moving, John O'Keefe's phone stops moving, do you know the next time it moves again?
I'm going to allow it.
What's the
It's
objection on
approximately
that?
6:15.
Now,
Do you know when it starts moving again?
less than 5 minutes later,
Yes, at this time.
12:37, that battery in that cell phone gets another temperature reading, doesn't it?
It does.
Does it go up?
It goes down.
And it goes down to what degrees?
72 degrees.
And over the next 8 minutes, does that temperature even or go up?
The jurors are present. How in they are at this point?
At 43 minutes past, there was another reading of 66
We've
Fahrenheit.
gotten into the weeds, and they don't have a ton of
And then
context.
at 12:53,
That's where testimony like this could backfire, having it in early. The jury doesn't have a lot of context. They're just getting information, but they don't have context of other information. So it is all going to be argued later. We have more context from the pretrial motions in the last trial. They don't have context. So they're like, okay, the phone might have taken steps at this time. They don't know what happened with Karen Reed's phone. They don't know what time John O'Keefe and Karen Reed supposedly arrived at 34 Fairview unless they remember that specific detail from opening. So they don't have context for all of this information yet.
That's about, what, 21
So
minutes or
it's
so
just-
after that phone stops moving?
Okay.
What's the temperature?
I'm sorry, at 12:53?
Yes.
Without context, it's hard to focus.
Oh, 61 Fahrenheit.
61 degrees?
Yes.
And over the next 14 minutes, does it drop again?
It does. It drops to 55 degrees at 1:07.
And at 1:36 a.m. that morning,
It's down to 50 degrees.
and this health data shows that that phone hasn't moved. Does
Correct.
this healthcare data show that this phone hasn't moved since
there's
12/32/16?
Health data.
no more steps were recorded.
Health data.
Now, you had studies where you put the phone in a freezer.
Correct.
They've heard
When
this
you put the phone
7
in the
times.
freezer, did you wrap it in anything?
I didn't know.
Did you use any type of heat source that would slow down the process of the temperature dropping?
These are good questions.
Let me ask you a hypothetical.
Yep.
If a person, a human, was lying prone on a cell phone outside
It's a good hypo.
and had a body temperature directly touching the phone, in your opinion, could that slow the process of the temperature decreasing as compared to just simply putting a phone in a freezer?
Sustained.
It's a good hypo. I'm surprised she sustained that. That's a fair hypothetical.
When you put the phone in the freezer, did you wrap it in any warmth,
No.
I'm surprised she sustained that.
any clothing?
Nothing at all.
He's allowed to answer a hypo.
Now, you don't know the temperature, but you said there was a blizzard outside.
That's my understanding, yes.
At 6:06 a.m., is there a change in the battery temperature of John O'Keefe's phone?
Yes, the temperature has dropped to 43 degrees Fahrenheit.
So there's a 7-degree drop in temperature at 6:06.
Correct.
Were you shared any of the facts or information that has nothing to do with data and science? Were you shared any facts or information about what may have occurred to that cell phone and its exposure to colder air that morning, minutes prior to 6:06 a.m.?
Latasha, 100%.
I may have heard that around that time is when John was found. But,
So could you answer the question, yes or no, that Mr. Gannon asked you? Did anybody share information with you about that, sir?
nobody shared it with me, no.
If the phone was in an environment and it was exposed to further colder air or drop in
Kim,
temperature,
he was found
could it register
supine.
a reading?
I'm sorry, you just ask that again?
I don't know if Brendan knows the difference.
Let me ask a different question. The phone drops to 43 degrees. John's
he
phone
was
at
found supine.
6:06.
And there's been testimony to that.
6.
Maybe that's why she sustained it.
Is there another change?
Maybe she sustained because the hypothetical has to be based on facts that are already in evidence. Maybe she sustained it because he said prone and not supine, because testimony was supine.
Change with this phone dropping?
That would be a good reason to sustain it, Chad.
temperature?
That
Yes,
would be
it
fair
drops to
because that's
37
not in
Fahrenheit.
evidence.
Do you know what, if anything, happened
Fair
as
enough.
far as the environment that phone was exposed to seconds before 6:14?
I don't know.
Do you know if that phone at 6:15:01 was then placed in a warmer environment like a pocket or a car? Do you
I
know?
have no idea.
But your data shows at 6:35 there's an increase in temperature,
Correct.
doesn't it?
It does.
So at 6:14 you don't know if there's been any increased exposure, do you?
No, I know that according to the battery temperature, it's increased, but I don't know the reason for that.
Now, if you look at the battery temperature at 6:06 a.m.
I think that's good
it's
information
43
at
degrees.
6:14.
Yes.
That's a change in temperature, isn't it? Is that a change in temperature from 136?
It is.
Looking at your healthcare
Yep.
data,
Health!
is there something happening relative to the phone at 6:04 to 6:11?
There is, 432 steps were recorded at that time.
Can a phone record steps if it's being moved back and forth?
It may record some. It's difficult to say how many would be misunderstood as being steps taken.
What do you mean by
If
back and
you're
forth?
Shaking an object that moves the
I
phone
whip my hand
violently,
like
could it
a
record steps?
Again, potentially it could record
Very
some, but it's not a consistent enough pattern of movement for it to be recorded as lots of steps.
Now at 6:14, the temperature is 37 degrees, and you just offered us that by 6:35, over the next 21 minutes, the degrees goes up by 6 degrees.
Correct.
You don't know what was happening with that phone at 6:15:01, do you?
No.
I'll allow it. Do you know?
I don't know. No.
Next question.
I mean,
But what
asked
you
and
do
answered
know
at
is
this
this
point.
healthcare data at 6:15:14.
Correct.
I think I would start objecting to the word healthcare because that's facts, not in evidence. It's facts, not in evidence. There's no healthcare data.
And that demonstrates what?
At 6:15:14, it was the start of 180 steps.
So the phone at 6:15:14 is again moving.
Correct.
And after that starts moving wherever the phone may go, it starts getting warmer temperature?
Correct.
Answered. It's asked and answered. It's asked and answered like 6 times over.
Now, you shared with us location data, and you explained the difference between Waze and other types of location data. I had asked you an opinion about where the phone was
could've
located
stopped while he was
based just
ahead.
on location data, nothing else.
Now we're just banging on.
When I
into
asked you
the
that
void.
opinion, I didn't ask you to a reasonable degree of scientific certainty, did I?
I don't recall.
I asked you if it was consistent
Yes.
with being near the flagpole the entire night.
Sustained.
Based on location data alone, are you offering an opinion to a reasonable degree of scientific certainty where that phone was?
It's difficult to say with a reasonable degree of certainty based on the randomness of the location data.
I'm going to ask you to keep your voice up, Mr. Whiffin. Could we turn the AC off, please? Thank you.
Oh, there is AC. That's the first one, y'all. That's the first one. Do it. We are on day 6, and we have gotten to the very first. I'm going to ask you to keep your voice up. There it is. There it is. We knew it was coming, but we got to 6 days without. I'm going to ask you to keep your voice up. Can we turn the air conditioning off? Because it does get loud in the courtroom as it gets hot. So.
No, it's difficult to give an answer based to a high degree of scientific certainty based on the sporadic nature of the records that night.
What was going to happen?
Based on the data you have, just on location data alone, is that location data consistent with that phone being near the flagpole area from midnight until 6:15 the next morning?
It is, yes.
There's also information because the broadness that it could have been somewhere else.
Correct.
Yet it is consistent.
It is.
Okay.
You didn't just rely on location data for your opinion, though.
I didn't know.
Watch the form, Mr. Brennan. Sustained.
Did you rely just on location data for your opinion?
No, I did not.
Did you also consider the health data?
I did.
And did you also consider the battery temperature?
There you go, Hank. The health data. We got to it. We got to it. Did you hear how proud he was? He was like, the health data. Yeah, we got it. No, the judge isn't going to sanction him for the form of the question. She's just going to keep telling him in front of the jury, which also looks bad.
No, I did not.
Did you also consider the health data?
I did.
And did you also consider the battery temperature?
Sustained.
In addition to location data, what are the other things
Pelosi's
you
indignation.
considered,
He's just like, ugh.
in your opinion, to a reasonable
Seriously.
degree of scientific certainty, that phone was at the flagpole the entire night from 12:30 until 6 the next morning?
I'm going to allow that.
It was based on the location data that recorded high accuracy, based on the health data that showed when the device moved and how far, based on the battery temperature information, and based on the Doppler face detection information.
Let me
Okay.
ask you some more questions about the health data.
Wait,
You
no,
were
why
shown
isn't that your last question?
Pieces of information on examination.
Leave that one to the end
You
then.
told us that health data, well, the phone was it your opinion the phone was in the car until it stopped at the flagpole?
Sustained.
At 12:31:56 and 12:32:16, does the data show that is the time that the phone was moving?
At what time, sorry?
12:31:56 to 12:32:16.
And sorry, the rest of the question was...
Does that demonstrate movement of the phone at that time?
RGH said, why not let them say the reason for the objection? I don't know. I hate it. I don't know why it's the rule. I don't know why it's the rule for this court. I don't know. I don't know. I don't know. I don't know.
yes, it did.
And I don't like
You
it.
shared that you can't tell the direction or the distance of steps. If... I'm sorry, please.
Now we're collegial.
If that phone moved from the flagpole in a straight line away from the flagpole, like, for example, towards the house,
Oh my God.
wouldn't it have to move again before 6:04 to get back to the flagpole?
What?
I would presume so.
All right, you asking me to strike that, Mr. Listy? I'm going to strike that.
Does health
Wait, did
data
she rule
register
on
when
that?
a phone moves?
It does.
I thought she said I'll allow it, and then he answered. Apparently I can't hear either.
I'll ask you some more detailed
I don't know if they need to
questions
strike
about
it. The jury's
your
like,
research into
what?
a phone that's been attributed to Jennifer McCabe. You looked at one piece of your report on the screen, and that was a
Oh, she allowed it. He said
call
presumed.
register.
Fair.
Yes.
He
Can you turn
can't.
to that phone call register, please?
He can't speculate. He's an expert.
What are we doing with the slide that's up there, Mr. Brennan?
Your Honor, can we
I
ask
would
what
like
are we
to change
doing,
the phone call register if possible.
like in a more global sense?
Oh, it's not me.
Because any good points made in the redirect, and at the beginning, the redirect was good. I think we've now started to spin into
I believe it's Exhibit 42.
less helpful territory.
Do you have the report that you could put on the screen
Here now.
regarding
Wandering. Are we going to ask about
I don't
Axiom?
know.
call register?
I don't have this one that was shared as
Okay.
Exhibit 42.
I know y'all. I feel for the jury too. I do. I feel for them. Because they're just like,
This is now
We're still
marked
doing
as
this?
Exhibit 42.
great.
In the phone call register, you noted that there was a call at 12:14:36.
Yes.
Have you found it?
Yeah, the jury's making grocery lists in
Yeah,
their
yeah.
head at this point.
This is not me, no.
I think it's Ms. Gilman.
Thank you, Ms. Gilman. Could you enlarge that, please?
And biggin. I don't know what that popping noise in court is. I have no idea. It happens
Which portion of it?
Up the top part. The first 4 or 5 calls. Thank you.
We're looking back at that phone
And we
record.
need it larger, Ms. Gilman, please.
If
That's
they're
better, thank you.
still trying to embiggen, we're going to zoom.
On examination, you read that at 12:14:36.
Oh,
there was a phone call.
Heather in the chat said, it sounds like 3-ring binders opening or closing. That is a very good point.
Call incoming.
Yes.
That is a very
appeared
good
to be
point.
from Jennifer McCabe.
That does
Correct.
happen a lot.
At 12:14:36, the location information is the John O'Keefe's cell phone at Fairview by that point?
Is the question, is it?
Yes, is it?
No.
And then at 12:18:47, there's another call, and again from Jen McCabe.
That's an outgoing call to Jen McCabe.
It's an outgoing call to Jennifer McCabe.
Yes.
12:18:47, the location information, does that place Mr. O'Keefe's cell phone at Fairview?
No, it does not.
Then at 12:29:44, there's an 8-second call that you said you believe is answered. Do you know if there was any conversation in that call?
No way to know if there's any conversation.
And at 12:29:44, does the location information place John O'Keefe's cell phone somewhere
It does at Fairview Road.
at the flagpole?
Oh, John,
yes.
you need lots of 3-ring binders
I'll
in court.
strike that.
Lots of 3-ring binders
Now,
in a trial like this. Lots and lots
There
and
is
lots.
not a
So
call.
needed.
Well, let me ask you, the next call,
You need physical
what time
copies
is
of
the next
everything.
call?
33 minutes and 35 seconds after midnight.
And who's that call from?
From Karen Reed.
Midnight.
Is that before or after John O'Keefe's health data stops?
After.
At 12:37, you offered us that the cell phone battery's temperature is decreasing.
That's really the only clue
Yes.
so far the
How
jury
many call-
has as to when John O'Keefe and Karen Reed are together versus no longer together is that 12:33 call from Karen Reed to John O'Keefe. The jury doesn't have Karen Reed's information. They don't have yet when the car gets to 34 Fairview. So they can start to make some assumptions about 12:33 and what it means. But we're so far afield in this redirect that they might just be like, yeah, we've seen it. We've
Calls
seen
have
it.
been
Okay,
made
fine. We've seen it.
from
Great.
the defendant to John O'Keefe by the time that cell phone battery stops dropping in temperature.
We'll get to the car
7.
data later. I don't. The car data last trial left a lot to be desired.
I want to turn now to some questions about your analysis of Ms. McCabe's phone. You were asked about hash values, a way of trying to confirm the integrity
Needham,
of
I'm
the
still going to
data
have to
on
take a break to get some food, but
extraction.
Yes.
we normally take a shorter break than the
When
court does.
forensic analysts look at phones, do you sometimes get to actually see the phone?
Yes.
Do you sometimes have to use an extraction, a copy of the phone?
Yes.
Is it important to try to look and research or search the item to determine whether or not there's been any tampering?
Yes.
You were asked if hash values is one way to do that.
I was.
And you were shown or read part of your report about hash values.
Yes.
There's a second part to that, isn't there?
There is.
You didn't get a chance to share the second part, did you?
Sustain.
I mean, no.
In this
Can
case,
you
there
share
was a
that?
hash value, wasn't there?
There was.
Now, just so we can understand simply, how is a hash value created during the extraction process? What does that mean in very, very simple terms?
At the end of the extraction, an algorithm is run on every piece of, every byte of data within the extraction, and it comes out with a value at the end. The idea is that if any of that data ever changes, be it through user interaction or through corruption of data in how it was stored, then that value will change at the end.
You mentioned Gray Key. Is that
That's
a
pretty
software, hardware that
good,
makes the copy of the
simple
phone?
version, I think.
It's a piece of hardware and includes software.
Erica, the
commonly
jury
is
probably
great
gets more
used
bored.
in
We
the
get to chat
industry?
with each other.
It's very common.
Did I hear you say that with gray key, the hash value is never authenticated?
Objection, Your Honor?
Sustained is
Yeah,
to fall.
he didn't fucking say
Does
that.
gray key authenticate the hash value?
The hash value is placed inside a PDF which is not signed.
That's what he
And is
said.
that common or typical in the industry?
That is the way that Grey Key do it.
Was there anything anomaly or untoward or different about the way this one was done?
No.
Did the hash value from the gray key extraction match the hash value?
It did.
Anything
good point.
irregular whatsoever about it?
No, not that I could see.
Those are
Now,
good questions.
You don't just read software programs when they spit out reports, do you?
No.
As an analyst, as one of the leaders of Cellebrite, do you have a history of being a researcher?
Yes, I do.
A history of study?
Yes.
Have you written reports and papers for people to learn?
No,
I've-
he writes blogs. I couldn't help myself. I'm sorry. Have you written research papers? He said I blogged about it yesterday. Why are we getting back into this? This is not going to go well. You write research paper? He's like, so like peer reviewed? Not so much.
Written multiple blogs, done multiple presentations.
I just peer-reviewed papers.
The hash value?
It did.
I had to back
Anything
up
irregular whatsoever about it?
just to entertain myself.
No, not that I could see.
Now, you don't.
The thing is, that point's really well made. Is there anything wrong with this data? Not that I can see. And then we get back into him trying to, I don't know, reassert his expert's expertise, and it just goes spectacularly wrong.
Just read software programs when they spit out reports, do you?
This is not.
As an analyst, as one of the leaders of Cellebrite, do you have a history of being a researcher?
It's a history of being
yes,
a
I do.
blogger.
A history of study?
Yes.
Have you written reports and papers for people to learn?
I've written multiple blogs, done multiple presentations, webinars. Some of my blog posts have become peer-reviewed articles.
What? I have many more questions. There we go. Some of my blog posts have become peer-reviewed articles. Okay, fair enough. I retract some of my snark, but not all.
Is it sufficient to simply look at a report that is generated by
He might have said that
Cellebrite
yesterday, I forgot.
or Axiom or any other service and make conclusions just on the report?
I don't believe it is, no.
Why do you think that's imprudent?
Sorry?
Why do you think that is not prudent to simply rely on a report?
Objection, Your Honor.
I'm going to allow him to answer.
The tools are very good at surfacing data, but I believe it's up to the examiner to understand what that data means and to provide context to the information which the tool itself can't give.
And when you were considering the hash value and determine whether or not you thought there was anything wrong with the data, aside from the hash value, how do you do that?
How can I do
How
what?
do you make a determination whether or not this has integrity, the data
He's
hasn't
like,
been
what are you
tampered with, so to
talking
speak?
about?
Okay. So, notwithstanding the hash value, I'd be looking for issues with the data that don't make sense. In this particular case, there was lots of data points that all appeared to work together. Like you would see one artifact change in one database and an artifact would change somewhere else. And it all just made perfect sense in how it was functioning. That kind of leads you to believe that it's not been tampered with,
That
or
makes
the
sense.
person tampering with it did an exceptional job to be able to cover all of these different tracks and make it undetectable.
Well,
Did you try to
that adds new
summarize that
information.
perspective in the part of the report that wasn't read to you on examination?
I did.
Do you have an opinion to a reasonable degree of scientific certainty if there was any data
Steed,
integrity
it's
issues?
fair. I'm being snarky at him. Steed said, I'm an academic. I do write peer-reviewed articles, but I also write blogs. I don't see the problem. It's that Brennan was going down the road of, do you write peer-review articles? And yesterday he's like, no, I wrote a blog about it. So the vernacular to me, A, is funny. B, this testimony is very dry. And he said, no, some of those have become peer-reviewed articles, which is completely fair. But we are so far afield into the, did you write a report about it? No, I wrote a blog about it. I think it's funny. Is it unnecessarily snarky? It might be. It might be. It might be. It might be. Why? Because it's funny. But I'm very curious how they became peer reviewed. Does that mean he's not an expert in his field? No. But am I kind of out on the, no, I don't know the temperature of the freezer? Also a bit. So we've gotten so far down in the weeds.
I don't believe there was any.
Is it unfair snark? It might be. It might be unfair snark.
It was characterized on examination. There was a dispute about the time origin of the search, how long to die in cold. Do you remember being asked the question about a dispute?
Yes.
I'm also not bothered that Cellebrite changed their program. I'm bothered that no one's explained it yet.
And in your position,
I am
is there
bothered.
any viable dispute in the forensic data scientific community
I think that should
about
be
that issue?
explained.
I don't believe there is any more.
Now, you got involved in this case
Fair.
because you received a complaint from a consumer.
I received a question from a consumer, yes.
And you attempt.
I want to know more about this. I want to know more about why Cellebrite changed their program, because I think it's one of the things that if you're sitting on the jury, and the lawyers know more about this case than the jury does, and we do too, but if you're sitting on the jury, aren't you like, wait, your program changed? Are you hiding something? Because after cross, for the jury, it can feel like, wait, so that data's hidden. So I think they have to get into it and redirect.
In the forensic data scientific community about that issue?
So I backed it up
I
because now
don't
I want to
believe there
hear
is any more.
how he got into this case.
Now, you got involved in this case because you received a complaint from a consumer.
I received a question from a consumer, yes.
And you attempted to resolve that?
Correct.
Sustained.
Other than that source, have you received any information, feedback, opinions that would make this issue in any way dispute?
What is that? What?
I'm sorry,
Allow
can you rephrase
what?
the question?
Other than that one person, that one consumer, have you received any information in the forensic community, which you're part of?
Oh.
Any data, any information that would suggest that your conclusions are in dispute?
Yeah, I received a very similar question from an examiner in Europe. Fairly similar circumstances with a case and with a timestamp that didn't make sense, that was originating from the same database. I applied the same logic and theory to his question, and he confirmed it solved the issue for him. It all made sense then.
And since then, has in your world, academic and research world, forensic data science, other than the person who originally raised the question, has there been any dispute brought to you by anybody about your conclusions about when this search actually happened?
No. If anything, I've heard people who have confirmed the research that I did.
That's just hearsay.
Do you know Jessica Hyde?
I do.
Is she well known in the forensic community?
She is.
That's another expert. We'll see her later.
You were asked questions about your law enforcement background and the fact that Cellebrite is used as a forensic tool oftentimes by law enforcement.
Yes.
I want to hear them
Did
explain
you go into
why Cellebrite
your
changed
company's
better.
software and change it to accommodate law enforcement?
No, definitely not.
Would you ever do such a thing?
No.
Why wouldn't you do something like that?
Explain why you changed it.
Aside from being unethical to change the data in that way, this is an artifact that is easily validated by any examiner. And if I was to tamper it for the purposes of changing the outcome of a case, it would be detected by all of our customers immediately and would destroy the reputation of Cellebrite, which I've got no intention of doing.
Before a prior proceeding, the printout from the software.
I still don't, I appreciate that he's like, no, we wouldn't do that. It would destroy our company. But what they didn't do is explain why it was changed. Explain why it was changed. I know what that answer is, but explain why it was changed. He got into it very briefly and direct, which everyone has forgotten about, which was the way it was on the report was confusing. And the way it was on the report could be misleading if you didn't do the analysis that he did. And in the Axiom report, he said it is noted differently. How? How does the Axiom report note it? And what was misleading about it? And How does the Axiom report reflect it now so that it still appears when it doesn't still appear on Cellebrite? There's a lot of questions.
When it was showing the timestamp of the Safari search, was it labeled something in particular before?
The Cellebrite search
Yes.
was
he's
labeled
getting
last
there.
visited time.
Last what?
Last visited time.
And when it was labeled last visit,
He's getting there in a different way. Fair enough, Emily. Keep reading.
Cellebrite, which I've got no intention of doing.
I'm going to let him ask that whole very long question again.
before a prior proceeding, the printout from the software, when it was showing the timestamp of the Safari search, was it labeled something in particular before?
The Cellebrite search
Yes.
was labeled last visited time.
Last what?
Last visited time.
And when it was labeled last visited time, did it show 227 on the report?
It did.
Cellebrite, after research and consideration, removed that label?
We removed the timestamp when we determined that it was not relevant to the last time that that page was visited.
Why was it important to remove that timestamp
That.
from the program and the software?
It was clearly causing confusion.
Does the company have concerns when consumers are confused about information?
Of course, yes.
Do companies have concerns if a consumer tries to manipulate the use of that information?
Ooh,
Of course.
spicy
Are
question.
companies concerned that a label could be misleading for somebody who may not have a higher level of experience?
Yes.
When that decision was made to change that for clarification, do you make that solely by yourself?
No, I did not.
Who do you consult with and who's part of that decision process?
So again, after my research, I passed the results of my research to the Forensic Research Group. This is a team based at Cellebrite whose sole job is to do the research, do the coding to make sure that what we're giving to customers is correct. They spent some time validating the research that I did, verifying that my research was correct, and then they were responsible for making the change based on the updated research.
It was suggested that a separate software program, not the company you work
Oh, he's
for,
gonna ask
Cellebrite,
it.
but
Good.
Axiom, reflects this search as deleted. That's not entirely accurate, is it?
Objection, Your Honor.
Sustained as to form.
Is that
Running
entirely
an
accurate?
Axiom program, would it reflect this search as deleted?
Yes, and it is a deleted search.
Does it have a label on it?
It does.
Is that carved?
Yes, it would be.
Now, are you familiar with the Axiom Artifact Reference Guide when it talks about the dangers of relying on the timestamp?
What?
I'm not familiar with it referencing dangers, but I'm aware of the document.
Are you aware of the reference guide when it talks about Safari suspended state tabs
Yes.
and offers that since these are local tab states, results from this artifact may
It's just
contain
leading.
an earlier date and time compared to the results in the Safari history artifact if iCloud Safari synchronization?
Objection, Your Honor.
Sustained.
Are you aware of the reference guide?
I am.
Are you aware that it cautions that a timestamp can be misinterpreted?
Objection, Your Honor.
Sustained.
You got to ask it a different way. Just ask the question instead of testifying to it. You're on redirect.
Sir, when you came to your opinion that the search
Thanks,
for
B.
how long to die in the cold at 6:23 and 6:24 in the morning of January 29, 2022, was the time that they were actually inputted, not 2:27. In forming your opinion, did you consider both Cellebrite and Axiom software?
I did.
Did you consider other tools as well?
Yes, my own.
And tell us a little bit about your own tool.
What?
Again, this is a tool I've been writing for approximately 5 or 6 years now.
I thought
Partially for fun, partially for research purposes.
I thought we'd escaped this. We haven't.
And it's a tool I make available to other examiners globally.
And sir,
We can't escape the tool.
when you were trying to examine these searches that in your opinion were 6:23 and 6:24 a.m.?
Yeah, Brennan is very memeable this trial. What would you call me? Sir, can you tell us about your tool? Brennan!
Did you ever try to test it yourself and actually take a phone so you could either prove or disprove to yourself that that earlier timestamp didn't mean it was the time that it was searched?
Oh, definitely. Yes, that's the kind of thing I do all the time when verifying artifacts.
Brennan, he
And in your
sometimes
opinion,
just
is that
does it with his
helpful
tool
in
for fun.
understanding
He said that.
how a timestamp earlier could relate to a later search?
Exactly, very helpful.
Would you be willing to do a live demonstration for us on the screen? And show us
On
how that works?
redirect?
Yes.
How long would that take?
Probably about 5 minutes,
Could you show us?
of course.
Okay.
I thought we were doing better with the slide presentation, but it looks like they want to do the live presentation that they formerly did. Let's see where we go. Okay. I know Chad is very concerned he's going to try to show us his tool. I know.
Good place to take our lunch and recess.
Oh,
45 minutes.
they're doing a 45-minute lunch before we get to his tool.
The rest of us are in recess.
Please rise for the jury. Please leave no folks on the chairs. Thank you.
Yeah. Okay. Well, hi, Fred. You showed up at exactly the right time. Yep, Fred's yawning too. Fred is over it. Fred just walked into trial and he's over it. They are taking a 45-minute lunch break. Let's see if we can summarize the morning other than stop while you're ahead. I think the takeaway from this morning is stop while you're ahead. Let's see. So their 45-minute break is going to be over in like 10 minutes. Okay, Dr. B. It's fine. You're all good. Thank you. We had just gotten to talking about the expert's tool. So you walked in at the perfect time. The expert part or the tool part? The expert showing everyone his tool. They had to take a lunch break so everyone could recover. Yep. All right, let's see if we've got like 15-ish minutes. I'm going to try to do a summary. I'm going to take a 15-minute break and take a deep breath from today because today has been much. So let's see where we're at. We are at the lunch break of day 6 of the Commonwealth versus Karen Reed retrial. The same witness has been on the stand all morning. And despite what I thought, and like 90% of you in the chat thought yesterday, the lawyers did not start with needing to see the judge this morning. They just got right into the jury coming in and right into the testimony of Ian Whiffin from Cellebrite. We had an extensive cross-examination. I think there were points of the cross-examination that were very precise, very impactful, and very effective. And there were parts of the cross-examination that were not that at all. I think what's going to be hard for the jury at this point is they don't have the context, but some of what the defense was doing was laying the groundwork for future witnesses and future arguments. And I think that was done really well, nailing down the timing that the defense wants to highlight, bringing up that after 12:30 a.m. when the phone took, I think it's 12:30 a.m., but when the phone took those 36 steps, that's roughly 84 feet according to Apple. And then that measurements were taken from the flagpole in the front of 34 Fairview to the door, and that measurement was 74 feet. Those, I think, were important bits of testimony. We got into more about how this expert did his experiments with regard to the battery temperature, putting it in a freezer. And at one point, when Alessi asked, well, what was the temperature of the freezer? And he said, well, I don't know. I'm like, you put the phone in the freezer and you watch the temperature on the phone go down quite quickly, but you don't know what the baseline temperature of the freezer was? And he's like, I didn't think it was important. In redirect, we got back to that he was looking for whether or not environmental factors impacted the phone. If you put it in the freezer, does the battery show that it's colder? If you take it out of the freezer, does it show it warming back up? He said he was looking for those patterns. But I also don't think it's a good look when you're saying, well, I didn't check to see what the temperature was in the freezer. So we will see. We are now in redirect, and we have just gotten to Attorney Brennan saying, well, what kind of other tools or programs do you use to evaluate this information? And have you written your own tool? And will you, show us your tool? Will you describe your tool for us? And Brennan has asked to do a live experiment in the courtroom. We saw that last trial. I didn't think we were going to see that this trial. I thought we were just going to go by the PowerPoint, but no, it looks like after lunch, we might see that live experiment of how the tab marks the time. And yes, we got more into the time of whether or not the Howe's long search was at 2:27 or whether that is the timing of the tab. And we heard a bit of explanation from Ian Whiffin deep into the redirect about why Cellebrite changed the way that their printouts read because it was confusing and it was causing confusion. Is the jury still with them at this point? I don't know. It was a long morning. There were points of cross that were good, and then there were points that got lost. There were points at the beginning of redirect that were good, and then there was points that got lost. How much of this will be taken away when we get into other testimony? I don't know. But will we be able to see the jury check back in with other witnesses? Maybe. Will we see the defense arguing the things that they nailed down in this cross? I imagine we will. And will we see the prosecution doing the same? Maybe, maybe not. But we did also see Alessi get admonished by the judge at sidebar for talking about the first trial in his testimony. And while witnesses are generally advised to say prior proceeding, the attorneys are too. And it was very interesting seeing Alessi say, well, in the first trial, and the judge is like, just sidebar. And then he came back and very clearly said, in the first proceeding. I was surprised with that from him. The prosecution didn't object to it and make a big deal about it because I think it highlights that it's an issue. But the court did pull Alessi to sidebar. And you did see him being very careful when he came back saying, in the prior proceeding. The jury is not told about the fact that there was a first trial because they are not given the information about what happened at a first trial. They shouldn't know that it was a mistrial vis-a-vis. It was a mistrial in the middle vis-a-vis. They ran out of jurors, couldn't make a decision. They're not supposed to know all of that. There is information that the jury's not given. They're not given everything. They're given proper legal evidence and testimony. And that is one of those things that is outside the purview of what the jury knows. Well, the shit's out of the horse now. Will it be the biggest deal to them by the time we get to some of these other witnesses? I don't know. Or will the jury sit there and be like, now I understand why there was a first trial, because they know now, and there's not much you can do about it. If the prosecution had done it, would the defense have asked for a mistrial? I don't know. It depends on how the defense views what the jury might assume from that information. If the jury assumes it was because the defense did something, then it might not be good for the defense. If the jury assumes that it's because the prosecution did something or because the evidence wasn't strong enough, then it might be good for the defense. But you can't really know what a jury is thinking or might assume because you just don't know how they will fill in the gaps. We'll see what happens after lunch. I hope that we'll get to another witness today. I really do. And for all of you that have asked, yes, we have had a couple subscriber bings. So yes, we can. Let's see. Karen asked, did the Crash Daddies go back to work? Yes, they're not going to testify until later in this trial when we get to the defense case in chief. I'm interested who the prosecution's next witness will be. If we're going to stay in scientific testimony for the afternoon or if we're going to get back into civilian testimony, I don't know. I don't know what we will do, but we will see. But I do owe you, and Law Nerds, you can fill in our new Law Nerds on the lore of it binged. We will play that, and then I'm going to take a few minutes to get some lunch. I'm still tired from yesterday. Brennan was emotionally exhausting yesterday. See, he's had some very good points today, but I'm still just tired from yesterday. The jury didn't see any of it. So we're tired, but Brennan has made some good points today. He is a good attorney. There are times that I do not like his style, but I cut myself off. But don't let him fool you. Oftentimes when jurors come into a case, they want to hear what the prosecution is going to prove to them. And if they think that the defense is trying to like smoke and mirrors them, they might be very much going, oh, okay, the phone got colder. It didn't get warmer again. There has been some good testimony that has come in for the prosecution. We are early in the case. At this point, there should be good testimony coming in for the prosecution. How much will it matter by the time we get to Proctor? Because I have a feeling that by the time we get to Proctor, it's going to blow everything up that the jury's thinking. Because I remember how much it surprised me not knowing everything that was going to come in the first trial. And I was like, how are we here? We'll see how those moments come in. It's why I'm trying not to give spoilers to those just watching this case for the first time, whether you saw the ID discovery or you're just seeing this on YouTube and you're like, I want to know what's happening. I'm trying to give foreshadowing, but not spoilers. It's a difficult line sometimes because it's like, there's so much more coming in. But also I love seeing those of you that have seen this for the first time, how you're interpreting the testimony vis-a-vis those that have seen it before, because it's very hard to parse out, but wait, there's this, and wait, there's that, and oh, there's this more. There is. The jury doesn't know it yet. And they are told to wait till all evidence to make an opinion. But all they can do is sit there and think about this case. All right, let's get to the OG. Let's get to the OG from when we binged at 100K. Because, you know, we're still on the road to 1 million as a bet with my 13-year-old. Oh, it binged. Move your head. Also, is that the noise I make when I like see my friends in public? Yes, it is. That is the I'm so excited to see you. That is that noise. That is the I'm so excited yell. So I'm going to I'm going to answer just a few questions and then I'm going to get to lunch. Emily, are we rambling? Yes. Are we going to try to ramble less after lunch? Look, man, tired plus ADHD is a bad combo. A bad combo. A bad combo. Bohica 462. I hope I said that correctly. The beard is glorious. Morally casual with his tool. It's just, Brennan has these moments where you're just like, what did you just say? Riza T said, thank you for gifting the 5 memberships. Colleen, thank you for gifting memberships. I appreciate it so much. Renee said his blogs have become peer-reviewed articles by who? I don't know. Maybe it's by the person from Murdoch that just threw the phone around and was like, the screen went on. I don't know. Christy said, I can't wrap my head around the idea that we're supposed to believe every timestamp in John's phone, but not Jen's. Christy, it's fair. I don't know if they've spent time differentiating between the search tabs in Safari and the times in John's phone that are connected to text messages, that are connected to Waze data, and that are connected to when phone calls are coming in. I don't know if they've parsed that out well enough for the jury. Maybe they have, maybe they haven't. Cat Max said, I'm here for the snark. Look, sometimes it can be too snarky. I get it. And if it's unfair snark, I know you'll tell me. There are times it's just like too much. I'm like, yeah. Also, I don't know how a blog becomes a peer-reviewed article, but this is not my field. So it's fine. We'll see. There's a lot of questions. What I'm really interested to see is with this, the Commonwealth's new accident reconstructionist. I'm interested to see how these timelines line up or don't, because they might not. And I think the defense is going to take some of these points in time and juxtapose them to what Karen Reed's phone is doing. And I am interested to see how that comes in evidence as well. There are things I'm just like, I'm waiting for. Gee Whiz said, I think the pop is a hard spout on a Stanley. It might also be a water bottle. It may well be. There are definitely pops that happen in the courtroom. It's like the really sharp pop. So we'll see. Kate said, I would have sworn the CCTV from the bar showed them leaving at 12:16. I don't remember from the last trial when they were leaving. You know, as you bring that up, it might be very interesting to get into the CCTV from when they leave Waterfall after this witness and go through the waterfall timing with what happened from getting to the waterfall, being at the waterfall, leaving the waterfall, and getting back to 34 Fairview. That might be interesting testimony to follow up next and tie those two together with somebody that either works at the waterfall or one of the people that was present at the waterfall. That might be a really good next place to go because it would answer those questions. So let's see. Anderson said, Emily, the lady in front of the judge, she is a stenographer. That is the court reporter speaking into the steno machine. So it is verbal stenography versus typed shorthand stenography. I have no idea how it works. I'm sure there are stenographers or steno students and court reporters in the chat who can explain. I don't know how it works at all. I never worked with a court reporter that did verbal court reporting, only with the typed court reporting, and then they had a recorder on their machine. But court reporting is A, fascinating, but B, there is a massive shortage of court reporters. So if you've ever been like, that seems interesting, A, court reporters know all of the tea, like all of the tea, and there is a massive shortage of court reporters. So if you're ever interested, look locally. There are jurisdictions that are paying for you to go to school to be a court reporter and paying like signing bonuses, like tens and tens of thousands of dollars of signing bonuses, depending on where you live. So if you're interested, it's fascinating. I'm fascinated. I have no idea how they do it. I have no idea how the verbal stenography works. We'll figure it out at some point. But if you want to know the tea, court reporters, especially the ones that go to depositions, you know everything. You know everything. So let's take a break. Let's see. 15 minutes. Court should be back shortly. They are not back yet. Court is still on lunch. So I am going to take us to lunch for, I'm going to say 1 o'clock Central. So like 10 minutes from now, I think we can do it because Dr. B brought me food. So 10 minutes should get us there. So Miguelina, if you will put us on a 10-minute break. Mods, please do not forget to take periodic breaks. Just because I'm sitting here streaming this whole time doesn't mean you shouldn't be taking breaks. Same for you, Miguelina. Don't forget, law nerds, snacks, hydration. We got a full day of court, and I'm going to try to get us done close in time because I have to do laundry. So remind me when we get to the end, and I'm like, let's just chat. Emily, you actually have stuff you have to get done, and you have to get some more sleep because, girl, we know you're tired. We can all tell, right? I can too. Let's get to court break. We're going to put on our new break video, not break stuff. Just one of those days. Emily, Limp Bizkit is not until this weekend. I'm really ready for concert time. We're getting the nails changed this week. We're getting some Metallica nails going. I'm so excited. Ready. But I'm also ready to see if we move on to another witness after lunch. If you are just like, miss me until we get to a next witness, get the Law Nerd app, lawnerd.com, completely free for you. And we are going to send you a notification when we switch witnesses. If you're like, fucking miss me, don't worry, go get your shit done. I'll ping you when there's a new witness. It's going to be fine. We're going to see him do the experiment that's going to mirror the PowerPoint presentation. You're not going to miss anything. And if you miss anything that is groundbreaking, it will be in the timestamps down below. Replay crew, we got you. And if it's really that much of a moment, it'll be in the case briefs tomorrow. So if you need a minute to go get some shit done before we get into another witness, take a minute. We'll let you know in the app. Don't worry, I got you. That's why we made the app. You have permission to just like be like, I'm going to step away. You won't miss anything. I'll let you know. I promise. But I'll still be here. I'll see you guys in a minute. That was me. Apologies. Hey Law Nerd, court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Law Nerd app has all of your live court notifications to keep you in the loop. LawNerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch, and take care of yourself. Trial days are long days. Trying to stay in the loop with this trial? I know sometimes it's hard if you miss a day. That's why I've got daily case briefs dropping over on the Emily Show YouTube channel and the Emily Show audio feed on your favorite podcast app, so you can stay in the loop even when things get busy. Are we ready, chat? Are we ready? Are we ready? I think so. I think we're ready to go. We sent out an app alert. Don't worry. If you're sitting there going, Emily, can I turn off my brain until we get to the next witness? Yes. If you would like, I will send you an app notification. You're like, girl, I got stuff to do. I will let you know. I will tell you when we are back with a new witness. What, if any, witnesses are we getting to today other than Ian Whiffin? I don't know. What was lunch today? Dr. B brought me some egg bites from Starbucks because they're easy to eat on stream, because generally during the lunch breaks, I do not have time to make food, and I am not prepared enough to make food in advance, though I always intend to be. I'm like, this would be a great idea. Now, 10 minutes is not enough time. It's enough time to go to the bathroom, stretch, refill things, go to the bathroom again, and bring food to the desk. And remind myself for the 5th day in a row that I have a fan that keeps some of the tech in my studio cool. And I moved it when I was redoing the studio and have forgotten to bring it back down. And today it is incredibly noticed. So as I am starting to get warm, the fan you will see in the background, it's going to be on. So they're going to get into a live demonstration. I don't know, man. I was a DA in LA, and live demonstrations, maybe it's just our office that was really particular about them, but even Apple doesn't do like full live demonstrations on stage. Live demos don't always go well. So live demonstrations in court are just one of those things that makes me nervous, but you know, they're grown-ass lawyers. They can do what they want to do, but live demos are a whole thing. So let's see how that's going to go. Is this the same live as last time? Who knows? Trial is dynamic. So we'll see if it's the same as last time, but let's bring the jury. Let's bring the jury and let's just get to court and see how it goes, because we're going to find out more about the tool that's being used, I suspect, and we're going to do a live demonstration of the tool, and we're going to, Emily, do you have this muted? I do, unfortunately. That's user error. That's not even on the court. That's 100% on me. Did we miss anything? Nope. So, you know, what, if any, tool are we using, Mr. Brennan? There's lots of bustle sounds in the courtroom at the moment.
Mr. Whiffin, I'd like to ask you a couple of general questions.
Yes.
Bustling.
You mentioned with reference to location data that the...
I am not going to give Brennan shit for yelling today because the tone is very different, which can be difficult to pick up. However, it is clear that we are back to it being loud with like whatever AC window units are happening in this courtroom. And it is hard for them to hear each other. That's been clear this morning. There's a microphone projecting out to us at the podium, but that is not projecting in the courtroom. So that microphone is not helping the witness and the jury hear him. It's loud for us, but it's more difficult in court with all the background noise. So this is just projecting. This is not yell mode. It's hard to hear in this courtroom mode.
Scope of identifying a location of a phone can change depending on what information the phone is receiving?
I'm sorry.
What?
Rephrase.
Coming
You
in
show us
hot.
a number of
not.
graphs and exhibits
Yes.
that show different circles.
Fred, that's my
Some
food.
might be smaller, some might be larger
Thank
than
you.
others.
Yes.
And you shared with us that location information is being received from a number of different sources.
Yes.
Can you remind us again what can affect that location data as far as receiving some high accuracy, mid, and low level? What could affect the receipt of that information?
So primarily the requesting application
So back to location
defines
data?
how accurate it needs the data. iOS Location Services then determines the best technology to use in order to work out that location. And it can use GPS information for the most accurate. It can use Wi-Fi cell sighting, so it understands the Wi-Fi networks that it can detect close by, and it knows where those networks are. And from that, it can derive where it itself is. Similar idea with both Bluetooth beacons and with cell tower technology. It understands where the cell towers are. It understands where the Bluetooth beacons are. And if it can see those particular cell towers or beacons, it knows roughly where itself must be.
You share with us there are some factors that can affect that location data,
Yes.
in addition to being in a building,
change
like a
my fan
house or
position, so-
a business. That's one way it
I'm
can
listening.
be affected.
It is.
And there are other ways as well, isn't there?
There are.
And could you share again the other ways that location information could change?
Yeah, the weather can play an effect on it. The geography of the area, whether it's in a rural or urban environment, other kinds of interference. If there are other items close by that are emitting electrical interference, it could affect the location data as well.
How about a body being on the phone? Could that affect location data?
Huh.
Ask it differently.
Huh? Well, it's a fair question.
If a human being was covering the phone so it wasn't exposed to the air, could that affect the location data?
I'm going to allow it.
I believe it could, yes.
You were
Interesting
shown
question.
Exhibit 40. It was one select piece of your report. It was a graph. With the
Again, we're back to
court's permission, I'd like
could.
to show Exhibit 40.
Yes.
Exhibit 40 has two
It'll be
circles,
interesting to
one
hear what the
darker,
other
one
witnesses
white.
say.
Yes,
And do you remember being asked questions about this particular exhibit?
I do.
And in addition to this exhibit, is there other information in your report that wasn't shown to you that would put this in context?
Obviously.
This exhibit is to demonstrate a window of when location data was taken for a particular time.
Watch the form of the question. Mr.
This
Mr. Brennan's like,
photograph,
I've been a defense attorney
What
for a
does it
very long
represent?
time, and I literally can't.
There were two particular time periods of approximately 5 seconds where multiple records showed identical latitude and longitude. So the same center point of the radius, but the radius themselves differed. So in this case, the white circle or the white circles show the lowest accuracy and the highest accuracy for 5 records that were all within a 5-second time period. and that shared the same latitude, longitude as the central point.
Looking at this snapshot of 5 seconds, is this still consistent with your opinion that to a reasonable degree of scientific certainty, you opine that the cell phone was in the flagpole area the entire evening of January 29th, 2022?
I'm going to allow it.
Yes, it still aligns with my opinion.
When you provide a report with all the different graphs and explanations, do you expect it's going to be shared with the defense attorneys?
Of course.
And you understand in this case everything is shared.
Of course.
And when you shared your report with this piece of information,
10 out of 10 intended.
did you include a summary chart that wasn't shown to you on examination?
I believe I did, yes.
May I approach?
Yes.
So now they are bringing in the rest of his report. I wonder if the court shot down the live demo. We'll see if he gets to it or not. I thought he was going to get into it first, based on his last questions.
22.
Do you recognize anything in particular as far as a chart on that page?
I do. There's a chart at the top with the location data that was used to create the image shown.
Does that chart help explain this photograph?
It does.
And move that chart into evidence.
Any objection, Mr. Alessi?
No objection, Your Honor.
He didn't get the full report in, and that's why he's bringing in parts of it. Interesting. I thought the court would allow it. I'm surprised she didn't. She's had some nuanced rulings today, which at times surprises me. And I'm just like, I'm actually really surprised
court's
based on your other
permission, I'd like
rulings.
to show us
That
the
was your
chart.
ruling, but okay.
Yes.
We're always open to be pleasantly surprised.
How long of a time period does that photograph encompass?
The photograph has got
Look at this.
2 time periods of 5 seconds each, which are approximately 40 minutes apart.
What?
And what does this show us? Can you explain the chart that goes along?
How are those 40 minutes up? What? I see 12:38 13 seconds to 12:38 21 seconds. I'm so confused. What?
With that photograph that was shown to you?
So this chart is
40 meters? He might have said meters,
or I should say
not minutes.
The map
Fair
shows
enough.
5 of the records
Thank
from
you,
this
Chad. I
particular
heard
chart.
minutes and I was like, what?
But we can see that all of these records have a consecutive timestamp 1 second apart. The latitude and longitude is identical for all of these records, but at the same time, the accuracy drops from 43 meters to 7 meters within that same 8-second time period. The idea was to demonstrate that if you had one of these records on its own, if you only had the 43-meter accurate record, for example, then the phone could be anywhere within that 43-meter radius. But as time goes on, the accuracy is refined. The same central point is used by iOS, but we've now got an accuracy of 7 meters.
So within 5 seconds.
And again, if we were to say that the phone is anywhere within that
within
7
5
meters,
seconds it went.
it's a much more accurate representation, according to the data, than the 43 meters would be. And with an 8-second time period, if the device was actually moving during that time, I wouldn't expect to see the latitude and longitude remain exactly the same. There'd be some degree of movement in the coordinates.
When you're producing location information in the circles that represent the location change, small, medium, large, at different times, does this chalk help represent that there can be changes in the location data, but the item can remain dormant?
So ask that differently, Mr. Brennan.
What is the exact point of the demonstration or this chalk? How does that help us understand the movement or the lack of movement of a cell phone?
I believe it demonstrates the fact that the phone is constantly refining the location data or the accuracy of the location data, even though it's using the same central point, the latitude and longitude, as the reference point. It doesn't necessarily mean the device had to move.
If I could go back to Exhibit 40, please. So looking at your photograph that you were asked about.
Yes,
There are
anything
two
brought up on
different
redirect
circles, one
can be
dark
brought
and
up
one
on
light.
recross,
Yes.
as long as it's not
And
treading the
those
same ground
circles are in
again.
different spots.
It would have to be
Based on
new.
the chalk, or the chart you just showed us, are both of those different
Yes, in Massachusetts, they call the demonstrative chalks. So it's the demonstrative exhibit or the chart. They call them chalks. He's not just pronouncing chart weird.
color circles consistent with a phone being in the same spot and not moving?
The previous chart that was shown only accounts for the white circles on this map. And it only shows the highest and the lowest accuracy. 20 minutes later, there was another similar scenario where there were multiple records with the same central GPS coordinates, but with different accuracy levels, and that's what was used for the black circles. Importantly, in my opinion, they all overlap, so it's possible that the device is somewhere in between those two circles for the duration of the time.
Now, finally, I want to turn back to the phone that was attributed to Jennifer McCabe.
Okay.
And you had shared with us your opinions about the time in which the searches at 6:23 and 6:24 were made.
Correct.
And I asked if you could just show us live right now
Oh, we're
how
doing
it
it.
works that a person
right.
can open a tab.
Do it.
And there's a timestamp, a time when it's open, and then make a later search but still retain
At least it's
the
a change of
original
pace for the
timestamp.
jury.
Yes,
Is that something you can do for us?
it is, yeah.
Okay. With the
All
court's
right.
permission, I'd ask Mr. Whiffin to give
Yes.
us a live
So
demonstration.
whip out his tool. No, Emily, no.
The light off would be better, thank you.
Okay, thank you, Dave.
Okay. First of all, I will highlight on the
We're
left
doing
side of the
this.
screen here, this is actually a live representation of what I have on a phone that's in front of me. So as I
Okay.
move this around, you can actually see on the screen that the screen refreshes.
Chat,
I'll
y'all are the
also
best.
point out the iOS version here is 15.2.1, which matches that from Jennifer McCabe's phone. On the right side of the screen is the tool which I spoke about earlier, the one that I've been writing for several years. I make it available for free
My tool.
for any examiner who wants to download it and research.
You can download it at
primarily iOS devices.
www. I'm teasing. We're not,
Here,
but
you can see I've
literally.
got a live connection to the device.
But literally.
So every file and folder that is on the device I can see within this directory view as you would normally see on a regular computer. And we can see the browser state.db database. If I open that database up, you can see there are 4 tables, one of which is called tabs.
Mr. Whiffin, I hate to interrupt you. Can we make this larger? I know jurors are really hoping
I can try to.
have a larger view of what's up there.
Embiggen. This judge is very mindful of the jury, and
better.
I think if she sees any of them kind of leaning forward or
I should be able to work around.
looking like they can't
Better for the
see,
jurors?
she's going to check in with them.
Yes.
And she asks them, is that better for you? And
Let me pull forward.
you would hope that they nod.
Turn the air conditioning off.
So at this moment in time, the tabs table has 2 records. I'm just going to ask that you ignore those for now. They're from a previous demonstration. I can't delete those without taking longer to do this demonstration.
Okay.
If I go back onto the phone itself,
Wouldn't you have like cleaned
just
your
takes a
tool if you were
second
going to show
refresh
it to
and
everybody
open up
today, though?
Safari,
No?
and I
Just
can
me?
open up a new tab.
I'm not going to be able to stop. I'm sorry, Chad.
What I will just do now
Shit's
is
out of the horse.
search for the time that we're on now, so 14:10, and hit go. So right now, that page is loaded. Sure.
What are we looking at? I don't fucking know.
And I can go back into the database
What a
and just
mess.
hit reload. That will bring the most recent version of the database from the device back onto my computer and show it back in this window in exactly the same way as I was viewing it a second ago. And you can see right now there's still only 2 records. So the fact that I did a new tab and a new search has had no effect on what I can see. This is different to on previous versions of iOS, where you would already now see a new record with the 1410 search, which I'd made. I'm then going to do another search.
We do?
Hopefully it's
Where?
catch up with me. It's now 1411, so I'll do a search for 1411.
The Google predictive searches. The Google predictive searches are just
Here we
like,
can see the page is
hey.
loaded, and I can go back over to this tool and reload the database. we still don't have a new record that shows that a search is being conducted. I'll just take the time to do another little search and just do 1411X.
This working for y'all, chat, or?
Reload the page again. Still, nothing's appeared. I can even close down Safari, just minimize it into the background.
No
And
longer
then
app
bring
on
it
the
back
phone.
into the foreground by just pressing the Safari icon.
But somewhere has a severe thunderstorm watch.
I can hit reload again. We still don't have a new record. And I can do a further search
I mean, load was a good
for
record.
now 1412. 1412 is loaded, and I can reload the page. Still no records present. I can now go into Safari and just close the tab.
What are these? What are
So now
the
that tab is
predictive
closed,
searches?
I can just prove that.
Oh my God.
So that tab is now closed. And I can go back over here and reload. And you'll see a new record has appeared. I'm just going to change the time zone just so that this shows accurately. And tell
Well, what was the
my
time zone
tool
before?
to treat the timestamps as Eastern time. So we look at this particular record. You can see the title is 1412. That's the last item that I searched for. You can see the URL is the google.ca /search 1412. Again, that is the content that I searched for. And then we see this field here, the last viewed timestamp. And the time here still says 1410 because that's the time that I first loaded the tab. The fact that I navigated between, the fact that I minimized and reopened Safari bears no relevance to this timestamp. It is purely the timestamp that tab was created or brought back into focus.
Where does it show you at what time you do the search,
To an
though?
untrained eye, can that development of a timestamp become confusing?
Yes, the name last viewed time clearly has implications that would make you believe that it was the time that the page was last viewed. It's a very simple test that I just demonstrated to prove that that's not the case.
Is there any other reason that Cellebrite removed that process of timestamp?
He said because
Other
it was
than
confusing.
clarify that issue?
Objection, Your Honor.
No, I'll allow it.
Purely because we determined it was unreliable to use as a time that the page was last viewed.
If an examiner
So what do you
simply
use?
made a
What do you use to determine when a Google search was queried, though? If not the tab, like what? Where is that then?
report from Axiom or Cellebrite or another software, but didn't have the time or skill to actually go into the data, could they be easily confused by this?
Yes, the way that Cellebrite provided this information showed as last viewed timestamp. The way that Axiom provides this data is called last interaction time. So there is some leeway there to misunderstand it less from Axiom because it's talking about.
That's the question I was waiting for him to answer earlier. Axiom calls it last interacted time, not so last interacted time would indicate last time you interacted with the tab, not necessarily when the search was. That is helpful. I think we've gotten so far afield with everything and lunch. I don't know if the point is lost or not, but I think that is an important point.
Tab interaction rather than a web page that was last viewed.
Thank you.
Last
I have no further
interacted time
questions.
versus
All right, thank you. The lights on, please. Mr.
versus
Leslie?
last viewed.
Your Honor, if I may? Thank you.
I think that was a helpful
You
clarification.
want Mr. Whiffin to take this down?
Yes, please, Your Honor. Good afternoon, and hello again, Mr. Whiffin.
Good afternoon.
And recross.
Magnet forensics Axiom still shows a 2:27:40 a.m. timestamp on its forensic tool, correct?
Correct.
Last interacted time.
And Magnet Forensic is a reliable forensic tool company, correct?
As reliable as they come, yes.
The demonstration that you just performed, When did you create it?
I did it live.
Sorry, the demonstration?
What you just,
Like literally just now as I was doing it live.
so you
Is how
just
you mean?
created the demonstration now live on the stand?
Yeah.
That particular demonstration, yes.
Yeah. So, that demonstration, therefore, was created after Cellebrite removed the 22740 timestamp from all of its tool programs, correct?
No, incorrect. I mean, that demonstration I just provided was right now, it was live. Initially, when I did these tests, I did the same kind of experiment, the same type of testing back in late 2023, I believe. And after I did those tests and used that research, that is when Cellebrite removed the timestamp.
Maybe my question wasn't clear. Let
Yes.
me see if I can rephrase it.
The wires
The
have been crossed.
demonstration that you just gave,
But it's not based on
when did you
Cellebrite
prepare
data,
it?
is
The
it?
demonstration, not just the demonstration that you just showed on the screen. When did you create that demonstration on your computer?
Hey, again,
Just
I've been
now.
doing this demonstration for 2 years.
My question, again, is the demonstration you just gave.
Yes.
When was the last time you altered that demonstration?
Other than to use different search terms, it's the same demonstration.
I'll try it differently.
Yes, please.
When was the last time you altered in any way the demonstration you just gave?
Right now.
So you altered it right now, and that alteration was made after Cellebrite had removed the 2:27:40 a.m. timestamp
I don't think those
from
things
its programs, correct?
connect.
Yes, okay.
Thank you. No further questions, Your Honor.
Mr. Whiffin, you are all set.
Okay. His demonstration wasn't relying on a Cellebrite
Have
report.
you seen why Mr. Whiffin is collecting his items?
Jurors, feel free to
Oh, jurors, feel free to stand up. All right. New witness. Prosecution is going to side by. And it looked like talking to Mr. Yannetti as they get to side by. We are going to zoom. We don't have a lot of zoom room though. So it might be zoom right into continued sidebar. We'll see. Okay, well, I think we're almost still at sidebar. Come on. we're zooming perilously. There we go.
Thank you very much. Your Honor, may I call my next witness?
Please.
Commonwealth calls Jennifer McCabe.
All right, chat. To everyone who said yesterday, we're hearing tomorrow that Jennifer McCabe is taking the stand. There you go. Accurate. All right. Well, I think maybe the text crew will be excited to hear that the next witness on the stand is Jennifer McCabe. This will be the rest of today and tomorrow. Emily, do you think we'll get to cross today? You're already. Everybody's like, can we skip direct examination and get directly into cross examination? No. No, we can't. But here we are. Next witness, witness 12, is Jennifer McCabe. The jury has to just be like, oh my God, finally. We finally see the Jennifer McCabe. Okay. The jury's awake now.
All right, Mr. Brennan, whenever you're ready, Mr. McCabe, I'd ask that you pull the microphone closer. Okay. Thank you.
Thank you, Your Honor.
Go right ahead.
Good afternoon.
Good afternoon.
Could you please introduce yourself to the jury?
Hi, I'm Jennifer McCabe, MCCABE.
Chat. You guys, put a 1 in the chat. Put a 1 in the chat if you're new to this trial. Law nerds, I'm going to ask you to do something that is really difficult. I'm going to ask you to do something that is really difficult. Even more difficult than no name calling Brennan yesterday. Look at how many haven't seen this trial before that are in our chat. Please do your best to not deprive them of what is going to unfold. It's like when you've seen the movie before and you know what's coming and you're trying not to slap the person next to you, being like, wait for it, wait for it, wait for it. It's coming. It's coming. Right. Right. It's so hard. But let's try not to deprive them of letting it unfold, because they have not seen this movie before. I know it's hard. I thank you, chat, because so many have not seen this yet. So buckle up and let's see how it goes. Let's see how it goes. I know we try to avoid the spoilers.
Ms. McCabe,
New trial.
how old are you?
I am 49 years old.
New
Are you
trial.
married?
Yes, I am married with 4 daughters.
New hair. New
Without
trial.
detailing your children's names, can you tell us a little bit about your family?
Sure, I have 4 daughters that are 16, 17, 19, and 21. 2 are in high school and 2 are in college.
In raising your children, was your family active in local sports?
Yes, all 4 of my daughters played multiple sports from when they were young. 2 now are playing in college. My husband and I both coached them. My husband coached them from when they were young up through 8th grade in soccer, and I coached them in basketball.
Without telling me your address, what town are you from?
I'm from Canton.
How long have you lived in Canton with your family for?
I was born and raised in Canton, and now I'm raising my family there.
So your family, their whole life, you've raised them in Canton?
1 year we lived in Stoughton with my daughter.
Who do you live with now?
I live with my husband and my 4 daughters.
Oh, the
Can
sports
you
are
briefly
relevant.
Give me a little bit more background on your children's school and
The
your
sports
participation
are relevant
in
to
interaction with your children, raising
the
them?
searches that we'll show.
Yeah, so I was a teacher, and then once I had children, I stayed at home with them and basically was just kind of like your typical, I don't know, small town mom. I was the room parent. I coached them.
I'll allow it, but why don't we?
Yes.
When I coached, I drove the kids back and forth on my team, would take them places, etc.
So you were involved
The growth of your family and
in
raising your children, did at some point
all
did
the
you
things.
meet a gentleman by the name of John O'Keefe?
Yes,
Share with us meeting John O'Keefe.
sure. When my 3rd daughter was in kindergarten, she became friends with John's niece. And during that kindergarten school year, unfortunately, Kaylee's mother and father both passed away, and John moved in the house and became Mr. Mom.
When John took over guardianship of the children, did you assist in an active role in helping him?
Yes, Kaylee and my daughter were very close, so she would come over and play. My daughter would go over there. Kaylee would come and have sleepovers. A lot of times it would be on Friday nights. I would have Kaylee, and then another individual would have Patrick.
Had you known John O'Keefe well before he took over guardianship of the children?
No.
During the time when he was the guardian of the children, did your relationship, not just with his niece and nephew, but with him, grow any closer?
Yes, we became very good friends.
I got you, Chad.
How close of friends did you become over the years?
Well, throughout the years, obviously, when they were younger, we talked more, just about the logistics of CCD, pickup, drop off, basketball, sports. But then he would also call me, about, as the girls got older, the girl drama or, the hormones and things like that. He would also come over, and hang out and have a beer and, just talk about whatever was new in his life or going on, or, just the day in and day out struggles of his, life and raising the kids now and figuring it all out with, work and family and all of that.
Leading into January 28th of 2022.
I mean, the girl drama in
the jury
junior high
understands
is real.
How close is your friendship with John O'Keefe at that time?
He was a very good friend of mine that I knew I could call for anything.
I want you to take us forward to January 28th, 2022. Do you remember that day?
Yes, I do.
Do you remember it well?
Yes.
Take us to the early morning hours, January 28th, 2022. Did you learn there may be weather or a storm coming?
Yes.
Tell us a little bit about that.
We all saw the report that there was going to be a big storm, a nor'easter. So we all knew that basically all the Saturday activities were going to be canceled.
That includes sports?
Yes.
Was and is the sporting events for the children a big part of your life?
Yes. Back then I had, 2 in high school that played 3 sports, and they played club sports as well. And then the 2 middle school played club sports and town sports. So most of our weekends were taken up by kind of running from one sporting event to the next.
When you learned about the weather and the change in schedule, did it change your plans for that day?
No, not particularly. I had my day was pretty set out. I had my niece, and then I had sporting events. It was kind of my plans for the next day that obviously got changed.
Take us through the afternoon of the 28th. What's happening?
Well, I had my niece for the week, and
Somebody went to a
she was
basketball
picked
game.
up. My oldest was on the hockey team, and she was having a team dinner at the house, so I picked up pizza, got desserts, set it up for them. And then I left with my daughters and my husband, Matt, and we met some of the parents from the high school basketball team at a local pub to grab a bite and a drink before the basketball game, because my other daughter played on the high school girls basketball team.
I didn't realize
What
they
time
went
was the
out
basketball
for
game
food
set
and a
for
drink
that night?
before the basketball
I believe
game.
it was 6 or 6:30.
Did you and your family go to the game?
Where
Yes,
did you
we did.
sit?
After the game, what happened?
After the game, I drove my daughter home. My sister, Nicole, sent me a text and said that she was going to be at the Waterfall, and it was my nephew's birthday. He was going to meet up, and did I want to come by for a drink?
What is your nephew's name?
Brian Jr.
It was his birthday that night?
Yes, it was.
When you received a call to meet with friends and family at the Waterfall, do you remember what time that plan was made?
I don't. My sister sent me a text at some point letting me know she was going to be there, so I'm not.
Yeah, I think having dinner before the game is
I
good
don't
too.
know what time.
After the game and after some time, did you go to the Waterfall to meet your friends and family?
Yes, I did.
Describe very briefly, what's the Waterfall?
It's just a local town bar.
What kind of tables does it
Remember
have?
about what time you got to the Waterfall?
Sorry.
About 9 o'clock.
When you got there, was it
The tables became a meme last trial. I promise. No, I don't promise that we'll let it go. We probably won't.
anybody there that you knew?
Yes.
Okay, now take us inside the Waterfall. When you get there, who do you see?
I walk in and I see
Much smoother
Julie and
questioning.
Chris Albert, my niece Caitlin, my sister Nicole, and my niece's boyfriend Tristan.
You said you saw Julie and Nicole Albert in the Waterfall?
Yes.
Were you related to either of them?
Nicole is my sister.
So Brian Sr. would be your brother-in-law?
Yes.
Also, you mentioned there was
The jury's got to be
a
like,
niece.
Yes, Caitlin.
Is that Brian and Nicole's daughter?
Yes.
yes.
You mentioned the name Tristan. What's his relationship to your niece, to Brian Albert's niece?
He's now her fiance.
And was there anybody else I missed?
That's all who was there. I'm not sure if Nick Kolakidis was already in there when I got there or if he arrived right after. And then his wife joined us.
So when
We
you're in the bar
remember.
and you see your friends, what
We
do you
love
do
the
next?
Kolakithises
I immediately
on this
just,
channel.
join them and sit down.
Were you eating,
The
drinking?
Kolakithises are like, this will be fun.
I know I
Now here we
ordered
are.
a beer. They had appetizers on the table. I'm not sure whether I had any or not.
Were you drinking alcohol that night?
Yes.
As you're spending time with your family, did the night grow?
Yes.
Did you stay at the table where everybody was eating, or did you move inside the bar?
We were pretty much right around the table.
Did anybody you knew join you or join the group at some point?
Yes,
Much
a little
smoother
while later,
questioning.
Brian Albert and Brian Higgins joined us at the Waterfall.
So when you first got there, was Brian Albert already there?
No, he wasn't.
Is that your brother-in-law, Brian Albert?
Yes.
And you
We're
said
gonna have
Mr.
to
Higgins.
differentiate
Did you know
between
Mr.
junior
Higgins?
and senior.
I had met him a few times when he was out with Brian.
You had met him a few times before that night?
Yes.
Were you friendly with him?
He was a friend of Brian's.
Was he your friend?
No, he was Brian's friend.
You knew who he was?
Yes.
So when Mr. Albert and Mr. Higgins joined the group later, did they come directly to you, or did they stay somewhere else inside the bar?
No, they came over to our table, I believe.
How long were you in the Waterfall for that night?
Approximately 9 to little around midnight-ish.
About 3 hours?
Yes.
Do you have an estimate how many drinks you had, alcoholic drinks you might have had?
I don't. I don't know, maybe 2, 3.
Throughout the night, were you feeling any effects of the alcohol?
Not that I recall, no.
When the group was together, you mentioned a number of people have joined. Were you joined by other people later?
Yes.
Who were you joined by later?
John O'Keefe and Karen Reed.
And you talked about your relationship with John O'Keefe?
Yes, earlier, yes.
Did you make plans with him, or did he just show up?
I believe he had started the conversation about the night with Chris Albert.
Chris Albert is a different Albert than Brian Albert?
Yes.
How was the relationship between them?
Brian Albert and Chris Albert are brothers.
Was Chris Albert there when Mr. Higgins and Brian Albert arrived?
Yes. Actually, Chris, did I miss him? Because Chris was there with Julie. Did I? I'm not sure if I said that when I was naming everyone at the table. I apologize.
You may have.
For those of
Okay.
you asking how long
First
she's
got
been on
there,
the
he
stand,
was
not
at the
very
table
long.
with your
Yes.
sister.
She just took
Yes,
the
he
stand a
was.
little bit ago. But I'm time blind, so I don't know how long it's been.
Moments
But
before
we're just getting to them getting
John
to the
O'Keefe
waterfall, and there was
arrived
not
at the
a ton of
defendant,
background.
What was the mood in the group?
Cheerful. Good mood. Everybody was just out having a drink. We all knew the storm was coming tomorrow, and, just a typical average night.
Celebratory?
Yeah.
You said you were going to see Brian Albert Jr. for
Yes.
his birthday. Was Brian Albert Jr. at the Waterfall when you got there?
No, he was not.
Was Brian Albert Jr. there anytime when you were at the Waterfall?
No, he was not.
Without relating a conversation with some other person, did you have an
that's helpful.
understanding where Brian Albert Jr. was?
He was at home.
Where's home?
Did you historically or typically see Brian Albert Jr., your nephew, on his birthday?
Yeah, typically we always, get together. We try to and do a cake for whoever's birthday it is, and then whatever, aunts or cousins are around come over.
When
I'm trying, Chad. I'm trying.
John O'Keefe arrived at the Waterfall with the defendant, do you have a general estimate or guess, not guess, but a general estimate of what time they arrived?
Approximately 11.
When they first arrived, did you see them?
Yes.
Where did you see them coming from?
I saw them walk in.
When they walked in, did you react in any way?
Yes, I was happy to see them
Why were you happy to see them?
because I loved John and I liked Karen.
So you were happy to see John?
Yes, very.
And you were happy to see the defendant?
Yes.
Do you remember your first interaction with either John or the defendant that night inside the Waterfall?
I believe John walked over to where I was, kind of to my end of the table, and then maybe Karen had walked to the other end of the table. But I would assume I probably hugged both of them when I saw them.
I'm going to ask you not to assume if you don't know. That's
Okay.
okay.
Just
You
roll the
said that
tape.
you had known
Just
the
roll the
defendant
tape.
as well.
Just roll the tape.
Yes.
Do you remember how long she had been dating
'Cause there's video.
John O'Keefe up until that point?
I know I met her in July of 2020.
Had you had a chance to spend time or interact with her over that time before that night at the Waterfall?
Yes, I had.
And share with us some of the moments or some of the reasons that you would interact.
The first time I met Karen, John had reached out. We would do pool days with him and his niece and his nephew. So he had told me he was dating a new girl and he wanted to bring her over. He said that she had multiple sclerosis. I also have multiple sclerosis. So he thought that that would be something we could, we would talk and bond over. I said, yeah, great, bring her over. So her and John and Kaylee and Patrick came over. We had a pool day. I liked Miss Reed immediately. I thought we hit it off. It was really great, you know, talking to someone my age that also had MS, because I didn't really know a lot of people who have it. So it was really nice to have somebody to relate to. Then moving forward, we would see them, you know, if it was my daughter's birthday party, when it was time for pickup, you know, they would come in, have a couple drinks. Same thing for like a Halloween party, after basketball games.
So you spent time both with John and Miss Reed?
Yes.
Did you spend time with the defendant separately without John around?
No.
Did you become friendly with her?
Yes.
And were you friendly that night?
Yes.
After John and the defendant enter the bar and you greet, did you interact or spend time with Miss Reed at the Waterfall?
Yes, I did.
And speaking of the defendant, do you recognize her here in the courtroom?
Yes, I do.
Could you kindly point to her and describe an article of clothing she's wearing?
She's sitting right over there with a black shirt or a blue.
Not
Is she
everybody
between
pointed out
Attorney
the
Jackson
defendant.
and Attorney Yannetti?
Yes, she is.
Done it here a few times.
When you were at the Waterfall that night, do you remember who you were speaking to or where you were spending your time?
As to earlier in the night or after?
I'm sorry, after Mr. O'Keefe and the defendant arrived.
Yes, Miss Reed came over and spoke to me because I had seen her the Saturday before, and she had told me how she had started a new medication, and it was giving her some awful side effects. And I said,
saw
I'm
the
shocked
look.
they put you on that.
The jury did too,
etc.
I'm sure.
Let me not ask you about conversations you
Okay.
had, but about the moment that you were in. Did you spend time with Miss Reed that night?
Yes, I did.
Inevitably, did you drink more alcohol as the night went on?
He said inevitably.
believe I had, like I said earlier,
Inevitably, did you drink more alcohol as the night went on? Sir, everyone.
a couple of drinks, 2, 3, not sure.
Did you ever have a shot of alcohol?
I do not believe I had the shot, no.
Did you see the party, the group of friends and family
Somebody-
doing a shot?
I
Bought
was in
shots.
the bathroom and walked out, and they were doing or had just done a shot.
With the court's permission, I'd like to display parts of Exhibit 22, which has already been introduced into evidence, which is
The video.
surveillance footage
I think
from
it's
the
a
Waterfall.
I think it's a good time to use the video from the Waterfall. Look, at this point, the jury doesn't
I'd like to start
know anything
at
other than what they've heard in this trial about
10:54:20,
Jen McCabe.
please.
It's just neutral at this point.
If you could just stop for 1 second. Do you recognize what's in that video?
High top tables. Those are high top tables.
And what is that?
That is the Waterfall.
Okay.
High tops are the tall tables. So those big long tall tables that you can stand at. And yes, the group is behind the timestamp for those of you that haven't seen this before. This video is harder to see than last time. Like it got really bright on the side of the screen, but the group is, hold on, let me move the closed captioning. The group is up at the top, and this is a fixed security camera, so that's not going to change.
Kindly proceed.
The timestamp makes it hard. You can see the band under the timestamp over here. You can see the group at the table over
You could
here.
stop.
And then
You see the
this
two people
got
entering from
super
the
blown
left?
out.
I do.
Do you know who they are?
I believe that is Miss Reed and John O'Keefe.
Ms. Gilman, is there any
They're
way to enlarge the top of the video where the other
apparitions.
people are closer to the table or bar? No. Okay. Looking at this video, can you tell
I
or
have
identify
no idea
anybody under
why the
that
video is so hard to
timestamp?
see.
And if you can't, that's okay. But if you can you tell us who you see?
I think the guy right there, well, where she just is Brian Higgins.
Okay. If you could go up a little bit, Ms. Gilman.
I believe that's my husband, Matt. And
On the
then
right?
on the right, and I think that's me on the left.
Okay. And if you can go down the table to the left, Ms. Gilman. You recognize who that might be from the clothing?
What?
I'd have to take a guess that
Okay,
it
but
could.
don't
Girl.
guess. It's
Okay.
if you don't. Anybody else at the table more to the left do you recognize?
Not from this picture.
Ms. Gilman, could you highlight where Ms. McCabe thinks that she is on that video with that circle you just had and play the video? If you could stop. Is that you clapping, Ms. McCabe?
Yes, it is.
Why are you clapping?
What?
Because I was happy to see them.
Both of them.
Yes.
Okay. Could you continue, please?
Oh, now I see the clapping. Okay.
And who's that person walking right to left hugging people?
That is John O'Keefe.
Can you continue, please, Ms. Gilman? Are you interacting with anybody?
I can't see where I am.
Okay. If you could stop the video, please. Could you
I have no idea why the video is so much
move
harder to
ahead
see.
to 11:26:50, please? 11:26:50.
I don't know if it's the light in the courtroom reflecting
that
on
your
the
group
screen
still at the
or if it's the
Waterfall?
video. I don't know.
Yes, it is.
If you could stop there, Ms. Gilman. If we could hone in or circle where you were previously, where we saw Ms. McCabe. I know it's a bit blurry. If you can, and if you can, please let me know. Can you see whether you're in that area?
I believe I am, yes.
Could you put the circle down just a little bit, Ms. Gilman? Okay. If you could play from 11:26:50 to 11:27, please. We're a little bit ahead right now. Who are you hugging there?
I believe that's Miss Reed.
Thank you. One more, Ms. Gilman. I'm going to ask you to move forward to 11:46.
Okay. The band is packed up. That's when everybody was doing shots. Shot. Emily, stop it.
Could you pause, Ms. Gilman? Could you circle in that same area where
Everything goes
Ms.
off the
McCabe
rails
was
after this.
last describing? Can you make anything out in this video?
Yes, it looks like they're all, toasting or doing a cheer before they do a shot.
Can you see whether or not the defendant's in that part of the video?
Yes, it looks like she is in front of the man in the plaid coat.
Were you participating with the drinking at this moment?
I don't see myself in the video. I don't believe I was.
But you were drinking separately that night, weren't you?
Yes, I was drinking beer.
If you can continue, please. Thank you. Shortly after the shot, was there conversation about leaving the Waterfall as a group?
Yes, there was.
Was there any discussion about where the group should go?
At first, Miss Reed was asking if we could go up the street to D&E.
What's D&E?
D&E is a sub shop that's owned by Chris Albert.
Was it open that late at night?
No, it wasn't.
Had you in the past gone to that pizza shop after hours to eat?
Yes, we had.
And tell us what the defendant was saying.
She just kept asking, can we go up to D&E? Can we go up to D&E? She wanted just to go up and, Chris makes food and then we were going to go she wanted us all just to go up there and eat and hang out.
That wasn't an uncommon occurrence for the group to sometimes go to that pizza shop after hours, was it?
No,
Did the group decide to go to the pizza shop?
they decided they weren't going to go.
Was there a different plan made?
Before Brian Albert left, he said to the group, hey, we're going to go back home and have a beer with Brian Jr. If anyone wants to come by.
When you received the invitation to the group to go back to Brian Albert's house, did you decide whether you were going to go home or go back to your sister's house?
Yes, I decided I was going to go to my sister's house.
Without saying what was said, was there any discussion in the group among the participants about going back to your sister and Brian Albert's house?
Everybody seemed to want to go back.
Did
I mean,
anybody
vibes.
object to going back?
No.
Had you been to your sister's house before?
Yes.
Many times?
Yes.
Do you know the address of where your sister lived?
Yes.
Everybody knows at this
And
point.
so after that conversation,
The jury's like, oh, 34
did you
Fairview.
stay at the Waterfall
Right.
for a little bit, or did you leave immediately?
Probably left after maybe 5-10 minutes.
Without saying what was said, before you left, did you have a chance to speak to John O'Keefe?
I did, yes.
You spoke to him inside the Waterfall?
Yes.
Did you have a chance to speak to the defendant?
Yes.
And was your plan to go back to your sister's house?
Yes.
Before you left, did you have any understanding whether or not Mr. O'Keefe and the defendant were going to join you?
Did you have another understanding regarding that?
Yes.
And what was your understanding?
They were coming.
Who else was going to go back to your nephew and your sister's house?
Brian Higgins and my niece Caitlin.
A little after 12, did you leave the Waterfall?
Yes.
Do you remember that night leaving?
Yes.
Before you left, did you talk to anybody in particular?
Yes. Miss Reed and then Mr. O'Keefe.
Did you speak to them inside the Waterfall?
I walked out with Miss Reed and we spoke at the doorway and then John joined us.
Did you invite Miss Reed to come with you?
I did, yes.
Did she decline?
Yes.
And who did you go to your sister's house with? Who drove?
I drove and I went with my husband, Matt.
Anybody else?
No.
Do you remember about what time it was that you were speaking to Miss Reed about going to your sister's house?
After midnight.
If I could have Exhibit 22 again. Ms. Gilman, if you could take us to 12:10:36.
The questioning is much, much smoother in this direct versus direct last time. So these are direct questions because they don't presume the answer. They are yes, no, but they are direct questions. A lot of it's background, which is why there's not a ton of objections to the form because they're not all leading, even though they are yes, no.
Okay. If you could stop it there, please. Did you have a chance to talk to Mr. O'Keefe and the defendant outside of the Waterfall?
Yes.
And do you know specifically what time you left the Waterfall?
It was after midnight.
After, okay. When you left the Waterfall with your husband, you said you were driving. Did you stop anywhere along the way before you got to your sister's house?
No.
Tell us what you see when you get to your sister's house. What are the weather conditions like as you're driving there?
It's starting to snow to the point where it's starting to like accumulate. It's on your car. It's just, getting on the street.
Is it light? Is it heavy?
It's light at this point.
How long does it take to get from the Waterfall to your sister's house?
5 to 8 minutes, depending on lights and weather, etc.
When you first get to your
Specific.
sister's house, while you're still in the car, describe
I
what
still
you
haven't
see.
said the address.
My wipers are on. I'm just looking out the window and it's snowing. It's dark.
Anybody in the driveway? Any cars in the driveway that you see?
Oh, when I pull up to my sister's?
Yes.
As I pull down the street, I take a left into the driveway, and there is a Jeep that's parked on the street, and there's maybe a couple of cars in my sister's driveway.
What do you do when you arrive at your sister's house?
I go in the house.
Now, there are a couple doors at your sister's house.
Yes.
Is there a front door?
Yes.
Is there a side door?
Yes.
Which one's closer to the driveway?
The side door.
Which door do you go in when you get to your sister's house?
The front door.
Was anybody with you when you went in?
My husband, Matt.
You walked in together?
Yes.
Tell us the first person you remember meeting.
When I went in the
Seeing.
house?
Yes.
Probably my niece was at the table, and then I saw my nephew, Brian.
Was there anybody else you saw at the table?
Julie Nagel and Sarah Levinson.
So when you walk in the front door of the house, is it what table? Is this a living room table, a kitchen table?
Oh, you walk in and then you go to the right and it's into the kitchen and there's a table there.
Is the kitchen separate from the living room or is it open?
It's open, but they're separate.
Can you see the kitchen table when you walk in the door if you turn and look right?
Yes.
And when you go into the kitchen, you said there was a woman by the name of Julie Nagel
Yes.
and then another woman, Sarah?
Yes.
You know her last name?
Levinson.
Okay. Julie Nagel, did you know her when you walked in the house that night?
I had met her a few times.
Had you spent time with her? Were you friends with her?
No, I just had met her a few times, and she had watched my dog for me when my nephew couldn't.
When you would go away, would your nephew be responsible to watch your dog?
Yes.
Did you understand that Julie Nagel had watched your dog a couple of times?
Yes.
Had you ever socialized with her before that night?
No, I may have seen her at a graduation party, but never beyond that.
Were you friends with her at that point?
No.
Friendly enough that she watched your dogs?
But
Yes, through my nephew. He just said my friend's going to do it, and I
it's your nephew's
trusted
friend.
his
You're not friends
judgment.
with the
And there
kids.
was another woman by the name of Sarah. Did you know her before you saw her that night?
I know they're
I
in their
knew
20s,
of her.
but
If I were to see her, I'd say hi, but that's the extent of it.
How did you know of her?
it's your nephew's
Just from
friends.
being in the town, going to different sporting activities, and just being around.
You said your nephew Brian was there as well in the kitchen.
Yes.
This was his birthday?
Yes.
How old was he?
I think he was turning 23.
Was there anybody else in the house when you and your husband first got there?
Yes, my sister and Brian Albert and Brian Higgins.
So Mr. Higgins, Brian Albert, and your sister were there before you.
Yes.
Where was everybody when you first came in?
My niece Caitlin, Sarah Levinson, Julie Nagel, and Brian Jr. were all at the kitchen table. My sister was over, I think, cleaning the counters, and Brian were off in that TV room that you can see from the kitchen because there's a wide opening.
If you walk in the front door, would I look left or right to see the TV room?
You look right to the kitchen, and then through the kitchen's the TV room, but you could look, and when you walk in, you can see because it's open.
Is the TV room in any way have a relationship with that side door?
Yes, it does.
If you were to walk in the side door, would you be walking into the TV room?
Spoilers.
Yes.
Hang in there. Hang in there.
When you saw your nephew Brian Jr. and his friends, are his friends about the same age as him?
Yes.
Were they drinking?
Yes.
Was there music?
Yes.
And when you went in, did you spend time with the group?
Yes, I sat right down and started talking to them.
And when you were speaking to them, did you have any drinks that night?
I believe they brought me over a White Claw. It was at that point where I just didn't want another drink.
As you were in the kitchen, were you expecting anybody else?
We had mentioned it to Karen and John, and I had actually just spoken to John, so I was expecting them.
So when you saw John O'Keefe in the Waterfall, that wasn't the last time you spoke to him?
No.
You had spoken to him, was it on the ride to your nieces? To your sisters?
Yes.
Did you call him or did he call you?
I didn't see it
He
skip,
texted me, and I believe
if the feed
asked
stuttered.
something like, where to? And since I was driving, I called him.
I didn't see it.
When you called him, what did you tell him? What did you guys say?
I just said they live 34 Fairview Road off of Chapman.
Do you know if John O'Keefe had ever been to
Now we hear
the
where they
Albert home
live.
before?
I don't believe he had.
In that conversation, how long did that conversation take?
It was quick.
Was there any other conversation that you had with him other than that one conversation?
Yes, he called me back, and he was trying to find it,
Trying to find the address?
try to find the house on Fairview.
Did he ask you for help trying to find the address?
He, not sure his exact words, but yes, he needed help. And so I just said, I told him, just go down the street, go by Bella's house. It's at the bottom of the street.
So you used Bella's house as a point of designation to try to guide him to get to your sister's house?
Yes.
Tell us who Bella was to John.
Bella is my daughter and John's niece friend. So so Bella is friends with my daughter, John's niece.
The Bella child.
And was there any relationship between Bella's mother and John that you knew of?
Did they go to sidebar over Bella? Damn it! This is the skin of a killer, Bella. I can't help myself. They are going to sidebar over the reason I said the Bella child is because that's how Lally referred to Bella in the last trial, and I'm still not over it because it was like the Bella child's house. So it's stuck in my brain. I can't not. So we've gotten to the point where she said, I'm on the phone with John. I'm trying to tell him where we're at. And I'm like, it's just past Bella's house. Like, go down the street. It's by Bella's house. We're trying to get into the fact that, well, what if any relationship between the Bella child's mother and John O'Keefe, even though kids were friends, we have very, very little zoom room. So we're going to zoom the zoomy room. Oh, we're going to run out of room. There's not enough room to zoom because they're still outside. Bah. All right. We are.
Sister's home and went in.
Nope. We did have a little more zoom room. I just went slowly. All right. There we go.
Thank you. May I?
Yes.
That second phone conversation you had with John, do you know about what time
Did she
that
say
was?
second?
I don't, it would be after 12:15, but before 12:30, approximately, between that.
Were you still driving when you had that conversation?
Yes.
And at some
He
point
lost
you told
that
us you
objection.
arrived at
So it's not.
your sister's home and went in.
Yes.
Like the movie.
The Bella's mother, whatever, came in a little bit through Carrie. I don't even know if the jury would remember at this point. Maybe not. I don't think it's a massive point, but he wanted to get into it. The court clearly said no, and we're moving on.
Move forward
to
now
the
to
phone
when
calls.
you were inside the house. Tell us generally when you first got there and saw everybody, what were you doing?
I
we
just
just do
sat
that?
down at the table. I started talking to them. We were listening to music. Typical night.
Anything stand out as far as music or interaction with the group?
It's raining,
We
men.
were just laughing,
Howling.
telling stories. At one point,
Sorry.
I'm not sure if it was at some point, my other nephew had been over my house and had shown me this video on his phone, and it was a family inside joke. The video, it was a music video from a long time ago. And so I was telling my other niece and nephew, oh my gosh, you have to see this video. It's hysterical. And then we started playing it and watching it.
What was the video?
It's Raining Men.
Did that get a lot of playtime during that get-together?
Well, I have one sister who sometimes has a little too much to drink, takes out an umbrella, and will...
What? You're telling me that there are people in this sphere of conversation that drink too much? I'm so surprised. The shocks will never end, chat. The shocks will never end. The shocking testimony. Why is this video important? Because it is in her phone searches, and they are trying to pin back the time of when the phone searches are to the time that this is happening. I am being facetious. We know, we heard well about the drinking last time, but we're letting the It's Raining Men explanation just play out. I will say, if you're going to watch a video on the internet to laugh at that is even slightly rain related, and it's not really to laugh at, but to marvel at, it's going to be Tom Holland lip syncing Umbrella. That's the video you pick. I mean, not to judge what is being YouTubed, but you go with Umbrella. Do you not?
This video, it's hysterical. And then we started playing it and watching it.
What was the video?
It's Raining Men.
Hallelujah.
Did that get a lot of playtime during that get-together?
Well, I have one sister who sometimes has a little too much to drink, takes out an umbrella, and will dance. So it's a family joke.
While you were at your sister's house, what area of the house were you spending time in?
It's giving Kyle Richards pre-sobriety, doing the splits at every party she was at. That's that.
Kitchen.
What was the mood of everybody in the house, as far as you remember?
Drunk.
Everybody was in a great mood.
Was there any fighting?
Sorry.
No.
Any
Good mood.
arguing?
No.
Any violence?
No.
Was it a celebratory mood?
Yes.
As you were in the house, were you waiting for anybody else that you expected to come?
Yes, I was expecting John and Karen to come.
At some point when you're in the kitchen, or let me ask you a little background. As you're in the kitchen of that house, can you see outside from the kitchen area?
They had blinds or something down, but if the blinds were up, you could see out.
Were the blinds up?
No.
At any point were you able to
Yes,
see outside
Carrie.
from inside the house?
Sonia Morgan.
From the front door, yes.
Does the front door, is it glass?
Yes.
At some point when you were with everybody in the celebration, did you have a chance to look outside?
Yes.
And when you looked outside, what did you see?
I saw a dark SUV out front.
Did you know whose SUV that was?
I believed it was Karen's.
Could you see who was in it?
No.
At that point of night, what does the weather look like from the front door?
It's dark and it's snowing, and I could see, brake lights.
Did you see if that SUV moved at all?
I didn't see the SUV actually move, but I saw it in a few different locations.
How many times did
A
you look
few?
out?
Can't give you an exact number of how many times I looked out. I can tell you I saw the vehicle first straight out from the front door. Then I saw it up at the flagpole, and then I saw it further up from the flagpole.
Were you studying the car at all?
No, it was quick glances.
Did you have any reason to study it?
No.
What were you expecting was going to happen?
I was expecting John and Karen to come into the house.
Did they ever make it in the house?
No, they did not.
As you were waiting, were you doing anything else in addition to waiting for them to come in?
Yes, so I was sitting at the table. Someone made mention of a car out front, so I got up, went to the door, looked out, and then I would go back to the table, and where we were just all laughing, talking, playing music, just hanging out, not really thinking much about anything.
Did you ever reach out to John when you thought the car out front was the defendant's
sorry,
car with
Brennan,
John
the
in it?
what?
Did you ever reach out to him?
Yes, I
How
did.
did we not go full
How
car
did you
there?
reach out to him?
I texted him.
Do you know if there was a phone call that was made to you before 12:30?
She already talked about it twice.
From John?
Yes.
I don't.
You mentioned you had spoken to him about directions. Is that the last time you heard his voice?
Yes.
When the car was out front, did you exchange text messages, or were you simply texting him?
I was texting him.
Do you remember what you were texting him?
The first time I said here,
What do you
Question
mean by
mark?
here? Was that
like
exclamation point?
hair question mark, because that's when I saw the car.
You were wondering whether that was him?
Yes.
Did you send any other text messages that you can remember?
After I saw the car move locations, When I saw it go up to the flagpole, I said, pull behind me.
I think
And
it's
do you
helpful to
remember any other
have this testimony after we saw the timeline. I think it is a very good timing because the jury will probably remember a number of those text messages that they just saw in the timeline from Ian Whiffin. So they now have something to check it against. It's like, oh, we saw that timeline of when those texts came in because it was just in the last witness. It's a good use of timing. We'll see how it goes, but it's a good use of timing.
Communications you had with him, was he texting you anything?
No,
Did he ever text you again that night?
he never texted me again.
Never called again?
No,
Did you continue to text him over the next 15, 20 minutes?
I did, yes.
And so at some point, did you realize that John O'Keefe and the defendant weren't coming in the house?
Yes, when the car was gone.
Did you ever go outside through the storm down to the flagpole to speak to them?
No.
Why not?
Why would I?
I was just asking.
I had no reason to.
So when you were in the house, at some point, did you notice that that car was gone?
Yes.
Were you marking the time or keeping track of it?
No.
After you didn't see the defendant's car anymore, did you stay?
Yes.
How long do you think you stayed for at the house?
Why would I?
I stayed till about around 1:30, 1:45-ish.
Did anybody else come in the house up until 1:45?
No.
Did people leave at certain times?
Yes, people did leave.
Who was the first to leave?
Brian Higgins?
Do you remember about what time he left?
I don't.
And after Mr. Higgins left, do you know who left?
I'm not I believe it was us, and then my niece Caitlin was also like at the door. It was kind of in a row. Brian left, and then a little bit later, I think it was.
Which Brian?
Myself, Matt, Julie, and Sarah left, but Caitlin was at the door. I believe she was waiting for her ride.
How much longer after Mr. Higgins left did you leave?
Maybe a half. I honestly can't say. I think he was there for a while I was there. So maybe he left anywhere from 15 minutes, approximately 15, 20 minutes before I did, or maybe a little more.
You mentioned that you had left the Waterfall after midnight,
Yes.
and you had phone calls with Mr. O'Keefe along the way.
Yes.
Do you know that there are phone records with your text messages and phone calls in them?
Yes.
And do you know whether your phone records reflect the time of your calls with Mr. O'Keefe
I mean,
Yes.
and your text messages?
Okay.
Yes.
When you were texting Mr. O'Keefe, when the Lexus or the car was in front of the house, rather, was Mr. Higgins still there?
Yes.
What are some of the things that everybody did along that night before you left? What happened in there?
What happened inside the house?
Yeah.
Nothing. We basically
What happened in there is an interesting phraseology, Mr. Brennan. I'm just gonna back that up. I'm just gonna back that up and remind the chat. Thank you for no spoilers. There's a lot of people joining us that have not watched this trial before. We will get there. We will get there. We will get there. So just, I know. And thank you.
Car was in front of the house, rather. Was Mr. Higgins still there?
Yes.
What are some of the things that everybody did along that night before you left? What happened in there?
What happened inside the house?
Yeah.
Nothing. We basically just sat around the table, talked, laughed, listened to music, chit-chatted.
Celebratory?
Yes.
Was there ever
AJ wrote down
any
that question.
fighting?
What happened in there? You know he did.
No, none at all.
Any arguing?
None at all.
Any physical interaction?
No, none.
People didn't hug.
When you
High
decided
five?
to leave that night, did you say around 1:45-ish?
Yes.
When you left around 1:45, was there any events that happened that night that would cause you unrest or excitement or your heartbeat to raise?
What?
No.
When you decided to leave, you and your husband, where were you going to go?
We were dropping off Julie Nagel and Sarah Levinson, and then we were going home.
Had you planned on dropping them off earlier in the night?
No, when we got there, Julie's brother had pulled up to pick them up, and
I won't ask you what was said because you weren't there.
Oh,
but
okay.
At some point, did you come to an understanding that you would give them a ride home?
Yes,
Did you offer?
yes.
Who was going to drive home between you and your husband?
Matt drove home.
When you left, I want you to describe as you step out into the driveway or the walkway. Was it the front door or side door, if you remember?
I walked out the front door.
Is the weather like it was when you first got there?
No, it's picked up.
Tell us what you mean by it's picked up.
So as I walk out, you kind of go, the walkway is to the left. So I walk down the steps, I go to the left. The snow was coming, it was cold, the wind was picking up. So I kind of just like curled up and ran to my car quick to get in.
What part of the car did you get into?
Front passenger,
Who was driving?
Matt.
And where were the other two people?
Sarah and Julie were in the back seat.
Who was in which spot?
I'm not exactly sure.
So both of the young women were in the back seat?
Yes.
Was there any conversation when you got into the car?
We got in the car and they were teasing me
Why were they teasing you?
because I had like bread and maybe peanut butter in my car.
Why did you have bread and peanut butter in your car?
Well, it's
I
snowing.
had my niece for the week, and I was dragging her like to all my kids' sporting events. So we'd go from like one game to another game to a practice. So sometimes instead of always giving her McDonald's or Dunkin' Donuts, I'd try to throw her a peanut butter sandwich.
And they were making fun of you?
Yeah.
As the car backs out of the driveway,
I imagine at 1:45 at night, they're like, can we get a sandwich? Like, can we get a sandwich? Can we get a sandwich? I mean, it's snowing. Can we just get a sandwich?
tell us what you're doing.
I'm talking to the girls.
You just moved your head.
Yes.
Does that mean anything?
Yes.
Tell us.
They were both sitting behind me, so I was like turning and,
I'd be like, get me a sandwich.
chatting and talking.
After your husband pulls out of the driveway,
Like for
you
real,
start
for
to
real.
drive home.
Yes.
If the house is on my right and you're driving,
The fact that we don't know at this point if it is crunchy peanut butter or smooth peanut butter is kind of off-putting to me. I just need to know. I need to know. Chad, I'm being facetious. I've seen a lot of you saying that you think her testimony is coming off rehearsed. I don't think the jury will see it that way. I don't at this point. We'll see how it goes, but I don't think it will read that way at this point.
are you in the passenger seat closest to the house or furthest away?
Passenger seat closest.
So you're driving, if you look at a picture of the house, you would be driving from right to
The
left?
questions are
So as you start to drive or your husband
the
starts to drive
questions
the car,
are very pointed.
what direction are you looking in, if you remember?
The back seat.
Did you drive by the front of the house, do you know?
We pulled out of the driveway and went up Chapman.
Okay. And
That's not what he
your
asked.
husband and you,
That's not what he asked. Did you pull by the front of the house is what he asked. The questions, and I've seen a lot of questions about the questions. The questions, a lot of them are not leading. They are very direct, but they are open-ended. Some of them are direct, yes, no, but they are not leading questions, but they are much more succinct, which keeps her from explaining. She's probably also been told, just answer the question you are asked. Do not add anything else into it. And so her answers are much more succinct, and the questioning is also much better. So it allows for more succinct answers. I don't think that this will read as scripted. To those of you that watched trial last time, it's going to be a very different testimony, but the jury didn't. So we'll see what happens. But no, so far, I don't think it will come across to them as rehearsed because the questioning is better. She's not trying to cram answers in where they don't belong, except for that last one is really the first time she has sidestepped a question.
The back seat.
And
did you drive by the front of the
I
house, do you know?
backed it up a little.
We pulled out of the driveway and went up Chapman.
Okay. And your
Sides.
husband and you passed by the front of the house?
Yes.
Did you pass by the flagpole?
Yes.
Were you looking at the flagpole?
No.
And how dark was it at that point?
It was dark.
Snow?
Yes.
As you're passing the flagpole, do you hear or see anything remarkable?
No, I'm not really paying attention. I'm just chatting to the girls, and Matt's just focusing on driving.
When you're talking to the girls and they're making fun of you, what's the mood in the car?
We're all
They
laughing
were
and joking.
teasing.
Where do you go next?
We drive Julie Nagel home.
After you drop off Miss Nagel, where do you go?
We drop off Sarah Levinson.
Is the weather constant?
Yes,
After you drop off the young woman in separate spots, where do you go?
we went home.
Can you tell us when you get home what happens next?
We go in the house. I go up to bed. Matt makes himself a snack, and then joins me upstairs.
Do you have
What was the snack? There were peanut butter sandwiches in the car. I have questions.
a telephone?
I want the details about the snack.
Yes.
An iPhone?
Yes.
I want the details I haven't heard before.
When you go to bed, do you stay up at all?
Yes.
Do you use your iPhone?
Yes, I do.
What were you doing?
I texted a few people, and
I don't know what the
then
background
I
noise is in
did a
court
couple
chat.
of Google searches.
And what were the searches for?
One, my daughter had played in a basketball game earlier in the night, and it was a very good game.
That's
So I
not
went and
the
I read
answers.
the report on it. And then my other daughter had an offer to play on a basketball team. So we had to make a decision about whether.
And that's what I mean about not answering the question. I said she had done a very good job. This time there is a lot of exposition. What did you Google? Answer it. Answer the Google. And then he will say why, or he won't say why. But you don't need to tell us the why before you give us the answer. I know why she's doing it. She's very defensive about the Google searches. I understand why the explanation needs to happen first. But that's not the answer. Did you do Google searches? Yes. What did you Google? There's a lot of over-explaining in that. I'm going to back it up because I interrupted.
When you go to bed, do you stay up at all?
Yes.
Do you use your iPhone?
Yes, I do.
What were you doing?
I texted a few people, and then I did a couple of Google searches.
I want to see those
And what were
texts.
the searches for?
One, my daughter had played in a basketball game earlier in the night, and it was a very good game. So I went and I read the report on it. And then my other daughter had an offer to play on a basketball team. So we had to make a decision about whether or not we were going to accept the spot. So I was just looking up that basketball club.
Other than those regular searches that one would do, was there anything remarkable about what you were searching at 2:27 that time frame?
No.
Judgment.
After you were looking at websites for your child's sports, what did you do?
I put my phone down and went to sleep.
And up to that point, had there been any discord or fighting or arguments in your world?
No.
Peaceful night?
Yes.
Did you go to sleep, Miss McCabe?
Yes.
Did you sleep through the night?
I typically get up to go to the bathroom, so that I could have gotten up possibly to go to the bathroom.
Did anything remarkable happen in the early morning hours of January 29th?
If there was ever a stream to sponsor by Remarkable.
That peaceful mood into something else.
Today would have been
Yes.
today.
I want you to share with the jury the first
What
thing that
happened
happens
next?
that changes everything.
Well, the demeanor changed. Brennan is just like, we're gonna just piece this story out. I'm backing it up again because that was immediate. That was immediate with the dramatic questioning from Brennan.
Did you sleep through the night?
I typically get up to go to the bathroom, so
Just
that I could
immediate
have gotten
change.
up possibly to go to the bathroom.
Did anything remarkable happen in the early morning hours of January 29th, 2022 that changed that peaceful mood into something else?
Yes.
I want you to share with the jury the first thing that happens that changes everything.
At 4:53, my phone rings, and I look at my caller ID. I look at the phone, and it's Kaylee, John's
Kaylee?
niece. John's niece. And I say hello, and she said, yeah, well, basically, she relayed to me that. Next question.
When you pick up the phone, could you
I'm sorry, chat. Dr. B walked in to ask me questions and I missed what happened and I saw the face. So what do we need? It's out there. where it was. Why? What's happening? Dr. B. He's looking around my office for stuff. I'm like, don't talk about stuff. What is happening? I gotta back it up. I gotta back it up. From the dramatic questioning, Kaylee called. We did know this. We did know this before. Kaylee called. This all came in last time. So that's where I had gotten to, and then I got interrupted. But Dr. B has no idea who John McCabe is. He's like, I don't know what's going on.
That peaceful mood into something else.
Dramatic questioning.
I want you to share with the jury
for the third
first
time.
Thing that happens that changes everything.
At 4:53, my phone rings, and I look at my caller ID. I look at the phone, and it's Kaylee, John's niece. John's niece. And I say hello, and she said, yeah, well, basically, she relayed to me that.
Next question.
It is
When you
hearsay.
pick up the phone, could you hear a voice on the other end?
However, there are exceptions to hearsay here, and I think this would fall under the hearsay exception, and we'll see if we get there. I think this would fall under the hearsay exception of effect on the listener. So the only way to really explain what she did next is to explain what she was told or what she heard. You're not offering it to prove that the thing that person is saying, like the thing Kaylee's saying, you're not offering it to prove that that thing's true. You're offering it to explain why she does whatever she does next. So there's an exception there. So we'll see what happens.
Right?
I heard a voice and a lot of screaming.
And the voice you heard, is that Kaylee, John's niece?
Yes,
And the screaming, was it a man or a woman screaming?
it was a woman,
How loud was that person screaming?
very loud.
Could you make out anything that person was saying as they were screaming?
My name was screamed a lot. And then the other individual ended up getting on the phone with me.
And who
Who
was
was
that
that?
person that was screaming in the background?
Miss Reed,
How long was she screaming for while you were speaking to your niece before you spoke to her?
Not her niece, John's niece.
the entire time I was speaking to Kaylee, she was screaming.
Describe her demeanor.
Miss Reed's,
Yes.
Jen! Jen! And then she's screaming that John didn't come.
He didn't ask you to act out the demeanor. He asked you to describe it. Yep, there's always a point where testimony turns, maybe.
The entire time I was speaking to Kaylee, she was screaming.
Describe her demeanor.
Miss Reed's,
Yes.
Jen! Jen! And then she's screaming that John didn't come home. She left him at the waterfall. She was hysterical. It was very hard to follow what she was saying.
How long did that first call last for?
I still don't know why it's not. She was beside herself. She was freaking out. She was hysterical. She was upset. I don't know why you don't just describe it. I don't know.
I'm not sure how long, maybe possibly a few minutes, but it was loud enough and long enough that my husband shot up in bed thinking one of my kids had come in the room screaming.
That calls for speculation.
Without saying what your niece said, could you describe your niece's demeanor?
It's not her
when you first spoke
niece.
to her? I mean, John's niece's demeanor.
Fuck's sake. Also,
I would say
there's a hearsay exception,
Kaylee
Brennan.
sounds
Just
concerned, uneasy.
fight for it.
During that phone call, other than the screaming and the screaming of your name, did the defendant give you any information other than she had dropped John off at the waterfall?
They had gotten into a fight. She had left him there and he didn't come home.
And when you were woken up, were you in a sleep when you were woken up?
Yes, I was sound asleep.
What was your mental state like when you first woke up and got that call?
Well, I had been up late. I had taken my medication that I take for my MS, so I was definitely a bit groggy when I first woke up. So immediately,
Did she stay outside?
I'm not sure.
That skip I saw. I'm going to back up. I don't know why it skipped. Oh, that's the feed. Hold on.
and that was the extent of it.
I don't know where we were because it completely jumped. So let me see if I can find where we were.
Shoe sizes, and he was going to.
Oh, shoes. I don't know. We were at Groggy, but I don't know how far back that is.
So immediately I just.
Yes. That's pretty close. Okay. Okay. There we go.
Wanted to help her. She was hysterical. Kaylee was upset. So I went into that kind of mom
only
mode of
overlapping a
what can
little.
I do? How can I help? So I immediately was like thinking, okay, well, if you left him at the waterfall, let me think who was still there, or, you know, how can I help you? How can we find John?
Did you have a plan when you ended that first call?
I did.
You know what, I'm going to back up I'm going to back up just a little bit more because she was talking about being groggy, and I don't know if she repeated herself.
Other than she had dropped
So I backed
John
up
off the
again.
Waterfall.
They'd gotten into a fight. She had left him there, and he didn't come home.
And when you were woken up, were you in a sleep when you were woken up?
Yes, I was sound asleep.
What was your mental state like when you first woke up and got that call?
Well, I had been up late. I had taken my medication that I take for my MS, so I was definitely a bit groggy when I first woke up. So immediately I just wanted to help her. She was hysterical. Kaylee was upset. So I went into that kind of mom mode of what can I do? How can I help? So I immediately was like thinking, okay, well, if you left him at the waterfall, let me think who was still there, or, you know, how can I help you? How can we find John?
Did you have a plan when you ended that first call?
I did. I knew Chris Albert had still been at the waterfall when I left. So I thought if Karen and John had gotten into a fight, maybe Chris had walked out of the bar, and Chris lived local to the bar, thought maybe they walked back to Chris's together.
So what did you do?
So I called Chris Albert's wife, Julie.
Did you speak to her?
No, she never answered.
After you had a moment to make a phone call and think about things, did your head become any more clearer?
It did, and I was, reminded by my husband that we had seen Karen in John's car
You
outside
didn't remember.
of Fairview.
When he reminded you, did you independently remember the text messages that you sent to John earlier?
That's
that evening?
leading.
Immediately, I was like, oh my God, you're right.
Did you remember that you had seen what you believed to be the defendant's car in front of the house and near the flagpole?
Objection. Watch the form.
Okay. What did you remember? What came to mind after you spoke to your husband about your memory from earlier that evening?
The minute he said it, I remember seeing the SUV, and then all the text messages that I had, and the phone conversation with John.
So after the defendant spoke to you and said she had left the defendant at the waterfall, and you had time to think about your memories, did you react or do anything with that?
Yes, I believe I called Kaylee back.
Why did you call Kaylee?
I didn't have Miss Reed's phone number.
When you called Kaylee back, did you speak to anybody?
Yes,
wasn't
I
me.
believe
That was in
Kaylee
court.
and then Miss Reed.
When you first spoke to Kaylee, could you hear anything other than Kaylee?
The screaming,
Was it any different, or was it similar to the first time you spoke by phone?
similar to the first time.
Regarding the demeanor or intensity, had it changed at all?
Not at all.
You mentioned the first time that you had that phone call, the defendant was screaming your name. Jen,
Yes.
Jen, Jen. Was she saying your name in the second call, or was it just general screaming?
My name, and then when she got on the phone, I had told her, Karen, I saw you guys outside of my sister's house. And then she told me she didn't remember being there. And then she went on to say, she started saying, could I have hit him? Did I hit him? And then she just was just all over the place, like screaming my name, screaming so many different things. She was hard to follow or understand.
When she was saying to you, did I hit him? Could have I hit him? Was that before or after you informed her that you had seen her out front of your sister's house?
It was after I told her that. She also informed me that she had cracked her taillight.
In that conversation, she told you that?
In one of the conversations I had with her in my bedroom, yes.
When you told her that you had seen her out front, and she had said that she didn't remember, that night. Was that before or after she was saying, did I hit him? Could have I hit him?
Can you repeat the question?
So
Sorry.
she was telling you about that she didn't remember that night.
Mm-hmm.
Was that before or after you had told her about seeing her car?
When I said I saw her at Fairview, then her response was she didn't even remember going there.
Did she ever deny that she came to Mr. O'Keefe's house? I mean, to your sister's house?
No.
When she told you or said to you, did I hit him or could have I hit him or something like that, did you have any idea what she was talking about?
No, I didn't pay attention to it.
When she told you that
Nobody
she had
seems
cracked
to
her
have.
tail light the night before, did that have any significance at that time to you?
No.
So in telling you these different things, did you ever piece them together at that time?
No.
What was your primary motivation at that point?
I just wanted to help her because she was hysterical. Kaylee was very upset, so I wanted to help her, and I wanted to find John.
So after she told you these things about whether she could or did hit her and the light and not remembering, did the conversation end or did it progress?
At some point, I was then going into like, okay, well, if she brought him there and left him there, where was he? Because he never came in the house, and she doesn't know where he is, so now where could he be? So I started thinking there was another gentleman that was supposed to meet us out at the bar who John was friends with. So I thought, okay, well, in my head I'm thinking maybe they got into a fight, John got out of the car, and he connected with this guy because he was at a party on the street.
What was that
over.
person's name?
What?
His name is Tom Beatty.
What?
Did you call him?
Yes.
Did you get a
What?
chance to speak to him that night?
That morning?
Yes.
No.
What?
Did you call around anywhere else?
I believe I called my sister. I called John. I called Tom Beatty. I called his daughter.
What?
You called John O'Keefe's phone?
Yes.
Did he answer?
No.
Did it go right to voicemail?
I don't remember.
Did you text anybody?
Yeah, Chad, I'm with you.
I honestly don't remember if I texted. I primarily think I was just trying to call as many people as I could.
Anything that's new to us is not new
and
to
try
this
figure
jury.
out what
so.
happened.
So you had two conversations.
Cross is gonna be
at this
interesting.
point with the defendant while you were still home.
Yes.
Was there any further phone calls that you had before you did something?
I'm not sure if I know I went downstairs to make coffee because my plan was to go with my husband. I said, come on, let's just go over to Tom Beatty's. Let's see. Maybe John's there. He passed it on the couch. I'm not sure if Karen called me again or not. It's a little foggy because there was so many calls and everything.
And so that morning when you're receiving calls, did something happen?
Karen showed up at my house.
How did you know Karen showed up at your house?
I could hear her screaming out front.
And about what time is this?
Approximately 5:20, 5:30. I can't be
Were
sure.
you worried for John at this point?
Not particularly, no.
Were you screaming?
No.
Now at this point, this moment when you hear her outside of your house yelling, early morning hours, did you know a person by the name of Kerry Roberts?
I knew of her. I'd met her once.
Were you friends with her at that time?
No.
Had you socialized with her at that time?
No.
Had you ever seen her before with John?
Once.
Tell me about that.
$3.
Years earlier.
What in the...
As I said earlier, I used to take Kaylee on Friday nights, and Kerry was the one who would take Patrick on Friday nights. So we would each have the kids. And to thank us, one day John told us how he got a discount at Reebok and to get our kids' shoe sizes, and he was going to buy us all sneakers, just as a way to say thank you for helping. So we all went to the store together, and then John took Kerry and myself to the hillside for lunch.
How many years before this moment was that?
Oh, gosh. Well, I think that's when my daughter was in kindergarten or first grade, and at this point she was in 8th grade. So
I'm trying not to spoil
like
it.
7 years.
Had you ever
so
spent
hard.
any other time with Carrie Roberts before this morning?
No,
Were you friends at that point?
no.
Are you
How
now?
would you consider your relationship with Miss Roberts on that morning when Miss Reed arrived to your home?
I had met her once, and that was the extent of it. I wouldn't say I knew her at all beyond that one time I went out with her.
I want you to take us back now to when you first hear the defendant in your driveway yelling.
Oh,
When
we're
you
jumping
hear
back
that,
in
Do
time.
you hear any words, or is it general yelling?
No, chat. We're gonna have to wait for.
So I hear yelling.
We're gonna have to wait for
I was
Cross for some of
downstairs
this.
making coffee. I go to my front door and I open it, and she's screaming, "Jen, Jen!" She's screaming that 3 times, and then
We
she
can't
was
just say she's
saying,
screaming.
We have to go to Fairview. You know, a lot of the "could I have hit him? Did I hit him?" Just she was on repeat.
What did you do?
My husband came running down the hall and was like, "Tell her to shut up. She's going to wake up the neighbors." And then I said, "I'm just going to go with her. I'm going to go look for John." And then he yelled down saying something like, "You can't be driving around in this weather, you know, with a broken taillight."
When you saw the defendant at your front door, had the weather changed overnight?
Yes.
Was it different?
Yes, now the snow had intensified. It was almost like it was dark outside, but it was like whiteout conditions.
How dark?
Dark. I mean,
I mean,
it was
dark.
It was
How
like
dark?
5:30 in the morning.
What was the visibility like?
Not good.
After you meet the defendant at your door, do you let her in, or does she stay outside?
I'm not sure if I just grabbed my coffee and ran out,
Where did you
or
go?
whether she
How
came
fast
in.
did you make
So
coffee?
we walked down. We went down my walkway.
What kind of coffee maker
She
are
was
we
just
talking
kind of
about?
running all around.
an espresso
the
or-
car, the driver's door was open, so I told her I was going to drive because
doing a
I
drip coffee
thought
with,
she
like,
was
a
too
whole pot?
hysterical to drive. In the meantime,
How did you have time to make
all of a
coffee?
sudden there was a car at the end of my street, and there was a plow behind it.
The car that came to the end of your street, do you know where it went?
I meant the end of my driveway. I'm sorry.
When you say at the end of your driveway, did it pull into your driveway?
No, it just kind of stopped right at the base of my driveway.
Okay. How far behind your car was that car?
Not far, because not too far.
Okay. Did you know who was in that car?
No.
Did you learn who was in that car?
Yes,
How did you learn who was in the car?
because I said, "Who is that?" And-
Did you ask the defendant, or did you walk
I
up?
asked the defendant, and she told me it was Carrie Roberts.
Did you meet Carrie Roberts face to face in your driveway that morning?
Yes, I wouldn't say we met. It was more of a, the plow was coming, so then she was having to like move down the street, and then either Karen called her or she called Karen, but they were on the phone, Karen's phone over the car, so they started talking.
Did you get into the defendant's car?
Yes, we did. I got in the car with Miss Reed.
When you got in the car, you were in the driver's seat. Was Miss Reed in the passenger front?
Yes,
You said there was an open call. Is this something you could hear on a speaker?
yes.
At that point, had you had a chance to go and look at the taillight of that car?
No,
Did you have any interest in the taillight at that point?
no.
There was an open call between who?
Karen and Carrie Roberts.
Can you describe what you heard in that call?
Karen was saying that she wanted to go to Fairview, and Carrie Roberts was instructing her that no, we weren't going to be going to Fairview, and she kept saying, "We got to go to your sister's house." And Carrie Roberts said, "No, we're not going to be driving around in this weather in 2 cars. Let's go back to John's. Let's go to Meadows. Let's go see if he's there." That was kind of the conversation. And then Karen was doing a lot of screaming, and Carrie was kind of yelling back at her to shut up.
Who was taking charge of the situation that morning?
Carrie Roberts.
Were you in charge of it?
No.
Did you weigh in or make any decisions on where you were going to go next, or were you just a listener?
I just listened. Carrie said that Carrie's kind of a take charge person. She
I'm
said,
sorry.
"We're going to Meadows." So I said, "Okay." I drove to Meadows.
Now, at this point, you
My
didn't
bad.
know Carrie Roberts other
No.
than that meeting.
Yes, correct.
And you agreed to follow her?
Yes.
So tell us what happens. Take us through the drive.
Excuse me.
She might have followed me. I'm not sure,
Excuse
but
me.
we drove back to Meadows, pulled into the driveway.
So you knew where Meadows was? You had been there many times for the kids?
Yes.
You think Miss Roberts may have followed you?
Yes.
What was the weather conditions as you were driving?
They were awful. It was, I was driving very slow, cautiously. It was dark. It was hard to see. It was that type where the snow is like coming at your window.
How long of a ride was it from your home to John's home?
Approximately 5-6 minutes.
Was there any other phone calls while you were in the car with Miss Roberts, or did the phone calls end?
I believe that was it.
Can
Well,
you
they
describe
got to
the defendant's
Meadows.
demeanor on the trip from your house to John's house?
She was just screaming, yelling things. It was almost like everything she said 3 times. And she just went from one thing
Really?
to the next. She was quite hysterical.
Do you remember what she was yelling about?
She said,
About going to Fairview, asking, could she have hit him? Did I hit him?
How many times did she raise the question, did I hit him, could have I hit him?
A good amount.
Did you ever speak to her about that?
No.
notice he said question.
At some point, did
'Cause
you
I do
finally
think it
get
was a
to
question.
John's home?
Yes,
When you got to John's home, who pulled in the driveway first?
I did.
Where did you pull in respect to the driveway?
I just pulled straight in next to the garage.
Did you see where Miss Roberts went?
This is at
I
One
believe
Meadows.
she pulled in behind me.
After you pulled into Meadows, John's home, and you stopped, what happened next?
We go into John's house.
When you went into John's house, did you all go in the same way?
Yes, we went through the garage.
And before going into John's home, did you do anything?
Before entering into the house.
Yes.
He wants to know if
I
you took
took
your
off my
shoes off.
You took off your shoes?
Yes,
Why did you do that?
because you always had to take your shoes off at John's. He didn't want you to track. He would have yelled at me for tracking snow in his house.
Did you see if Kerry took her shoes off or not?
I believe she did.
Did you see whether the defendant took her shoes off or not?
She just walked right in.
Not me.
How would
Again,
you remember that?
I have no idea what the background noise is. Chad, I know I'm as distracted as you are. It's killing me. Again, the prosecution keeps harping on the shoes. This is how I feel about it. This is how I felt about it in the last trial. I think the prosecution is going to try to say, see, she didn't care that she was tracking shoes into John's house because she knew he was dead. I don't read it that way. I read everything from every witness and everything we saw in the last trial as pure panic. And so from Carrie's testimony and her testimony, we're going to go look and see if John's there. I don't think someone who's panicked is going to stop and take off their shoes because they said, you're going to go look for John. I think it reads as panic. I don't think it reads in any other way. Everything is consistent about one thing in this case is that morning from before 5 a.m. till she gets to the hospital, Karen is panicked and trying to figure out what happened. It is the most consistent thing in this case. So they keep trying to make the shoes a thing. It's just, okay.
See if
That was me.
Kerry took her shoes off or not?
I believe she did.
Everybody
Did
took
you
off
see
their
whether
shoes.
The defendant took her shoes off or not?
She just walked right in
How would you remember that?
because I thought it was strange.
What was your purpose when you went into the house? What was the number one thing
Just,
that you were worried about?
you think it's
We were
strange?
looking-
You think it's strange. She's panicked. She's telling you that John didn't come home. She's telling you she's concerned about Kaylee because we heard that from Carrie. She's screaming. She thinks she left him at the Waterfall, which everybody has said that until Jen told her she saw her at 34 Fairview, that Karen doesn't remember. And I think that's probably the truth, that Karen thought that she left him at the Waterfall and didn't remember going to 34 Fairview. And she doesn't know where he is. And it's strange that she didn't stop to take off her. That's the thing that's strange. That's the thing.
For John.
Okay.
Anything else on your mind when you went into his house?
Also, I knew Kaylee was there.
Now, at this point, did you have a close relationship with Kaylee?
Yes.
Do you still?
Yes.
What did you do when you went in the house? Where did you go?
I walked through the kitchen and then I kind of peeked into the TV room. I walked through the dining room, and then before I went up the stairs, I kind of peeked into a living room. I went up to the top of the stairs. I peeked into John's room, and then I went into Kaylee's room.
Did you ever see John?
No,
Why did you go to Kaylee's room?
because I wanted to go check on Kaylee.
Did you have a chance to speak to her?
I did, yes.
What was her demeanor at that point?
She was very, she was in the bed. She was holding on to her phone. She was terrified.
Was she screaming?
No.
Did you provide her any comfort?
Yes. I told
Calls
her
for
that I was
speculation.
going to go out. I told Kaylee that I was going to go out with them and I was going to find John. And I promised her that everything would be okay.
At some point, you left Kaylee?
Yes.
Where did you go?
I went back downstairs and then we went out to look for John.
Before
And after that exchange with Kaylee, because the thing in this case that really hurts my heart the most is John's niece and nephew. After that exchange with Kaylee, you told her you were going to find him and that it was going to be okay. And then there was no emotion when he's found. Whether it's emotion for John or not, there's no emotion for Kaylee when he's found.
before
Okay.
you left John's
I'm
house
listening.
that
I'm
morning,
trying not to
did
be
the
a
defendant
spoiler,
show you
Chad.
anything?
I'm trying so hard.
Yes. When we were out in the driveway,
I'm doing badly at this point.
I had thought it was when we went in, but I think it might have been when we came out. But regardless, at one point when we were in the driveway at Meadows, Karen showed myself and Kerry Roberts the cracked taillight.
Did you or Miss Roberts get close to the taillight at that point?
Yes, we walked over and the taillight was missing pieces.
Did Miss Roberts have any comment about it?
Yes, Miss Rob.
Yeah, that's
She had a comment. Next question.
hearsay.
What was Miss Roberts' demeanor at that point?
She was frustrated with Karen. Had said that. Had said that Karen basically was telling her to shut up. You were so drunk, you could have hit anything last night. And then Kerry, I remember just thinking, all right, let's go. And I remember Kerry thinking, oh,
Well,
someone's
let me
going
not
to
ask
get.
you what Kerry-
Oh, sorry.
We don't want to.
Also, that I believe 100%. I believe 100% that Carrie was like, all of you shut the fuck up. It is 5 fucking a.m. It is snowing. Y'all went drinking last night and you're waking me up. Shut the fuck up. 100%. We heard some of that from Carrie last trial, not as much this trial, but 100%. But yes, that's what Carrie was thinking. Apparently, according to Jen.
Think what somebody thought.
Okay.
I want to know what you heard and what you saw. Okay.
Yeah.
We didn't get as much of that from Carrie this trial.
At some point,
It wasn't
when you were
asked,
looking
but
at
that's
the
100%
taillight with
what
missing
Carrie testified to
pieces
last
with
trial.
The defendant and Miss Roberts, did you see Miss Roberts point anything out?
Yes.
Share that with us.
She pointed a piece that was sticking out and was concerned that someone was going to catch their coat or something on it.
And during that time when the defendant is showing you the taillight with missing pieces, was she saying anything about it?
No, I don't. Not that I can recall right now.
You mentioned at some point she was saying, did I or could I have hit him after you left John's house? Was that in the car or before you got in the car?
I know for a fact it was definitely in the car, was one of the times, yes.
Now, Miss Roberts' car is parked behind the defendant's car in John's driveway.
Yes,
Was there a decision made to take one or two cars?
one car.
What was the plan?
The plan was to get into Carrie's car and to go and look for John. I wanted to go thinking, let's go to Tom Beatty's, but Miss Reed was pretty adamant that we go to Fairview first.
You said that at times there was
I'm
some
gonna wait till
arguing
class.
or
I'm gonna wait till
bickering, and
class.
Miss
I'm gonna wait
Roberts
till class.
was
I'm gonna
raising
wait
her
till
voice
class.
to the defendant.
Yes.
Who made the decision to go to Fairview?
Ultimately, Carrie said, all right, we'll go there, almost like to shut her up.
When you got in the car, where was everybody? When you got into Kerry Roberts' car, where
Yes.
was everybody sitting?
Carrie was driving, I was in the front and passenger. Karen was in the back, in the middle, kind of peeking her head through between us.
I want you to take us through the ride from John's house at Meadows until you first get to Fairview. So as you pull out of, or Kerry Roberts pulls out of John's driveway, what is the mood inside that car?
I'd say it was starting to get tense because Karen was just continuously screaming. Carrie was trying to focus on driving, and Karen's behavior in the back of the car was a bit erratic.
When you say erratic, can you just give some detail what you mean by that?
Yes, she would go from sitting back to leaning up in between us, and she would yell Kerry's name 3 times. Then she would yell my name three times. And then she would yell, could I hit him? Did I hit him? Over and over again.
When she was repeating these questions or phrases that she was yelling, did you respond in any way?
I don't believe I did, no.
How about Kerry?
Carrie was telling her to shut up and to buckle up.
Was she buckled?
I don't believe so.
You began your drive from Mr.
Of all the
O'Keefe's
things
home
we're
at
troubled
Meadows
about, Brennan.
to Fairview. Is the weather getting better?
No, it's getting worse.
Unlike the memories,
Visibility
apparently.
still difficult?
It was terrible.
As you began that drive to Fairview, was there anything that you were doing on the way?
Yes, I was just kind of looking out the window intently to see if I saw anything.
What were you looking for?
I guess John, which
thought
I know
you
it sounds crazy,
Couldn't
but
see anything.
I didn't know where the hell he was.
Did you have any difficulty seeing from the car the side of the road?
Yes.
Did you see what direction Ms. Roberts was looking when she was driving?
Well, she, it was
Forward?
hard because she needed to focus on driving because the conditions were that bad.
Did you have a chance to see the defendant on that drive at all?
Yes.
Was she looking out the windows with you?
No, she was popping back and forth and screaming.
Was it constant screaming, or did it change at all?
She would scream and then kind of sit back, and she'd almost be like quiet for a minute. It was like, okay, good. And then she'd start again.
In those quiet times, do you know what, if anything, she was doing?
I didn't know what she was doing that morning, no.
How long did it take to get to Fairview?
I don't know. I'm going to assume maybe 10 minutes, like with
Don't
the weather, maybe 10 minutes. I'm not, give or take, approximately.
As you're approaching 34 Fairview Road, before you get there, is Fairview going to be on your left side, driver's side, or on the right side?
As we're pulling up, it's on the driver's side. Carrie's going to take a left down Fairview off of Chapman.
I want you to take us back to that morning, about 20 or 30 yards before you get to Fairview.
Mm-hmm.
You're in the car with Miss Roberts and the defendant?
Yes.
What's happening in the car?
Karen's is screaming, and at that point, she had asked if John could be cheating on her and if John could be with Bella's mom.
And then what happens?
I didn't know what the hell she was talking about. I was like, what are you talking about? Why would he be with Bella's mom? And then Carrie said, well, do you think he could have walked to, there was another woman years before that John had dated who lived on the next street over to her house.
What?
And as you approach that area before you get to the flagpole, does anything remarkable happen?
No.
Okay. What happens next?
As we're driving down the street, I just say to Carrie, because she doesn't know where my sister lives, oh, her house is just at the bottom of the street.
Visibility still difficult?
Yes, awful.
What happens next?
We continue, driving, and we're driving slowly past, the line of, I guess, bushes and the flagpole area. And all of a sudden, Karen's screaming from the back, "There he is," or something to the effect of, "There he is, let me out."
Did you know what she was talking about?
I had no idea.
When she was yelling that, did you look out the window?
Yeah, we had our eyes peeled out the window.
Did you see anything?
Nothing but snow.
How long was she yelling about whatever it is she was saying?
Carrie, she screamed, "Stop!" So Carrie stopped pretty quickly. There he is, there he is. She could have kicked the door, like, "Let me out of here."
And when she was kicking the door, what were you doing?
I was just like, what the heck? What is going on?
What happens next?
She gets out. Carrie looks at me and said something. I said, like, she's batshit crazy.
Then what happens?
Then Carrie got out. Then I got out of the car, walked around the back of the car, and was walking, like, over to where I could see the girls were.
Now, at that point, you were in Kerry Roberts' car.
Yes.
It had its headlights on.
Yes.
Was it facing up the street of Fairview?
Well, we had come down the hill, so yes, up the street.
There was no other lighting in that area?
I do not believe so.
No fire engines or ambulances at that point?
No.
No police cars?
No.
Any street lights?
It was dark.
When you got out of the car, did you
okay.
look towards the area of the flagpole?
Yes.
Could you see anything at that point?
No.
Y'all in the
close
chat
did
are
you
saying
get
these
to
are
the area
terrible
of the flag?
friends. These aren't Karen's friends. They didn't have her number. Neither of them did. These are John's friends. Everybody's like, these are terrible friends. They were friendly in person, but they are not Karen's friends. Neither of them had Karen's phone number. And that's why they used Kaylee's phone to call Jen, because Karen didn't have Jen's number and Jen didn't have Karen's number.
Flagpole before you
No.
could first actually see something.
Well, I saw the shadowy figures of Carrie and Karen, and it wasn't until I got
The shadowy the phrasing for me. At
that point?
No.
How close did you get to the area of the flagpole before you could first actually see something?
Well, I saw the shadowy figures of Carrie and Karen, and it wasn't until I got very close over to them that I saw Carrie removing the snow from John's face.
Is that the first moment you realized that was John O'Keefe on the ground?
Yes, it was.
When you see Carrie removing the snow from John's face, what do you do?
I was frozen. I was shocked. I couldn't believe that was him just lying there.
Tell us what you're seeing.
What do I see? I see Carrie just wiping the snow off. Karen had straddled him and had lifted her shirt and his shirt and was laying on him, and Carrie was screaming at her to get off of him. And I was literally just stunned. I mean, there he was.
What did John look like when you saw him?
I couldn't see much but his face, because the rest was snow and Karen was moving over him, but he just looked like just him, but just like frozen.
What did you do?
At first, I just stood there for a minute because I couldn't believe it was him. And then Carrie Roberts and I made eye contact. And I like knew, I was like, all right, I'm going to call 911. But I think I knew in that moment that John, was dead.
Did you call 911?
Yeah, I started to call 911, and Kerry and Karen were just screaming. And so I walked back towards Kerry's car, and then Kerry was also yelling at me to go to the back of the car to look for blankets and towels. So as I was calling 911, I was at the back of the car looking for the towels and the blankets to bring over to Kerry. And while I was doing that, I believe 911 answered.
Did you speak to 911?
I did, yes.
Did you get the towels and blankets that Kerry had requested?
I did, yes.
After your phone call with 911 and you had the towels and blankets, tell us what happens next.
So after I called 911, I went back over to Kerry, Karen, and John. And at that point, Kerry asked if I would take over compressions. So she got up and I started doing compressions, and Karen was doing mouth to mouth.
When you started doing compressions, were you touching John over his clothes or touching his skin?
I don't remember.
Did you at that point get a chance to touch John's body and see how it felt temperature-wise?
I just remember when I was doing the compressions, I don't really know how to explain it. It just felt very funny.
I'm sorry, very
It just wasn't like normal.
Why?
I don't. I can't think of how to describe the way it felt when I was trying to press down, but it was like resistance.
How long did you try to give compressions and give aid to John for?
Until the police came.
Mr. Brennan, why don't we end here?
Oh,
Ms. McCabe, we're going to need you back tomorrow. You can stay. Okay. Jurors, that's it for today. I have to give you those same cautions. Please do not
okay.
discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case,
Well, that's a
please
place to
disregard
break
it
the
and let us know.
testimony.
Again, please be very careful.
The court was just like, all right, Mr. Brennan, and we're done.
See you tomorrow morning.
Right in the middle of that testimony. Okay.
Goodbye.
Yeah, that's exactly how it felt. That's exactly how it felt. I'm gonna wait till the jury's out because the feed is still going. Let's do a quick summary of where we're at, and then we will see. Let me just zoom and see if they go back. Yes, they do go back on the record. All right. So I'm gonna try to summarize that, and then we'll go back to court because we are not done yet. So after we finally finished with Ian Whiffin's testimony and the live demonstration in court of the tool that he created, that he provides for free so people can use it to do their own experimentation, the Commonwealth called Jen McCabe to the stand. And when the court broke for the day, we were to the point of Jen McCabe's testimony where she was saying that she was doing chest compressions on John O'Keefe in the snow. So we are just getting to 34 Fairview and what's going on. And it is hard not to juxtapose her testimony with her testimony last time because it is one of those moments in the last trial that stuck out very much. However, if the jury is sitting there fresh as they should be and have not seen this trial, I think her testimony in direct examination came across very clear. I think her testimony was much easier to follow than last time. Brennan's questioning was much better, though there are definitely moments that Brennan will bring in emotional questions and a little bit leaning into the drama of, and then what happened that changed everything. And as we are getting to the point in her testimony where they're at 34 Fairview, The chat read her testimony as very contrived. I don't think the jury will read it that way. It's hard to read her testimony especially after seeing her last time and knowing that there are changes to her testimony, which will come up in cross, because there are things I'm like, wait a second, I have not heard that before. But at this point, we have not gotten to cross-examination yet. And so if the jury is sitting there listening and knowing that she is friendly with John, knowing that she is friendly with his niece, they are going to feel for her as she is talking about realizing that it's him in the snow, that Carrie is brushing the snow off of his face, and she's realizing that that is her friend. How the jury will feel about it after cross-examination may be different. We're just not there yet. At the end of the day today, the testimony was clearer. It was less explanatory, and I felt that it was less forced. We will see how it goes from here, because I don't think that her testimony at this point has read as forced. I think it has read much clearer, and I think a lot of that is because of the style of the questioning. The questioning has been much more pointed and direct, and her answers, it seems to me that she has been told to answer just the question that is asked, which is appropriate. And she, at times, you could see where she was straining to add more information. The over-explanation was a problem for Jen McCabe in her direct examination last trial. And it seems very much that Brennan is trying to rein that in so there is not over-explanation. And still at times there is moments of that, but it reins back in. I am interested to see how much cross-examination there is, because there was information in this testimony that was not consistent with what we've seen before, but we're just not there yet. And the jury does not know that yet. They're left at the end of the day with a woman who is seeing her friend's face be uncovered in the snow, trying to do CPR, saying that it felt odd trying to do CPR, that it felt weird, which if you've never done CPR before and they haven't asked, I imagine would feel weird. And we haven't heard the 911 calls. I think what the prosecution has done well in ordering these witnesses is in Ian Whiffin's testimony, in his timeline, we saw a timeline of when Jen was texting back and forth with John O'Keefe. And now we are hearing Jen's side of texting back and forth with John O'Keefe. And we've seen some of the videos at the Waterfall that were really hard to see. They were much like the exposure was overgained. I don't know if that's the lights in court or if they tried to clean up the video and just missed, because there were parts of the video that were very hard to see. But we got into some of the video from the Waterfall with the timestamps, but we didn't get into it in depth. There wasn't like this rehashing of the video. It was just, okay, at this time you see these people here, you see those people there. We will see what happens tomorrow, because I have a feeling we have a bit more of direct examination to go before we get in cross, and the cross examination I expect will be incredibly lengthy. So after the jury is out today, it looks like court keeps going. So we're going to go back to court. Also, chat, I see a lot of you saying, Emily, how can you say that? I'm telling you how I read the testimony. It's going to change after cross, but I can put aside what I thought of her testimony last time most of the time. There are moments when I'm like, what? We're going to have to wait. But no, I don't think her testimony reads as overwrought this time. I don't think it reads as overwrought. And I think it's really hard to read her testimony the more you know about Jen McCabe and the more you've seen, but it doesn't read overwrought. And for those who aren't familiar with this case, I don't think it will read as overwrought at this point. The questioning is better. The way she's explaining it is better. A lot of you are asking, has she been coached? It doesn't. When witnesses have been coached in the traditional sense of the word, it's almost like they are checking back in with what they've been told. I don't think she has been coached that way. I think she is self-edited. I don't think someone else told her, do this, do this, do that. I think she has paid attention to this case. This is my pure speculation. I think she is self-editing. So I don't think she is checking back in on being coached. I think it is self-edited. I think it's I don't know, maybe checking in with what the internet had to say about her, but I don't think a lawyer sat her down. And this is when I hear coached, I don't think a lawyer sat her down and said, you need to do this, you need to do that, you need to do this better. I do think she paid attention to this case and how she was perceived and the rest of it. I do. And I think that that's part of it. So, but the jury doesn't know that. And it did not come across nearly as overwrought as last time. That's how I see it today. Is it going to change after cross? Probably is. But that's where I see it at the end of the day today. All right. We're going to go back to court because they go back on the record. Are y'all ready? That's just my read on it. You guys, it's okay if you disagree. It's totally okay to disagree. You've been watching this case too. Totally okay. Totally okay. Angela said, is the self-editing possible perjury? Not at this point, but when we get into cross, I imagine there will be some impeachment that's happening. So we will see. If there are things she said in previous statements to police, testimony, and the rest of it, we'll see. We'll see. But coached, I give a very specific meaning of that. We got to get to cross. All right, y'all. Are you ready to get back to court? I know you are. I know you are. Let's get back to court. Miguelina, will you let the Lawnerd app know that court is still in session? Because the chat is aware and they are like, motherfucker, we're going back to court. Let's go. Dude, if I don't summarize Jen McCabe's testimony before we get into other shit, I will forget. Because there's more. Don't worry. Don't worry. We will get back to court. We are not very far behind real time. So do not worry. And thank you for no spoilers. The chat is ready to rock. I know it's hard when we've watched this testimony before.
We're back in session. You may be seated.
Court is back in session.
All right, Mr. Brennan, I'll hear you.
I thought we might start today talking about ARCCA. I think this is where we're going now based on what the chat has said.
In light of yesterday's hearing with the ARCCA witnesses, the Commonwealth is going to ask the court to preclude the ARCCA witnesses from testifying both about any new testing and any new opinions, and secondly, from testifying about their original opinions turned over in a report prior to last year's trial. To be brief,
let's just be clear. The jury is out. The jury is done for the day. These are legal arguments based on yesterday's motion. Brennan, I'm not trying to keep ARCCA out. I'm not trying to keep ARCCA out. I'm not trying to keep ARCCA out. Your Honor, out. Out. Okay. Okay.
Hearing with the ARCCA witnesses, the Commonwealth is going to ask the court to preclude the ARCCA witnesses from testifying both about any new testing and any new opinions, and secondly, from testifying about their original opinions turned over in a report prior to last year's trial. To be brief, what we learned or
they want to preclude ARCCA
is that we do not have all of the discovery of communications. There was a court order for the ARCCA witnesses to provide Your Honor with all of their information, phone records, text messages, communications about this case. Instead of providing their information to the court, they instead chose to send it to the defense, and then it was summarized and provided by the defense to the court and to the Commonwealth. It appears to me that is not in compliance with the court's order. What we learned during the hearing yesterday is that Dr. Wolf admittedly destroyed over 100 text messages.
That's dramatic.
Now, he mentioned that he...
Why do I say that's dramatic? I don't see it as destroyed if there was no preservation order. I'll snark about it when it comes to Higgins's phone, but technically Higgins's phone was rehomed before there was a preservation order. There was no preservation order. However, if I'm going to side-eye him saying it was destroyed, I have to do the same with Higgins because there was no preservation order for Higgins's phone either. I think it's different with a fact witness versus an expert, but
changed phone carriers, but then later admitted that he actually intentionally, for no apparent reason, destroyed the text messages in this case. And so what is left for Your Honor to look at is a summary of phone records from the defense and ARCCA's information that is passed through the defense to the court. You do not have the text messages. You do not have the content of the text messages.
when does the court ever get the text
of
messages?
the conversations, dozens and dozens of calls between the defense and the experts. It is difficult to believe that all of those text messages and all of those phone conversations dealt with simply logistics. In fact,
You find it suspicious when people change phone carriers and they don't have text messages anymore? I just want to make sure we're clear. That's sus to you. Want to make sure we're on the record with that.
During the questioning of Dr. Renschler, there is much more involved than simply logistics. But to get back to Dr. Wolf, he did not disclose to the court that he was communicating and having conversations on Signal. How odd. An expert using Signal. Never used it before. Dr. Renschler said would not use Signal, never use Signal. But Signal, as we know, is an application that does not create a record of communications. Dr. Wolf maintained on his direct that everything he did was logistics, even when we showed him the direct examinations with comments that asked for input from the defense to questions in a way that would be advantageous to the defense and to thwart the Commonwealth. Dr. Wolf actually still continued to testify that that was simply procedure and logistics, never admitting the fact that there was, in fact, conversations or information exchanged about bettering the presentation for the defense. Inevitably, I asked him about the sequestration.
The lawyers are losing their mind. Otherwise, I would say come say hi to the law nerds. But good to see you, T.
Order and how evasive he was. You simply have to compare him to Dr. Renschler, who was quite candid. An hour or 45 minutes with Dr. Wolf, difficult getting a straight answer. Dr. Renschler told us more in 5 minutes than Dr. Wolf told us his entire examination. And what we unfortunately learned is that during the trial, when this court had a sequestration order,
I've got questions about
information was
that.
being passed to the experts about witness testimony, in this case, unknown to the Commonwealth, unknown to the court.
The sequestration order might be a problem. I don't know what the sequestration order is from the first trial. The court will know, but the experts should have known if they were going to be allowed to testify. They might not have known. Like, I need more timing on it. If they didn't know they were testifying, then they don't know it applies to them. So
Particular
I'm going to back him up
had
real
a
quick.
Sequestration order. Information was being passed to the experts about witness testimony, in this case, unknown to the Commonwealth, unknown to the court. Information, particular information, not general information, witness testimony, issues in the case. We have no idea who is deciding or identifying the issues and who the advantage is given to in describing those issues. But that is witnesses being prepped through an intermediary. So we know the Department of Justice, at least, is violating the order, helping the witnesses along.
How does the order apply to the DOJ? I'm truly curious.
And then they testify, unbeknownst to the Commonwealth, that they have this information, but obviously is reflected in the testimony. In addition, I've provided some clips to Your Honor for review
Yes, do you want me to mark these as an exhibit?
No, play them.
Okay, so this was an exhibit from yes.
Clip, play the clips. Nope, play them in court. Brennan. We put up with all day yesterday. I think I speak for myself and the Lawnard chat at large. Play the clips. Play the clip. We sat through all day yesterday. Play the clips. Just clip. Okay, enough housewives. Clip. I'm not done yet. Clip.
I did have the opportunity.
Dorinda entered the chat for me, right?
I suggest that the relationship was not resigned to mere logistics. And so from that subterfuge, what we stand with today is that we know that the witnesses were well prepared. We know that there was not true independence. And what we know is that they are refusing to provide the necessary information to support their original opinions that they gave at the first trial. They cited that it was a protective order. Perhaps it is. That has nothing to do with the issue. By calling the ARCCA witnesses as their witnesses, they then have the obligation to comply with Rule 14. Unlike the first trial, where the Commonwealth had no ability to do any testing, review, vet the reliability of the information, properly prepare for cross-examination, this trial, that should not occur. Just because it happened last trial and the Commonwealth was disadvantaged does not mean it should happen this trial. And that is precisely why I began moving for discovery in this case early on.
Oh, girl.
Inevitably, if these witnesses cannot provide information because it's under a protective order, it may not be the defendant's fault in its inception.
It's a
but
really
it is their
difficult quandary.
problem and difficulty because they chose to hire the ARCCA witnesses. They could have chosen any witnesses they want. Rule 14 is not obviated because they made a strategic decision to call the ARCCA witnesses. So now going into this trial, even Dr. Rentschler admitted that an expert should have time, in their opinion, a month or more, to review the raw materials. It's not enough simply to have a report, as Attorney Alisi preached during his argument. We should have the...
Alessi. Okay.
In their opinion, a month or more, to review the raw materials. It's not enough simply to have a report, as Attorney Alisi preached during his argument. We should have the opportunity to go through the raw data, the history, the videos, determine whether there's any failed testing. We don't have that benefit. And so my position has changed, that those early opinions should not come in because we have no ability to fairly cross-examine. As for the new opinions, the report may not be done until May 7th. We are in the middle of trial. Concedingly by the defense, or at least their witnesses, it takes a month to go through the discovery. When I filed my motion on the eve of trial that we would be unable to prepare or we would want a continuance in this case, I appreciate why this case wasn't continued, but I knew, given our scheduling, our experts will not be able to look at this material. Our expert is away until after the first week of May. He is going to be testifying shortly after. He will have no ability to digest this enormous amount of materials, vet whether it's accurate or not, conduct tests to combat it if he thinks that it's inaccurate or unfair. And so the discovery violations, regardless of the state of mind, are upon the defendant. There is no exception that you used ARCCA witnesses. There is no exception that you
The raw data
hired somebody that used to
is
be under
going
a
to be a
federal protective
problem.
order. They chose them, and I would suggest it seems strategically. When we noticed we'd have
I knew he
new
was gonna argue
experts
that.
in October, the defense from past experience, and probably other experience
said
that we
that's
know
where
from
we're
this
going.
case, knows the process. They would have to file a TUI letter and wait for a response. And yet they waited until February to seek permission, which then extended their permission past February into March, and then they didn't even start the review until late March. And so it's fundamentally unfair. We should not be placed in the position of cross-examining experts without the fair ability, as any participant, defendant, Commonwealth, any participant would have in a case, to consider and then to rebut. And so for that reason, I ask you to exclude both the new opinions and new testing.
That's everything.
And also to exclude the earlier opinions that we will never, at this point, receive the proper discovery with to prepare.
All right, thank you.
The raw
Mr.
data is going to be an
Alessi,
issue.
I only have one question for you.
Oh.
So would you stand, please? You're arguing this, right? This was your motion?
That's dramatic. That's dramatic.
So my question is, how do I reconcile the fact that 100 text messages were deleted by counsel? And
Not by
we
counsel,
heard yesterday,
by the
counsel's
expert.
preferred method of dealing with Dr. Wolf was via Signal. How do we reconcile that with the Massachusetts Rules of Professional Conduct 1.15? I don't see how you reconcile that, where all correspondence related to the matter, whether in physical or electronic form, must be saved for 10 years minimum. How do you reconcile that? How do I reconcile that?
Should I go to the podium?
Right there, and I expect a short answer.
The short answer
Whoa.
is the rule that you're citing has absolutely no applicability to this proceeding for the, can I finish my answer, Your Honor?
Right ahead.
Has no applicability.
I'm going to back that up. The court is saying that under the rules of professional conduct, all physical or electronic communications must be kept for 10 years.
100 text
she's
messages were
pissed.
deleted by counsel. And we heard yesterday, counsel's preferred method of dealing with Dr. Wolf was via Signal. How do we reconcile that with the Massachusetts Rules of Professional Conduct 1.15? I don't see how you reconcile that, where all correspondence related to the matter, whether in physical or electronic form, must be saved for 10 years minimum. How do you reconcile that? How do I reconcile that?
Should I go to the podium?
Right there, and I expect a short answer.
The short answer, Your Honor, is the rule that you're citing has absolutely no applicability to this proceeding for the, can I finish my answer, Your Honor?
Right ahead.
Has no applicability. That rule is intended to be between an attorney and the client. The court has no jurisdiction to enforce that rule.
I agree. I agree. That's a different body, but I'm asking you how I reconcile that when I'm trying to figure this out.
Well, it's
Mr.
not a
Leslie,
client
you know
communication.
what? You're going to win this, so why don't you just let me make my ruling, okay? So
The fuck just happened? What? Mr. Alessi, square this rule for me. Your Honor, that deals with communications between an attorney and a client. Okay, well, Mr. Alessi, can you please shut up and sit down because you're going to win this. I have hurt my neck with the whiplash that has just happened. I feel just the emotional roller coaster that we are on is not a delight today. I am so fucking confused. Mr. Alessi, you're going to win this. Just let me make my record. What? Okay. Make your record. The fuck?
I understand there have been repeated violations of the reciprocal discovery orders and my orders. Repeated
violations of the reciprocal discovery. Well, Commonwealth, you wanted to say they didn't give us the text. You wanted to say they didn't give us the text. Well,
and deliberate. But, and Mr. Brennan, I understand completely the Commonwealth's argument, completely the ambush that has been set upon here. However, a defendant's right to a fair trial is paramount to everything. So I'm going to allow the ARCCA witnesses to testify. I am going to allow what I expect to be a very robust cross-examination. And I'm going to allow them to testify to everything that they said up until yesterday. So you'll get the report May 7th. And I know that's late. And if you need anything as a result of that being late, I'll hear you on whatever motion you have. But that's where we stand. And I expect counsel to comply with all rulings and rules of the court and all rules of professional conduct. And no more nonsense. Let's just try this case. All right, that's it. I'll see you tomorrow.
All rise in the court, please.
Wow. Well, I'm stunned. Do we need to watch that again? Chad, do we need to watch it again? Do we need to watch it again? Do we need to watch it again? I feel like we need to watch it again, and then I'll summarize it. I think we need to watch it again, and then we will summarize it, because she's mad. We're gonna just I need an instant replay sound, like doodle-doo. I am very surprised that went that way after Brennan's argument. Let's continue.
This proceeding for this. Can I finish my answer, Your Honor?
Right ahead.
Has no applicability. That rule is intended to be between an attorney and the client. The court has no jurisdiction to enforce that rule.
I agree. That's a different body, but I'm asking you how I reconcile that when I'm trying to figure this out. Mr. Lessie, you know what? You're going to win this, so why don't you just let me make my ruling, okay?
Did you see how fast he sat down? Mr. Alessi, you're going to read that. You're going to win that. Your Honor, I'm sitting down immediately. I am sat. Immediately sat.
I understand there have been repeated violations of the reciprocal discovery orders and my orders, repeated and deliberate. But, and Mr. Brennan, I understand completely the Commonwealth's
Brennan's
argument,
face has to
completely
be.
the ambush that has been set upon here. However, a defendant's right to a fair trial is paramount to everything. So I'm going to allow the ARCCA witnesses to testify. I am going to allow what I expect to be a very robust cross-examination. And I'm going to allow them to testify to everything that they said up until yesterday. So you'll get the report May 7th. And I know that's late. And if you need anything as a result of that being late, I'll hear you on whatever motion you have. But that's where we stand. And I expect counsel to comply with all rulings and rules of the court and all rules of professional conduct. And no more nonsense. Let's just try this case. All right? That's it. I'll see you tomorrow.
Were you looking at Brennan when you said all more nonsense? Wow. I am very surprised that when we got to the ARCCA arguments today, after the voir dire, that at the end of the ruling, the court is not just letting it in, but letting it all in. All of it. So Brennan argued what I thought he was going to argue yesterday. And when Brennan started going down the line of questioning about when ARCCA was out of their contract with the federal government in June 2024, it seemed clear to me that the argument from the Commonwealth is, Your Honor, the defense could have done this sooner. They waited, and they waited on purpose so that we would not have time to evaluate it. They waited to even ask until February. They couldn't even get appointed until March. And then the reports are coming in the middle of trial. There are a lot of judges who, on that information on this new trial, might have kept that out and said, you're right. They could have hired ARCCA in February, but they waited until March because they didn't, or hired them back in June or July of 2024, but they waited. I think the flip side to that is that the defense didn't have the Commonwealth's reciprocal discovery with the underlying data and the full underlying data until just last month. So on the rebuttal part, I think it would have flown if they are coming in as rebuttal witnesses, which it seems that they were planning to just come in as rebuttal witnesses. And the judge threw the entire fucking door open and said, well, I know you were going to have them come in as rebuttal witnesses. They can testify about all of it. They can literally mention it all. ARCCA said, we've only been brought in to testify as rebuttal witnesses. They said that yesterday, and the court said, nah, you can give your opinions from last time and you can come in as rebuttal. More than what the defense asked for, which surprises me because I think the Commonwealth yesterday did a good job of illustrating how important the underlying raw data is, and the fact that they don't have that underlying raw data in this case, cannot turn it over, cannot get it, and won't get it. She could have limited ARCCA very reasonably, and easily. She could have restricted ARCCA for, at this point, not turning over the raw data and kept them to a rebuttal witness, which would have fallen under what the defense was asking for. And she didn't. She said they can talk about all of their findings. That is a broader ruling than what the defense asked for. And I think Brennan is probably sitting there going, not only did I lose, but I lost shit I thought I couldn't lose. And the Commonwealth is going to be pissed about that, because the judge expanded what ARCCA can testify about, which is a very big ruling for the defense. The defense, I don't think a single defense attorney on the defense team gives a shit that she called it an ambush or said whatever. She said, you know, this ambush that has been set upon you to the Commonwealth, the defense doesn't give a shit because they won a huge motion in their favor. Okay, Your Honor, say it's reciprocal discovery that we violated, but they are going to bring ARCCA in for more. And I understand where the Commonwealth is coming from. In the first trial, is there as much they can do? No. Could the defense have reached out to ARCCA in the summer and brought that in and tried to get to more of the underlying information? I don't know. The Commonwealth thinks they could have. The difficulty with having a federal investigation is that there are things that will be sealed, and the DOJ is not giving you what is sealed. It doesn't matter if you're the defense. It doesn't matter if you're the prosecution. I suspect if the Commonwealth, and given ARCCA's findings, that's not going to be the case. But I suspect if the situation was reversed and the Commonwealth wanted to bring in ARCCA because it was good for their case, and they didn't have the underlying raw data, that the court probably would have kept it out, finding that it unfairly prejudices the defense. So when we're looking at how the court is ruling, I think that this ruling would have gone differently had the prosecution been the one seeking to bring in an expert without turning over the raw underlying data. And that is why the Commonwealth is so frustrated. But if Karen Read is acquitted, you know what? The Commonwealth can't appeal it and say, we should have gotten more discovery. There's nothing they can do. If Karen Read is convicted, this isn't going to be an issue that the defense brings up because the court expanded what their experts are allowed to say, even in the face of discovery violations. The court said, hey, the voir dire is your resolution to the discovery violations. And then the jury can decide if they find these experts trustworthy or not. I can see a lot of judges that might have said, take it up on appeal. You're not turning over the data. You're required to. You had time to do it, and you can't bring it in. Wow. So the Commonwealth is going to be livid with that ruling. And the court, I think, to the surprise of many, expanded a very large ruling in favor of the defense. I will say with this judge, there are times that she has stronger languaging for the defense, but every time it comes down to, I don't know, the rubber meeting the road, those big motions, she has ruled in favor of the defense on most of them. And that, again, is one of the things we heard this judge said, this defendant deserves a fair trial. So ARCCA can testify fully. Not all judges would have done that. We're going to see what happens, but she also didn't say ARCCA needs to give the Commonwealth their report before May 7th. She said, you'll get it when you get it. Wow. Wow, wow. I'm going to answer some questions, but there are a lot of courts that would not. Brennan's getting to experience what it's like to be on the other side of those rulings as a prosecutor going, so they can just like not. Yeah, sometimes. Yeah, sometimes, Brennan. He's not happy. So it looks like those will get turned over May 7th. The Commonwealth is going to have to tell their expert, hey, review what you can. And she's not speeding up ARCCA and asking for them to turn that over sooner. And the Commonwealth's expert will testify when they testify. ARCCA will testify when we get to the end. So, boy, oh boy, oh boy. I wonder if Brennan's regretting what he asked, and how much time he wasted on the emails yesterday. So, interesting. Anna in the chat asked, Emily, do you think she changed her tune after yesterday's ARCCA point when they said the DOJ watched closely the first trial? No, because she did this last trial too. There were times last trial where I'm like, there's a lot of judges who wouldn't let that in, and she's like, yep, we're allowing it. When it comes to those big rulings, they have largely favored the defense. In the motion to dismiss, I wanted to see an evidentiary hearing, but in the motion to dismiss, a lot of courts aren't going to grant them in that way. I think she could have had stronger language for the Commonwealth about not turning things over. She keeps that strong language for the defense for sure, but the rulings still go in their favor. So that's what it is. I often don't answer questions like this, Susan, but I'm going to answer this one. Why? Because it's Tuesday. Why the fuck not? Susan said, if Karen is acquitted, the NBC 10 Boston News said last night that the Commonwealth will not look to find who did it. Why? Well, I don't know if that's what NBC Boston 10 said, but I'm assuming that it is. So taking that assumption at its face, why? You can't try someone after you tried a person twice for this. It almost builds doubt in to a trial. Oh, but you tried this other person for it. And then the other trial would become about Karen Reid's trials. Because the person sitting in the chair, whoever that is, it would be almost impossible to just try them. Because the whole trial would be, but you thought this person did it, and you thought this person did it because of this, and you thought this person did it because of that. That doesn't mean if the feds, and we've heard that their investigation is closed, if the feds find fuckery that is criminal, could the feds charge that? Yes. Could they charge someone else with killing John O'Keefe? It would be really difficult. Could the state charge someone else with killing John O'Keefe? Technically, legally, yes. Could you try that? No. Practically, you can't try that case because it bakes in automatic doubt. Could people be tried for, it's dangerous to speculate on the internet because then I will inevitably say EDB said, and I'm like, no, there was a whole lot of context. Things outside of homicide aren't necessarily closed. We've seen that with the feds looking into cases. Do I know if that will happen here? We're going to have to wait and see. But I think the feds are 100% looking at this. But no, if you tried, dude, for the murder of John O'Keefe, the entire trial is, and the investigator thought it was Karen Reed, and then you thought it was Karen Reed, and then this was undetermined by the coroner, and then the entire trial would be about that. And how, if you're sitting on that jury being like, well, if everybody thought somebody else did it, like, why are we here? No, it would not. So yes, I hope that's helpful. Let's answer a few questions. Today was a fucking roller coaster, y'all. Trials are dynamic. I know there are moments of trials that can be dry, can be a little sloggy. We didn't have that shit happen today. That's not true. We did have a little slogging today. But damn, by the end of the day, did it change. So today, Danielle said, Emily, has there ever been a bench trial that didn't end with a verdict? I can imagine a scenario where it would happen. Like if you're in a bench trial and then someone decided to take a plea deal, or you're in a bench trial and then the case gets dismissed, but there would be more of a circumstance. So I don't think a judge would just be like, I'm undecided in my mind. I don't think a judge would be like, I am hung. Wait, no, damn it. I can definitely see judges saying that. The problem is I'm at the point where I've been an attorney long enough that a lot of the people I knew as rowdy young attorneys are now judges. So I know them. I know it too much. But no, I don't think a judge would be like, I'm undecided. I just can't make up my mind. No, I don't. That would not happen. But you know, I can see a circumstance where something else would happen. It happened to me when I started trials, and we would get through trial and then the case would plea in the middle of the case. It does in fact happen. But once you're already in trial, it's like, I've already got all my trial clothes clean. Like, we're in now. Like, you've jumped in the cold plunge. Like, we're in it now. Can we just keep going? It's the worst. Like, starting trial and having it plea in the middle is just, it's the worst. Because then you're like, damn it. It's so unresolved. It's like, I had a whole plan. I have been working weekends. I haven't slept. It's just over. How many of you watched the Rust case with me, with Baldwin? How many of you watched Baldwin with me? You get the Baldwin case going, and then you get to the middle and you're just like, what do you mean we're done? It's so unresolved. You're just like, what the fuck? The worst. Absolutely the worst. Absolutely the worst. Absolutely the worst. All right. I'm going to try to get to some of your questions because it is just. Allie B from Tennessee said, so now she isn't going with the I hit him. I don't think we've gotten to that point in the testimony yet. We have not gotten to what was said at 34 Fairview. We've gotten to what was said before. However, I really think, I don't know, I thought this from the first case. I really think the whole I hit him thing is not a serve. I think it's a question. We'll see how the evidence comes in this time. It's going to be difficult for me to see it differently because in all the testimony we've seen so far, it's panic and it's, well, partly drunkenness and questioning. Like everything in here that we've seen feels like panic and drunkenness and questioning. So we're just not there yet, but it's hard. Jojo, I'm glad you are safe. Jojo said, just came back from fighting off an intruder, a spider, and my elderly cat just ignored my squeak and snoozed. Cats. Right. I mean, they're just like, ugh. human. I don't do your bidding. If it was 4 a.m. though, Cat would be on top of it and like jumping off your body on to the bed to try to reach something. So it's just it's the time of day thing. Cats are only pressed in their own time. In their own time. In their own time. JWW said, I'm still leaning not guilty. JWW, I think that's a perfectly fair place to be. Defendants are not guilty unless and until proven guilty. And we're not at the end of the case yet. I think it's completely fair to be sitting here being like, okay, prove it to me. I'm struggling to get past the cell phone data. There's a lot more data to come. And I also think watching this trial, it's like, oh, that's a good point. That's a good point. That's an interesting point. How are they going to address that? It's fair to check the information against other information while still saying to the Commonwealth, I need you to prove it to me. Because what we haven't gotten to yet is how John O'Keefe died, how he was hit by a car, and what shows that. So we haven't gotten there. I think it's very fair to say that data is compelling to me, but what more is there? It's just the process of evaluation. Natasha O'Hare said, I'm getting married on Monday, EDB. Natasha, congratulations. I hope it is a beautiful day. My best advice is don't forget to hydrate. Don't forget to eat. If you don't get to see everybody, it's fine. They're there also to see each other. Have a beautiful day. Have fun. Take lots of pictures. It goes too fast. It goes too fast. And it will be amazing and fun. Let's see. Thank you for everybody who gifted memberships. Welcome to all the new members. Let's see. Squirrely Nerdy Jess says, EDB, is it just me or is it sus that Jen's text calls from John stop, but he, quote, never came in the house? I'm wondering if they will ask her, why did you stop texting John? We'll see. I have things I can't get past, and I try to, because I can split the lawyer brain pretty well. But I want somebody to just ask Jen McCabe. Because her testimony today was, I'm making all these calls to whoever this Beatty person is. I don't know, Chad, I don't know. I'm waiting to see. I'm making all these calls. And she goes, I don't know when, because I'm making all these calls. Did she ever call her sister that's at 34 Fairview? Or only Chris Albert's wife? Because I don't think she called Brian Albert's wife. I think she only called Chris Albert's wife. So when your husband says, no, remember, we saw them at 34 Fairview, and everyone's screaming, Karen is screaming and clearly distressed and freaking out, and Kaylee's worried, and you're like, I'm going to find your uncle. And it's going to be okay. You don't pick up the phone and call the person who lives at 34 Fairview and say, everyone is freaking out. John didn't come home last night. I saw Karen's car outside of your house. Can you see, is John on your couch? Can you see if he's there? Everyone's worried. We're going to drive over there now. We're scared. I'm worried for Kaylee. She's freaked out that her uncle's not home. I was there in kindergarten when this child lost her mom and her dad within 2 months of each other. And I am fucking panicked for her. And Karen seems to still be drunk and is freaking the fuck out and is no help. Can you help? Is he there? I got questions. Wouldn't you be calling the home at 34 Fairview over and over and over and over and over and over and over again until somebody picked up? If for nothing else than out of concern for Kaylee. We'll see if that gets asked. I imagine it'll get asked on cross, because we now have testimony that she's going in to comfort Kaylee. I'm going to find your uncle. It's going to be okay. We're driving to your house. Is John on your couch? It's like 5 fucking a.m. It's white out snowing. They're afraid to drive. And the one person who is at the location, who is literally your blood, y'all don't talk. I understand if there were 500 missed calls and everybody's phone is on do not disturb, no repeat calls, they drank the night before and everybody's asleep. Like, I get that. But the call logs would show it. Hey, everybody's worried. This is because the vibe I got from Carrie was, hey, everybody's worried. She's calling hospitals. Hey, Jen, can you call your fucking sister? Because her tone on the hospital calls is, everyone's probably freaking out for nothing. Right? Everyone's probably freaking out for nothing. We'll just call around and see. He's probably on a couch somewhere. Everybody's just worried. Jen, your sister's house. You saw him at your sister's house. Can you call your fucking sister then? Because I'm calling hospitals. Help, a little bit of help before we go driving through this blizzard? No? You go in the car and call 911, but don't start banging on the door being like, can you help? I just have questions. I just have questions. So, I have questions. We'll see if they get answered. The Commonwealth has to prove this case. It is not on the defense to prove this case. It is on the Commonwealth to prove this case. There are questions. Hey, could he be, they're talking about fucking Bella's house and they're talking about the house like down the street and around the corner and somebody else that's having like a house party a street away. They're talking about all of them, but not the person who lives at the house. I don't understand. I don't understand. So that's where I'm at. Nope, don't get it. We'll see. Sorry, y'all. Some of y'all are like, Emily, do your laundry. I know. There's a lot. I said no spoilers. There's a lot to come. We should put a spoiler alert on Emily's rant. But I hope the defense asks. So she testified. I was making all these calls. So you're making all these calls. When do you call your sister? Because they're like, oh, maybe John's on somebody's couch. When do you call your sister? Because if maybe he could have walked down the street, then maybe he could have knocked on the door. And even if the answer is, well, we left at 1 a.m. and he wasn't there, okay. But you went back to his house. Karen said he wasn't at his house. You went back and checked there too. So if you're just double checking everywhere and you're making all these calls because you don't know where he is, you forgot that you had seen Karen's car there at 1:45 until your husband told you. So don't you just make some calls? You went into Kaylee's bedroom and told her you were going to find her uncle. So that's when you called 34 Fairview? To just ask your sister, hey, can you go downstairs and check the couch? Did John come back? After we left, did you see anybody? He didn't come home. And I saw Karen's car here, so maybe. People do a lot of things when they panic. If she had made no phone calls, I think maybe I would think differently. Because maybe if she makes no phone calls and is just like, get the coffee, get in the car and go, and your train of thought is like, physically, I need to get there, I get it. But that's not where her train of thought was. Her train of thought was, I need to start calling around and finding him. So if the train of thought is, I need to start calling around and finding him, like, doesn't that train of thought stop at 34 Fairview at some point? Because I get it when people go into mode like, I just need to get there. Carrie was like, I called the hospital's not there. We're going to look. Like, blinders down. Let's go. Jen was in, let's call everybody. We'll see how cross-examination goes. I'm curious. But you know what would have helped? You know what really would have helped? If everybody was like interviewed by police right after this happened. That would have sure been helpful. Wouldn't it? Sure would have. The emotional roller coaster of today. Jojo said, I hope the prosecution asked the right question and run more smoothly. No more potato cannon. Jojo, I appreciate this. I disagree. I want to hear everything about the potato cannon. Then again, by the time we got through the tech testimony today, I'm like, what kind of peanut butter was it? Chunky or smooth? Like, I mean, smooth for with chocolate, chunky for with sandwiches and just about everything else. Celery. But there were appetizers on the table. What? Just tell us what they are at this point. We didn't even hear where people sat at the basketball game. What are we going to do with ourselves, chat? We don't know. We don't know. How? Jay said, got married on Saturday. Best believe I snuck beyond a reasonable doubt into my vows. You're the best, EDB. I'm going to need to know more, Jay, but I love it. That is the law nerdiness. The law nerdiness of all. Krista Cree said, thank you for body doubling. Happy 7 months. You are welcome. Always here to body double while y'all are at work getting stuff done because we're going to be doing that tomorrow too. What day is it today? Tuesday. All right, y'all. Emily has to bounce. Why? Because, well, Dr. B is texting me and because I need to make sure that we get the rest of the stuff we need to get done today done. I need to give Team Baker a break so that they can get the case briefs ready because y'all, Team Baker has been killed. Have you guys been watching the case briefs? It's okay if you haven't, but just tell me if you have. Don't tell me if you're not watching. Just tell me if you are. Team Baker has just been killing the case briefs and I appreciate it so much. So if you need to catch up on what happened to our day in court or just want a summary again to be like, wait, that was an emotional roller coaster, what happened? Or you were just like playing Midas Merge and maybe want to make sure you didn't miss something, totally get it. They have been working on the case briefs, but can't start doing that until I wrap stream. And tomorrow I need to go get Metallica nails done. So today laundry, tomorrow Metallica nails, Thursday Metallica. So Thursday it's going to be like, I'm going to be the judge. I'm going to be like, what? 4:00 on the dot. Peace. We out. Which means lunch break on Thursday will probably be pretty quick and I'll be pausing less because it's just like, let's go. So we've got things, we got a week, but I'm excited to be here with you. Don't forget that on Thursdays, if you are local in Boston, I am on Carson and Kennedy in the morning talking about this case at 7:10. So we will remind you on Thursday morning. And if any of you are local, I'll be on with them in the 7:00 hour. Case briefs are out every day. Nightbot's been sharing the channel for the Emily Show. So for those of you that know it as the Quick Bits channel, the name changed to the Emily Show because that's where the podcast lives now. We just thought it was more clear to put the VODs all on that channel. So the podcast and the Emily Show and the case briefs are there. I'm also going to Metallica on Saturday, which is why I've got to get the podcast done early because there's lots and lots happening. So we need to get things done, which is what I need to go do today. We need to prep the podcast today so we can record it so that I am not recording into the weekend so that I can go to Metallica and be nonsensical over this weekend. And what do I mean by that? I'm going to jump more than my knees at this age appreciate. There will be more of this. By Sunday, I am going to be in traction. I'm here for it. Emily, do you drink at concerts anymore? Not really. Why? I'm honestly afraid I'll like break an ankle jumping up and down. I'm like, I'll trip. I'll lose my balance. I'll tear an ACL. Like, I need to hydrate so I can headbang without hurting myself. We've got to pick. In our 20s, we could be reckless. Now, I'm like, oh no, man, no, I can't. I can't hurt myself. I do have ear protection, though. I do have ear protection. Law nerds, y'all are the best. Thank you for spending the days with me. I know today was hard with the no spoilers. To everyone who's watching this trial for the first time, we're really trying. The effort I saw in the chat today, y'all, I've asked you to do hard things the last couple days. When Brennan said, "What would you call me?" and all of you were just like, "Bitch, don't test me." I appreciate you. I appreciate you, because the no name calling rule, we are strict about, and there are days where I'm like, you're just fucking taunting us at this point. And with the no spoilers today, damn, it was hard. And y'all were great. Law nerds, thank you for having healthy boundaries and letting our friends discover this case in their own time. I appreciate you. It is hard. It's hard, and it's like, oh, just wait. There's more. And that more is tomorrow. Emily, is tomorrow going to be the only day of this trial you're going to be on time? Probably. Because, well, Jen McCabe's on the stand. And cross-examination is going to be tomorrow. And we are going to be as close to real time as we can be, because I am riveted. And I think that cross is probably going to take at least a day. I am riveted. Are you guys? You're in. I'll see you tomorrow. Don't forget to get the app. Court's gonna be feisty tomorrow, y'all. I will see you then. Thanks for joining me on this stream. If you don't want to miss a moment in court, you need the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, where I can keep you in the loop with everything happening in court, and of course, when the jury has a verdict. So if you don't want to miss a moment of this trial coverage, make sure you get the Law Nerd app. Thank you for being here, and thank you for being a Law Nerd.